ಯಾವಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು? Yes. ಇವತ್ತು ನಾಳೆ ಏನಪ್ಪ ಅರ್ಜೆಂಟು? ಆಯ್ತು ಕೊಡಿ. ನಾಳೆ ಟುಮಾರೋ. What is the urgency for today and tomorrow? Can we dispose the matter tomorrow? Totally after vacation. Yes. No. Election matter. 2:30. Yes, Rakshit. Election ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
ಅಪ್ಲಿಕೇಶನ್ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಒಂದ್ ನಿಮಿಷ. ಎಲೆಕ್ಷನ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಎಲೆಕ್ಷನ್ ಎಲ್ಲ 2:30. ಎಲ್ಲ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. ಯೋಗೇಶ್ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. You get instructions. If you don't serve it on Mr. Yogesh Naik, we won't take it up. Yes.
My lord, it's a fresh matter, my lord.
Yenappa. January. It must be 17 January only. Yen urgency ಏನು? ನಾಳೆ ತೋಳ್.
My lords, auction is held, my lords, next week, my lords. The
Auction is to
petitioner-
be held.
Yes, my lords. At
Tomorrow.
2:30, my lords, 2:30, my lords.
Tomorrow we'll take it up.
My
You'll
lords,
find out how much of it.
Petitioner is a senior citizen, my lords. He already
Auction is
repaid the-
next week ಅಲ್ಲಪ್ಪ.
Yes, my lords.
ಮತ್ತಿನ್ನೇನು ಕೊಡಿ.
Application not renewed, my lord, on the ground of infrastructure, my lord. Yesterday,
Not renewed.
applications, me.
Affiliation.
Please, my lord.
Tomorrow.
2:30.
Serve it on the
2:30.
tomorrow.
My lord, ಇವತ್ತು ನಿನ್ನೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರು.
ಇವತ್ತು 160 ಮ್ಯಾಟ್ರ್ ಇದೆ, ರೀಚ್ ಆಗಲ್ಲಪ್ಪ.
2:30.
My lord,
ಇವತ್ತು ಆಮೇಲೆ ರೀಚ್ ಅಡ್ಜರ್ನ್ ಮಾಡೋಣ ಜಾನ್ವರಿಗೆ.
I will wait, my lord.
ನಾಳೆ.
Wait, madam.
My lord,
Madam.
education matter. Mine is an
Madam,
contravention to the Bar Council guidelines rules,
Madam,
so the interim
Madam,
pay
what-
was allowed. The said notification is quashed, my lord, so covered by judgment here.
Which notification?
The Bar Council KSLU notification, my lord, which was passed on 6/12/2024, wherein they had made.
BNS.
BNS IPC.
It's been quashed, so you'll get
Covered
benefit.
by judgment.
Why do you need one more order in that?
Benefiting the petition.
Another petition, ತಗೊಳ್ಳಿ ನಾಳೆ, tomorrow.
Lords,
Matter with that tomorrow, my lords. The administrator was appointed, even though, my lord, the time has been.
Tomorrow ನಾ ಕೊಡಿ.
One matter at 2:30, my lord. Education matter, student. Tomorrow is examination.
Tomorrow is 2:30.
2:30.
Yes.
My lord, examination is tomorrow, my lord.
ಆಯ್ತಪ್ಪ 2:30 ಹೇಳಿ ಆಯ್ತಲ್ಲ.
ಅವ್ರು ನಾಳೆ ಅಂದ್ರು.
Serve it on there.
My lord, this is the matter of endowment property going to the temple. There is a stay. We have filed an application for removing the stay. Therefore,
can't
the filing
take it up
application,
now.
my lord. There is going to be encroachment by the other persons. We are,
We can't
Proposed
take
to-
up the matter for vacating stay in the last 2 days, so it will come up after vacation.
my lord, I moved it yesterday, but the office not posted it
Yes,
yesterday.
it won't come up. It will come after
My
vacation.
lord, this is the.
Okay, let it be posted after vacation at least.
After vacation one day.
Under secretary region act, my lord. Matter is reporting, my lord. Here, withdrawing the region, right? Can take it up
Tomorrow.
Tomorrow, yes.
So, tomorrow ಕೊಡಿ.
my lords, the petitioner is an Group D employee of corporate agriculture cooperative society.
Today or tomorrow?
Today, my lords, 2:30.
What is the urgency?
My lords, the urgency is this, they have misappropriated certain funds and have made several representations to the authorities.
In one day, more misappropriation will happen.
Therefore-
Tomorrow, ಕೊಡಿ.
Withdrawals,
Withdrawal. tomorrow.
withdrawal. Obliged.
Decision rendered in Kalburgi bench 201984. 12 matters have been moved before the coordinate bench. We are seeking for release of the order, my lord.
ಯಾವ್ದಪ್ಪ?
WP 201984 of 2024 disposed on 16/12/24, my lord.
What is the subject matter?
That is the tender conditions. My lordships has upheld the tender conditions. Another 12 matters before Bangalore bench. we have
Already
put it.
signed it, it's been released.
Released, my lords.
Released.
Not released, my lords. That's why we got the matter.
Registry
posted.
follow ಮಾಡ್ಬೇಕು, ನಮ್ ಸಿಗ್ನೇಚರ್ ಆಗಿದೆ.
Very much, my lords. Obliged, my lord.
ಅದಕ್ಕೆ ಯಾವ್ದು ಅಂತ ಕೇಳಿದ್ರು.
Obliged, my lords.
Adjournments. List number 1, page number 11, serial number 43.
Serial number 30, my lord.
30.
30. So
Yes.
No, I have got a marriage.
B
Son's
group.
Marriage tomorrow and day after.
It's 2012.
Yes, my lord. I've never taken time today because tomorrow and day after is a marriage. son's
Yardu?
marriage. Son Magandu, Magandu.
Magan, wish him all the best.
Thank you, my lord.
30 at the request of counsel for the petitioner. Relist on, this is that stamp matter.
Yes, my lord, yes, my lord.
ಬಂದಿಲ್ಲ ಅವ್ರು ಸರ್ಕ್ಯುಲರ್ ತಾನ್ ಬಂದಿಲ್ಲ
Bandilva.
ಕೇಳ್ದು
At the request of learned AGA relist on
Let a date be fixed, my lord,
tenth.
we'll complete.
9, after 10th, huh?
No, no, no. Any
In
date may be.
9
fixed.
January.
9th January. Oblige, my lord.
Serial number? 60. Wait, please. Correct.
Serial number 38, the
38.
English one, I appear for the petitioner.
Yes.
I'm awaiting
Appearing for the
some
respondent.
questions from the petitioner, your lordship, matter may be had soon after the vacation, subject to your lordship's convenience.
38 at the request of, you have informed everybody?
Please, they are online.
At the request of counsel for the petitioner relist on 16 January.
Please. My lords, it may be had on 17th January, subject to your lordship's convenience.
17 January.
I'm
36 ಇಲ್ಲಿ ಕರೀತಾ ಇರೋದು ಬೇರೆ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಬೇರೆ 36 at the request of counsel for the petitioner relist on 17 January.
Page number 12. Serial number 44 to 48. Page number 13, serial number 49 to 53. Page number 14, serial number 54 to 58. Page number 15, serial number 59.
Lord, one submission, 213 either.
Lord one.
Lordship, serial number 16, Lordship, 16.
16.
Yes, Lordship.
Yes.
After vacation, Lordship. I intimation
In at
the
the
other
request
side
of
advocate.
counsel
The respondent advocates also is present, Lordship.
for the petitioner relist on 16 January.
Lord,
My
serial number
lords,
26.
serial number 12, my lords.
12.
Proxy
Yes.
counsel, my lords. Arguing counsel is unwell, my lords.
Inform ಮಾಡಿದಿರಾ?
Yes, my lord.
12 at the request of counsel for the petitioner relist on 16 January.
My lord, third week of January, my lord, she is in surgery, my lord.
Huh?
Surgery ಆಗಿದೆ, my lord, sir.
Serial number 12 ಅಲ್ಲ? First list or second list?
First list.
Relist on 23rd January.
Serial number 26, my lord, I informed Nitin Prasad. May be taken. to the patient.
26.
26.
At the request of learned counsel
Respondent,
for
state-
respond number 3 to 6.
3 to.
Relist on 16 January.
Okay.
List number 1, order serial number 1. Rahul S. Reddy.
appearing for the petitioner, my lords. My lords, I have already paid the process today morning, my lords, to respondent number 6D, my lord.
Counsel for the petitioner submit that needful has been done, registry directed to verify. If needful has been done, issue notice to unserved respond number 6D, returnable by February end on date.
25th February,
25th.
serial number 2. Ravi Raghavan.
For the petitioner, my lords.
Paper copy.
My lords, in 12, moderation.
Serial number 2, right?
ಯಾವ್ದಪ್ಪ?
12, my lord, serial number 12.
12 ಅಲ್ಲಿ entry order ನೋಡಿ ಅದು ಯಾವ್ದ್ರಲ್ಲಿ
Number 2. You are for? Seacom Limited is.
Yes, serial number 2.
For the petitioner, my lords.
Yes.
Number 18.
Respondent. One.
Notice to respond number 4, 5, 10 and 15 could not be served though issued on 3 earlier occasions. Hence, on application being filed by order date 14/11/2024, this court had permitted the petitioner to take out sub-service by way of paper publication. The memo dated 17/12/2024 has been filed enclosing copies of the Hindu and Vijay Karnataka dated
First December.
3/12/2024. The Hindu and Dinatanti dated 3/12/2024. The Times of India and Maharashtra Times dated 3/12/2024. Career 3, 4, 5.
Respondent number 3, BPL Engineering Limited, represented by Vice Chairman. Respondent number 4, Sri V.S. Ramanan. Respondent number 5, Major Ajit G. Nambiar. Respondent number 10, American Express Bank Limited, represented by its manager. Respondent number 15, Syscom Limited, represented by manager.
None of them want to be represented.
No.
My lord, we are from respondent number 15. We have received the paper publication and we don't have a copy of writ petition and interim application.
Serve them.
So please serve us on our.
Many times it did not get served on you.
Sir, actually our address has been changed And it has also been updated in MCA websites and everywhere. And even on our website
You
is,
checked all the MCA website for the proper address.
My lords, is a 2015 petition. The address was, there. I'll serve them a copy, my lords. No difference.
Respond number 3, 4, 5, 10 and 15 were called out.
my lord,
Respond number 3, 4, 5 and 10 are neither present in person nor anybody answers for them. Shri so-and-so of respond number 15 is present. He submits that if copies of the petition and annexures are furnished and given 4 weeks' time, you would file a statement of objections.
my lord, can you just give us more time of 6
4
weeks?
weeks is more than enough.
Sir, the matter is very old.
So what? That is why it should be less than that. He seeks for, how much time you want?
6 weeks would be fine.
6 weeks' time to file a statement of objection. In that view of the matter, service and respect of respond number 3, 4, 5 and 10 is held sufficient. Registry is direct print their respective names with the endorsement served by way of paper publication. Who will be appearing for respond number 15?
Actually, we have not appointed any advocate at present.
On a counsel entering appearance for respond number 15, registry is direct print the name of said counsel as that appearing for respond number 15. 6 weeks time is granted to file their respective statement of objections. Objections, if any, to be filed on or before 30th January, relist on 5th February.
Can I make one submission, my lord? But I'm representing on behalf of KSIDC, respond number 18. Earlier, my senior Shri P.S. Manjunath is representing. Now he is no more. My senior colleague Shri T.P. Vivekananda name may be reflected, man.
Registry is direct print the name of Shri T.P. Vivekananda as that appearing for respond number 18 and delete the name of Shri P.S. Manjunath as that appearing for respond number 18.
Macho. My lords, one more submission, my lords. My lords, it says that a copy has not been served to R1, R2, R6, 11, 12 and 16, 18. My lords, I've served a copy to R12, R16, R19, R20.
File acknowledgement
I've already filed it.
with the registry.
8, 11, R12.
File the
and-
acknowledgement with the registry.
Yes, my lord. R12 and
Counsel for the
R18.
petitioner submits that he has served the amended petition on some of the respondents and he seeks for 2 weeks' time to serve the same on the other respondents. On service being effected, counsel for the petitioner to file acknowledgement of service with the registry, which is directed to be taken note of by the registry. Relist on so and so date.
Serial number 3.
Regarding the petition complaint which was transferred to the CID. Subsequently, the transfer to
ಏನಾಯ್ತು?
the CID, certain reports have come up. I'll place it on record.
That is what you said last time.
ಇವಾಗ ಅದು subsequent transfer to the CID. I'll place it.
That is the submission made on 4/12.
It
Is now being investigated by CID.
I have secured the instructions and the file. I'll place it before the lordship. It will pass.
ಬಂದಿದ್ಯಾ ಫೈಲ್? ಏನಾಗಿದೆ?
The same investigation still going on, same fact.
When will you complete the investigation?
Investigation is going on.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಷ್ಟು ವರ್ಷದಿಂದ ನಡೀತಾ ಇದೆ? 2015 ಇಂದ ನಡೀತಾ ಇದೆ. ಇನ್ನ ಎಷ್ಟು ವರ್ಷ ಬೇಕು? 9 ವರ್ಷ ಸಾಲದ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ.
CID has taken over by 1 year back.
1 year CIDಗೆ. CID 1 day.
However, the best way that investigation can work, we are doing it. Promptly we are doing it. That is the instructions also.
But 1 year is too long. 9 years in the wait ಆಗ್ತಾ ಇದೆಯಪ್ಪ ಇದು. For investigation to be completed. Complaint was submitted on 14/8/2014,
Yes, Lord.
17/8.
If 3 months time is granted, we'll conclude the investigation. 3 months. In that.
And AG on instruction submits that investigation would be completed given 3 months' time. A perusal of the records indicates that the FIR was registered on 17/8/2014 as crime number 202 of 2014 by the Anekal police station. Now the same has been transferred to the CID. it is more than 10 years since the FIR has been registered and investigation has not been completed. Since 3 months' time is sought for, the same is granted, but however, respondent number 1 is directed to personally look into this matter and see to it that the investigation is completed within the aforesaid time period of 3 months. Relist on March end on date.
My lord,
27th March.
one submission, it is crime number 17 of 15, my lord. 202 is missing complaint, 17 of 2015 is complaint against,
Yearly the page number
page number 59, my lord.
59.
Yes, my lord. Annexure N.
This is pending.
Yes, my lord.
Here it was a missing complaint, then it was turned into a kidnap complaint.
And subsequently, another complaint was filed on 21/2015, registered as crime number 17 of 2015.
Yes, my lord.
Serial number 4, Abhinavar.
I'm for the respondent number 9, my lord. On record advocate is not feeling well.
I appear for respondent number 6 and 7, my lord.
Whether, my lord, they can transfer Archaks. There is no provision under the rules by virtue of which they can transfer an Archak, particularly on the ground of allegation, my lord.
Can transfer as a disciplinary proceedings.
Disciplinary
proceedings, it's only, they can be removed.
Remove.
As this, he cannot be transferred.
Cannot be transferred.
Initiate proceedings for removal.
Yes. Can be remanded.
Allow the petition and remand.
remanded back.
The petitioner is before this court seeking for the following reliefs. By order dated 19/1/2016, the petitioner who is an Archak has been transferred. Learned AG was called upon by the order dated 3/3/2022 to make a submission as to whether there is any provision for transfer of an Archak. When it was, after taking repeated adjournment, the submission was made that there is no particular provision. Being of the considered opinion that transfer, but he however submit that there being allegation and complaints against the petitioner has been transferred. If there are allegations and complaints against the petitioner, disciplinary inquiry and proceedings are required to be initiated. Transfer cannot be imposed as a methodology of punishment or otherwise. In that view of the matter, I pass the following order. Writ petition allowed, a certiorari is issued. The order dated so-and-so by 4th respondent at annexure J is quashed. The matter is remitted to the 4th respondent, liberty being reserved to initiate such disciplinary proceedings as are permissible under the relevant statute.
Much
Great.
obliged, my lord.
Pending IA stand disposed.
Serial number 5, GC Sitaram Rao, on connected matters.
Submissions would be.
Some objection on your objections.
Fresh adjudication. They say, my lord, that there is no opportunity. There is a judgment of this honorable court in this regard.
In resumption,
I am not only.
They all contentions will be kept open, they will be heard in the matter, please, my lords. If they want to argue on merits, my lords, I will go ahead. They
ನೀವು
can-
ಹಂಗ್ ಹೇಳ್ತಾರೆ ಸೀತಾರಾಮರಾವ್ ರಿಂಗ್ ಅಂತ.
Please, please.
Yes, ಹೇಳಿ ಸೀತಾರಾಮ್.
There is arbitrariness apparent on the face of the record. KADB has not come out clean even before this on report. Though the plot was allotted to me and lease cum sale agreement was executed upon payment of the required amount. Till 2016, they could not implement the project in full because of, for want of environmental clearance. ಚಿಪ್ಗೊಂಡಳ್ಳಿ ಕೆರೆಗೆ ಇವರು ಇಂಟರ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ. It appears that Sompura first stage and second stage were clubbed together. This I came to know while reading one of the judgments rendered by the Supreme Court. They revised the cost from 57 lakhs to 70. Tentative cost. After environmental clearance, they started approving the plans in this pocket. As though I had committed fault, extension of time kodtivi, annexure H may kindly be seen. Of course, in the objection statement, it has not been dealt. ಮೊದಲು difference.
16 lakhs in the 1 crore 49 lakhs ಮಾಡಿದ್ದಾರೆ.
1,16,76,000 ಬಾಕಿ ಅಂದ್ರು ಏನು ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಟೆಂಟೇಟಿವ್ ಕಾಸ್ಟ್ ರಿವೈಸ್ ಮಾಡಕ್ ಕಾರಣ ಇಲ್ಲ ಅಂತ ನಾನು ರಿಟ್ ಹಾಕಿದ್ದೆ. That is listed. Kindly see the last line. They say, I have not done. I have not paid 16 lakhs anta. Their demand indication is otherwise. In last 4 lines of annexure H. Further, you are also requested to remit the sum of rupees 16,76,765 towards balance difference cost of land at revised rate at 73.82 lakhs per acre, along with interest so and so, so and so. 16 ಲಕ್ಷ ಈಗ ತಿರುಗಿದೆ 73 ಏನು ಅಂತ ಇಲ್ಲಿ ಕ್ಲಾರಿಟಿ ಇಲ್ಲ. In the objection statement, they have said, I have to pay 16,76,765. However, annexure H speaks different. For no fault of mine, after 9 years of execution of lease and come sale agreement, they can't increase it again another 100%.
How can you be revising the rates, Mr. Mani?
That, it depends, please, my lords, on the circumstances.
What is the circumstance for revising?
Various people will come to court, there will be litigation, there will be enhancement, please, my lords, of the awards. All that. We have indicated, my lords, very clearly.
Where is your objections?
Lords, we have very clearly indicated.
Objections?
He has not said how much increase was there.
Let's complete his arguments, I will conclude.
Yes. Yes, he has completed, really.
Please, now, my lords, my objections may kindly be appreciated. There are 2 writ petitions, my lords, in this case on hands. Lords, one is, please, my lords, the WP number 9119 of 2018. And the other, please, my lords, WP number 4094 of 934938, please, my lords, of 2019. Lords, in the first petition, please, my lords, what they have sought is quash annexure L. Lords, that is the order dated 17/11/2017.
Yes.
In the subsequent petition also, lords, I have extracted, please, my lords, in my objection statement at what is the relief that they have sought and what is the accompanying annexure. It is the same. So 2 petitions filed, please, my lords, seeking the same relief. In my, lords, the remark column, please, my lords, at page number 2 of my objection statement, in WP number 40934, 4093 out of 2019. Kindly appreciate, please, my lords, what we have extracted, please, my lords, in page number 2. The 3rd column. May I read, my lords? Annexure H is the same document on which relief in WP number 9119 of 2018 is filed. As regards to Annexure J, it is produced as Annexure M in WP number 9119, which is the order passed in the proceedings, proceeding the demand. Annexure C is the demand of money deposit of monies being difference in land cost. Annexure F being the notice under section 34B1 of the KIDB Act. Annexure M, which is the order of the respondent communicating resumption of the land to the petitioner. Lords, a year, 10 years, please, my lords, after that it has been granted to them. No, my lord, they do not even move their little finger, please, my lords, apart from, my lords, making the certain grievances before this honorable court. But they do not even comply, please, my lords. We put a small brick also there. That is our position, please, my lords. It cannot be against the terms of sanction in itself. And in terms of sanction, please, my lords, we have indicated to them, the price is only tentative. It is subject to enhancement. And this honorable court.
Why have you enhanced it? Is what we are asking you.
Please, my lords.
What is the basis of enhancement?
Correct time.
There will be so many factors, my lords. If my lords want to put the economics on hand, I will place it to my lord's hands.
Place it.
Yes, I will do that, my lord. We have no
there will be
difficulty.
so many
And
factors.
in fact, my lord, this honorable court has upheld this enhancement of.
We'll do one thing. We'll say there are so many factors to allow the petition, therefore petition.
May I submit, my lords? The
Not-
same, my lords, identical case has come up before this court. I'll place the economics. Adu bere.
Yes.
Let's para number 6. In that background, the petitioner is in position in enjoyment of the allotted plot. When this was the position, the communication dated so and so was issued by the second respondent to the petitioner, intimating the tentative allotment rate in Somapura first stage and second stage is revised from 57 lakh to 73 lakhs 82,000, including the pro rata cost of water supply scheme. The calculation was made and the petitioner was called upon to pay the amount as indicated therein. The petitioner got issued notice through their counsel intimating such demand is not justified. The second respondent has replied the same through their communication. dated so and so, and sought to justify their action and once again called upon the petitioner to pay the amount. It is in this circumstance the petitioners are before this honorable court. Let's kindly turn to page number 10.
Yes.
Para 10, please. Sorry. The clause which is prayed to be struck down is evidently not a provision contained in any enactment or rule. So as to consider.
That is for the striking down.
Please,
But
my
now
lords.
if you have to
But-
demand it,
but
what
what
is the
this
basis
co-
for the demand?
It is, please, my lords. It says very clearly, this judgment says very clearly, we are at liberty, please, my lord. There'll be so many factors.
We're at
please, my lord.
liberty, why only this much?
That
You
is the
could ask
reason
for
why we
100
fix a
crores.
tentative price, my lords. At the stage of allotment, we make it
Manish,
known.
why don't you ask for 100 crores?
No, we will not do as such.
Then?
Because we are a no loss, no profit organization.
Whatever it is, you have to justify your claim. So you'll have to place that. You cannot say, I'll do whatever
But
because I am
the land
entitled.
costs keep escalating. Acquisitions are there. We are visited by various awards. Development
Say it-
factor,
place it
development
on
of the layout, my lords, will, these are my
ಆ
submissions.
judgment.
I will
ಕೊಟ್ಟಿರೋದು
place, I will
irrelevant
ask my
ಅಲ್ಲ.
authority.
If
please.
that is your submission, we'll deal with it now.
Lords, kindly appreciate, my lords. I will ask my authority, whatever are the enhancing factors, please, my lords, and I will file, please, my lords, immediately after vacation.
The judgment, my lords, has been shown pertaining to enhancement from 57 lakhs to 73,000.
Yes.
Look, my
Not
only instructions
73 to
today was-
150.
My instructions today was that, my lord, they are complaining grievances, my lord, that they have not been heard in the matter. The matter could be remanded back.
Not
We'll
the
hear
only
them, please, my
grievance.
lords, and pass out.
There's
This was
three
my-
things here. One is the enhancement which has been.
Please.
made. Two is that you could not grant, you could not give any connections for them to start.
Please,
Three is the environment clearance could not be given because of pendency of litigation.
please. Lord,
So
I
on
will
these
place all
three
the
things,
material on record.
The contention of learned counsel for the petitioner in both the above matters is that the tentative cost of allotment being at rupees
57 lakhs.
57, ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಅದು?
ಮೊದಲು 57 lakhs ಕಾಸ್ಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
57,00,000,000.
Revised to
Initially
73,
revised to
82.
73, 76, 765. And thereafter to rupees 1,49, 89, 362 per acre. Without any basis. Learned counsel for the KADB submits that the KADB is authorized and entitled to under the agreement between the petitioner and the KADB to enhance the cost of
The price
allotment.
indicated is tentative in nature.
Since it has been indicated as tentative. Even if that be so, KADB being a not-for-profit entity would be required to place on record the reason for such enhancement and the cost incurred by the KADB for implementation of the said project. And without the same being indicated, the KADB cannot unilaterally enhance the allotment rate. And as can be seen, in the present case, the allotment cost has been increased nearly 3 times. The second submission of learned counsel for the petitioner is that the petitioner could not implement the project in view of the said acquired area coming within the Tipgonalli catchment area, as regards which there were litigations which were pending before this court
ಅಲ್ಲ ನ್ಯಾಷನಲ್ ಗ್ರೀನ್ ಟ್ರಿಬ್ಯುನಲ್
and the National Green Tribunal. And as such, the environment clearance was not issued. Thirdly, it is submitted that even the KADB has not made available electricity and water connection to the said premises,
So
said
that is the
plot
best
which have been
comment you have
allotted
to
to
do
the petitioner. These aspects have not been adverted to in the statement of objection which have been filed. In that view of the matter, 3 weeks' time is granted to the KADB to place all the relevant documents in relation to the above. Relist on 16th January.
Obliged.
Serial number 6. Ishwara HH.
For the petitioner, my lords,
Yes.
my lords, the orders of the honorable court is complied with, my lords. A date may be fixed post vacation, my lords.
Only 2.5 lakhs has been paid as on today.
2.5
was
lakhs.
Ordered by this honorable court, my lord. Thereafter, they have not come forward to pay a single rupee. As on today, 89,85,432 rupees is the due.
89?
89,85,432.
433.
32.
2. Yes, Mr. Counsel. You had undertaken to make payment of the EMIs regularly and make the account regular
They have not come forward to
on
settle down.
17/11/23. And you have not paid anything is what the submission is.
My lords, they have made the partial payment, my lords, and we'll instruct them to pay further, my lords. A date may be fixed, my lords.
You are to have made all the EMIs regularly without skipping. Is the direction on 17/11.
Please, my lords.
Place that on record. If you are not paid payment, made the payment, it will go.
Please, my lords.
Lord Counsel for respond number 1 and 2 submit the dues as on date is rupees 89,85,432. And that as directed by this court by order dated 17/11/2023, the EMIs have not been paid and the account has not been made regular. Counsel for the petitioner is granted 3 weeks time to place on record the details of the payment already made, if not, to place on record the manner and methodology in which the aforesaid amount will be paid and the time frame in which it will be paid. Relist on 16th January. In interim order, extend agilvalla.
2.5 lakhs pay ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
Interim order has not been extended on last 2-3 occasions. The
Interim-
counsel, you're only permitted to approach the bank. Interim order earlier granted is extended till next date. Relist on 16th.
Obliged.
Serial number
In
7,
the meanwhile, office objections to be complied with.
Janardana Ji.
This matter,
Janardhan, now is
emergent
R5.
notice is ordered to R5
Huh?
and await anta ಇದೆ.
Yaar R5?
R5 is the private party.
Private party na? ಯಾವ dispatch ಆಗಿದೆ?
17 December.
Note 17 December. Nenne. ಯಾಕೆ?
It could be disposed of. The contesting respondents, slum board has already made a statement. Service because she is the beneficiary sitting over the road portion. That it could be, your lordship may, that immediately after service of notice would be disposed of because of the statement made by slum board. So lordship may call it immediately after vacation. Awaiting. that.
Notice to respond number 5 has been dispatched on 17/12. Awaiting service relist on 29/1.
Right.
Registry direct place the postal track record on that date.
Serial number 8, Kiran BS.
I represent for petitioner in this case, my lord.
Appearing for the respondent bank in this matter.
Office objection 2 and 3 has been filed.
My lord, the writ petition may be dismissed, my lord.
Why, madam?
On the last occasion itself, I have submitted my memorandum of objections along with the synopsis, my lord, stating that whatever it has been stated in the petition, it is not maintainable.
So what is not maintainable?
The contention of the petitioner is that at the time of the purchase of his purchase from his previous vendor, there was no loan accounts in operation. I have submitted a synopsis stating that since the year 2010 until 2018, our loan account was in operation.
When was the mortgage effected?
First mortgage was effected on 18/3/2010, my lord.
18/3?
2010.
2012.
10/10.
10. Where is the document?
I have produced in my objections, my lord.
Early objection.
Annexure R1 is the sanction letter.
Objections allidiya. Where is the mortgage?
That is the sanction letter. The next is the mortgage deed, my lord. Next document.
28 March 2010. Property bearing 24/1/1. When is your sale deed?
My
When was
lord,
sale deed?
my sale deed is dated to 19/9/2019, my lord. 19/9/2019, my lord.
19/9/2019.
19, my lord.
ಮತ್ತೆ ಹೆಂಗಪ್ಪ?
In order to rebut those submissions, my lord, I would kindly draw attention towards page number 28, my lord, the challenging order itself. They are just trying to misrepresent the facts and suppression of material things, my lord. Page number 28, my lord. This is the order where the bank has obtained against the respondent number 3 to 6, my lord. Page number 28 in page 4. May I read it out, my lord? It is the case of the petitioner that the respondents have borrowed loan account so and so of 3 crore on 21/2/2017, my lord. And subsequently on another loan is on 31/3/2018, my lord. And moreover, my lord, I have not purchased the property from the borrower of this order, my lord. I have purchased the property from the previous vendor where all the debts were cleared. To that aspect, my lord, I already filed the memo stating that the loan accounts has been cleared and it has been showing as nil. To that aspect, my lord, there is a criminal case pending against the bank authorities as well as all the respondents herein, where they have committed an act of forgery, my lord, where they have mortgaged my property, my lord. Now, I am neither a borrower nor the guarantor nor under the lessee.
You may not be borrower. You
Yes, my
purchased
lord.
it from whom? Yes, Nagaraj.
Yes, my lord. Who has purchased this property in the year 2013 itself, my lord. I have purchased
Who did
this
he purchase it from?
Ramesh Babu, my lord, who is the R3 herein.
Yes.
The borrower.
He is the borrower.
So Ramesh Babu is the borrower who had mortgaged the property in the year 2010 and sold the property in 2013
Yes.
to Nagaraj,
Yes.
who
Those
in
loans
turn
have
sold
been
it to
cleared, my lord.
2019.
Those loans have been cleared, my lord. I have placed the memo to that aspect, my lord.
Where is that memo?
My lord,
Date. When did you file the memo?
my lord, the last 2 months back itself, I have filed a memo. Just it is only one page, my lord, where there are 5 loan accounts. In the 5 loan accounts, my lord, 1, 2, 3 has been shown as nil.
There are 2 more.
Yes, my lord, this is of subsequent to 2017-18. But I have not purchased from the borrower from 2017-18 onwards.
Mr. Kiran,
My lord.
your borrower, you purchased it from the person who sold,
Those loan
the
accounts have
borrower
been
sold
cleared.
it to.
Nagaraj.
Ah.
Borrower sold it to Nagaraj in the year 2013
Yes.
itself.
Once
How-
a mortgage, always a mortgage, appa.
My lord. Yes, my lord, but those accounts has been cleared, my lord. To that aspect, I have filed only 1 page statement which has been filed before criminal court. Only 1 page, my lord. It has been showing as nil.
3 accounts are nil. There are 2
Yes, my
more
lord.
accounts.
Yes, my lord.
The mortgages.
Yes, my lord. 17-18 onwards, I have not purchased from the borrower.
Whatever he is stating as nil, my lord, that accounts were closed and then
Yes, my
top-up
lord.
loan was sanctioned. The very next day, the mortgage has been renewed. It has not been
Account has
closed.
been
That
closed, my
account
lord.
has been closed. Another account has been opened in another name. Ramesh Babu has withdrawn the loan. He has
This will
applied for
require
a
trial.
sanction
We
of loan.
can't look
His
into
wife has
this.
been granted
My
the
lord.
loan.
We can't look into this here in these proceedings. You'll have to go under 17.
My lord.
He spent
My lord.
before DRT, the petition has been dismissed.
My lord.
Again, he has approached this
My
honorable
lord,
court.
I will convince your lordship, it may be pass out to afternoon, my lord. I will convince your lordship. Because it's a pre-mortgage, my lord, anti-mortgage.
This court will exercise jurisdiction in these matters only if you are going to settle the amounts. You have an alternative advocacy remedy in terms of appeal before the DRAT. You'll have to go there, not before
My
this
lord,
court.
Surface Act will be applicable only when I comes under the ambit of, my lord, section
There's a
70.
different forum for that.
My lord,
If
in-
ex facie no jurisdiction, then we could have. The ex facie
Yeah.
jurisdiction is there.
it may be pass over, my lord. I will convince your lordship on the afternoon.
You get instruction on payment. Otherwise, we'll be
My lord,
dismissing.
I'm not liable to pay, my lord.
Then we'll be dismissing it. Pass over.
Pass over, my lord, please.
Serial number 9. Sharat Kumar Shetty.
For petitioners in this.
My lord,
Already complete the order, your lordship.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ petitioner ಡೆತ್ ಆಗ್ಯಾರ my lord.
Petitioner did that.
ಸ್ವಾಮಿ.
The loan was granted to the petitioner. He was 70 years old, your lordship, when the loan was granted. Actually, there's a fraud case also, which has been registered. A criminal case is pending before the magistrate court. And all the respondents
Petitioner
are party in
notice,
that
my lord.
case, your lordship. What has happened here is
What have you complied with?
30 lakhs has been paid, your lordship. And before that, 65 lakhs we had paid.
ಸ್ವಾಮಿ ಲೋನ್ ಡ್ಯೂಸ್ 40 lakhs ಇದೆ ಸ್ವಾಮಿ. 40 lakhs that
Statement of account
87,000.
also was not produced, your lordship. we had completed the order.
My lord, now legal errors fresh demand notice issue ಮಾಡಿ my lord.
Actually, this is a fraud case, your lordship. The second respondent and the act of second respondent and third respondent is that they have created
if it is even a fraud, we don't have jurisdiction on this.
your lordship,
Understand that.
total
That you'll have to
loan
go before the DRAT, not before us.
Yes, your lordship. We have paid whatever amount, only the 72 lakhs was sanctioned to us. In the sense, the second respondent and third respondent, the total loan amount was 1 crore 20 lakhs. In that 72 lakhs, they had given to the petitioners. First of all, the petitioner was aged more than 70 years. They had created a...
These are all facts upon you. Payment madangidre early,
No,
we can try and
30 lakhs,
pursue it.
we have already...
Not all these things, we can't consider this.
We have
Our
already
hands are
completed the
tied.
order, your lordship. We have already completed the order. 30
This
lakhs,
you have complied, but other, ಆಮೇಲೆ
they have not provided the statement of account. We are ready to...
ಎಷ್ಟಿದೆಯಪ್ಪ?
So my loan dues
Come
40
on.
lakhs ಇದೆ sir. 40 lakhs
ಕೊಡಿ
87,000
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ sir.
ಯಾವ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
Lordship, 1 month's time may be given, your lordship.
Learned counsel
My lord.
for respondent.
ಇದು
Has today handed
Even
over,
criminal case is pending, your lordship. Charge
today
sheet
handed
also
over
has
a
been
statement
filed.
of account.
ಸ್ವಾಮಿ ಇದು petitioner infractions my lord. ನಾವು fresh demand notice issue ಮಾಡಿದ್ದೀವಿ already.
ಆಯ್ತಪ್ಪ, ಇವಾಗ ದುಡ್ಡು ಬೇಕಾ ಬೇಡವಾ?
ಹಾ ಸ್ವಾಮಿ.
ಎಷ್ಟಿದೆ ಅಮೌಂಟ್ ಹೇಳಿ?
40 lakhs 87,000.
13-2 notice was not issued with respect to second respondent, third respondent also, your lordship. Issued to the petitioner. And we are ready to...
You want to pay or you
We'll pay,
you are
your
going to be
lordship.
taking up these contentions?
No, your lordship, we'll pay. The statement of account, if they provide,
Learned
we'll
counsel
pay.
for respondent number 1 and 2 has handed over a statement of account to the counsel for the petitioner.
They have not handed it to.
He is handing it over IRRI. In terms whereof the amount stated to be due is rupees 40,87,
40 lakhs 87,000. 218 rupees my lord.
to
18 rupees.
18.
Initially overdue
Overdue,
amount was
madam.
10 lakhs, your lordship.
ಅವ್ರ ಅಕೌಂಟ್ ನೀವು ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಇವಾಗ ನೀವ್ ಹೇಳ್ಬೇಕಷ್ಟೇ. Counsel for the petition seeks for and is granted 3 weeks time to make a submission as to in what manner the said amount should be paid and the time frame. Relist on 17th January, interim order earlier granted is extended till next date of hearing.
Serial number 10. R. Kotwal and connected matter.
Still number 10, I appear for the.
For the petitioner in this case, your lordship. Your lordship, the office objections may kindly be overruled, your lordship. We have already filed NOC Vakalat.
Who is filed now?
R Kotwal, your lordship.
You have entered appearance.
Yes, yes, your lordship.
In 2310 order and 2310.
Your lordship, and I may kindly be heard in WP 16526, your lordship.
You don't want to be heard in 8826.
That I'll make submissions, your lordship. We have applied for an RTI
Directions,
for some documents, your lordship.
What is this matter?
directions may be issued, Manas. They are saying that we have
Application,
not
okay.
considered their appeal. We will consider it.
Next
Your
year,
lords.
E. What do you want? What details do you want?
Your lordship, page number. Your lordship, page number, annexure page number 16. The petitioner's husband, late Azhar Nadim, he was a proprietor of National Gas Agency.
You
your lordship.
want these documents?
Yes, your lordship.
Petitioner is before this court seeking for the following, 16526. Seeking for the following reliefs. The grievance of the petitioner is that despite an application having been filed under the Right to Information Act on 6/2/2024, the documents which have been sought for have not been issued. Whenever any application is filed under the RTI Act to the information officer for seeking for either information or certified copies of documents, it is but required that those documents
Orders-
and or information. is
Orders have
furnished.
been passed on that. Annexure F. We have rejected it. They have filed an appeal. That has to be considered.
Why did you reject it?
Manas, we have said that these are all the personal information. In fact, there's a bar under section 8(1)(e).
Wife asking about the husband's document?
Yes, your lordship.
But there is
She
a-
is a
If my lord
legal
sees,
there.
if my lord sees 8(1),
After the expiry of the husband as regard the transaction,
Manas, in fact,
how is it personal?
what is happening is that there is a dispute with, there are two wives. The person says that they say that he has two wives. There's a dispute going on between the wives.
Entitled
So we
to
don't
two
have
wives.
any details of who is the wife.
Lordship, we have produced.
Entitled to two wives, not more than 4. Then what's your problem?
My lords, in fact, if my lord sees 8, my lords, there's a bar.
Yen bar
So
idea.
that will be, my lords, on the merits, the appellant authority will consider, my lords. Their only grievance is that we have
Why,
not
why are you
considered.
giving this kind of endorsement?
My lords, if my lord sees, I'll just take my lords to annex
You can't give this kind of endorsement.
section 8.
ಆಮೇಲೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು writ petition ಆದ್ಮೇಲೆ I'll give ಅಂದ್ರೆ you should have given it to them then only.
4 weeks, no, they will consider the appeal.
What consider the appeal? You have to give the documents. That is what we are directing.
That is our prayer, your lordship.
May be permitted to just
Application
file a
is
formal
filed.
objections, my lords.
No objection for this. The said application was rejected by the information officer under section 81J of the RTA Act 2005, stating that the information requested for is personal information and the same cannot be disclosed. What has been sought for by the petitioner are certified copies of the agreements entered into by the late husband of the petitioner with the Indian Oil Corporation. The husband having expired and the wife not having the documents, it cannot be said that the documents which have been sought for are personal information of the husband not being required to be given to the wife. At this stage, Learned Counsel for Respondent submit that the petitioner is the second wife of
First wife.
first wife or second?
First wife.
First wife.
First wife ಇನ್ನೇನು ಇಲ್ಲ.
No, they're claiming.
Your lordship, there is
They're
no
claiming
second
she's
wife
the
at
first
all. your
wife.
lordship.
ಯಾವ ಲಾಲೂ ಇಲ್ಲ.
Your lordship, first of all, there is no second wife at all. It is a dispute.
No, there is, if you see the second
Yeah.
matter, my lords, there is a dispute on that also.
That we have produced the documents, your lordship.
At this stage, but in that view of the matter, I pass the following order. Writ petitions allowed. A mandamus issued to respond number 1 to consider the application of the petition dated 6/2/2024 at Annexure E and furnish the certified copies of the documents sought for by the petitioner within a period of
That may be directed.
3 weeks from the date of receipt of a copy of this order.
Your lordship, short date may be fixed for an other writ petition.
What is that other one?
Your lordship, we have made a representation for before the respondent authorities for temporary caretaking of this particular agency, your lordship, gas agency, National Gas Agency.
This
The
you have
petitioner-
disputes between them. This cannot be
There is
granted.
no dispute at all, your lordship may kindly see annexure.
That
K.
has been terminated in the year 2022.
You filed your objections?
I have filed my objections.
Council 8826, D-Link, released on 17 January
Much obliged.
Grateful.
for final hearing.
Serial number 11, XM Joseph on connected matter.
My lords, appearing for the petitioner, my lords, kindly pass over, my lords.
Pass over.
Serial number 12, Adjourn 13. Praveen Kumar Raikote.
Yes, Mr. Raikote.
Last time, my lord, your lordship directed Mr. Jagdish to find out how the notice is issued, because my contention was that suo moto they have taken up the proceedings. The district caste committee.
Mr. Jagdish? ನೆನ್ನೆ ಬಂದಿದ್ರಲ್ಲ?
No, sir.
Lord, kindly pass over, my lord, is held up
Oh,
before the.
ಹೆಸರು print ಆಗಿಲ್ಲ.
ಹೆಸರು ಪ್ರಿಂಟ್ ಆಗಿಲ್ಲ. You are appearing for Mr. Jagdish? Pass over.
Please, ma'am.
Serial number 14,
Appearing for the respondent number 2 bank in this matter.
I appear for petition.
Your lordship has directed us to confirm the availability of the original documents. Link memo.
ಅದು RSA ಮ್ಯಾಟರ್ ಅಲ್ಲ?
RSM. ಹೌದು.
ಸಿಕ್ಕಿದ್ಯಾ?
ಅವೈಲೇಬಲ್ ಇದೆ DRT ಅಲ್ಲಿ. We have made.
DRT available ಇದೆ ಅಂತ ಹೇಳಿ ಆಗ್ತಾ ಇರೋದು ಮ್ಯಾಮ್.
We have already filed necessary application for withdrawal. Copy.
These are the 5 documents?
ಇದು move it. Submission ಮಾಡ್ಕೊಡ್ತೀನಿ. In the copy.
ಇಷ್ಟೇ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ?
He is not the borrower, he is the.
Borrower ಹೇಳ್ಬೇಕು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. I am the person who paid the amount.
Documents are there, we'll dispose the matter. Petitioner is before this court. seeking for the following reliefs. During the pendency of the above matter, a memo dated 18/12/2024 has been filed by respondent number 2 bank, signed by the chief manager and the counsel for the bank, which reads as under. In terms of the aforesaid memo, it is categorically stated that the entire loan has been cleared and the original documents which had been produced in OA number 77 of 2010, which had been filed before the Debt Recovery Tribunal, Bangalore, has sought return of. And as per the earlier submission made, on the return of the documents, the same would be deposited in RSA number 387 of 2015, which is pending between the parties. In that view of the matter, nothing survives for consideration. Placing the submission of the learned counsel for the bank that the documents would be deposited in RSA 387 of 2015 within 2 weeks from the date of receipt.
On receipt of the,
Within 2 weeks from the date of receipt of the same from the DRT, the petition stands disposed.
please, much.
The
Connected matter.
14.1. Petitioner is before this court seeking for the following reliefs. In view of the disposal of WP number, in view of the order passed in WP number 23210 of 2017, the relief sought for in the present petition do not survive for consideration. As said, the petition stands disposed.
Much obvious.
Serial number 50, Abhishek.
Yes,
Leave of
Vasanth.
the court, I was able to serve it only yesterday. May I be permitted to file it in the open court?
Ian, what are you filing?
The affidavit.
My lord, I appear for the petitioner, my lord. Yesterday we have been served with a copy. I seek for 3 weeks' time, my lord.
You are appearing for the petitioner
Yes.
in 15.
I'm sorry, my lord. I'm sorry. Apologies.
Have you filed any criminal complaint, Vasanth?
No, my lord, as of now, no.
Okay.
My lord.
Only
the
then we can
matters-
direct
The
investigation.
matters were all pending before this court, my lord. And even that about the bank, the RFA is pending before this court, so I will request the court to investigate that part of it, but
Your lordship's kind leave, my lord.
Yes.
Serial number 15, I'm appearing for Abhishek, my lord. I'm his colleague. I seek 3 weeks' time, my lord. Yesterday evening, we were served with a copy.
Yes. So whereabouts of your mother are not known.
as of now, no, my lord. She herself was apparently made to say that she
Direct
was
you to
in Kottayam.
inquire. But you should have filed a complaint.
My lord, we are online, my lord. I can't say certain things here, but the court itself in the DV case has recorded that she said that she was in Kottayam. She is not in Kottayam. I am certain about it. Because my neighbor claims to have spoken to her and she says, I went for her birthday celebration to the house of so and so. And when the court commissioner went also, my lord, all that happened. And the bedridden person was suddenly produced in a wheelchair before the court.
Right now, we can only direct the registrar judicial to look
Yes,
into
ma'am.
this, that's all.
That is
The
more
other
than
aspect, if
sufficient
you
for
have not
that.
filed a complaint, how do we even direct them?
All the other matters we look into separately, my lord, but this part of it, if it is looked into. And once a report is submitted, it would also amount to criminal contempt of court.
Respondent number 2, party in person, has filed an affidavit. Sri Vinay, who appears for the petitioner's counsel, confirms having received the said affidavit yesterday. He seeks for and is granted 2 weeks' time to file a counter affidavit since there are serious allegations which have been made in the said affidavit. The registrar judicial is also directed to look into the allegations made in the said affidavit, more particularly at para 10, and submit a report in relation thereto within a period of 2 weeks from now. Relist on 9th January.
Obliged.
Obliged, Your Honor.
Serial number 16, adjourn 17. Brijesh Kadapa.
Please.
Yes, Mr. Kadapa.
Lords, this is a matter, Lords, which was filed sometime in 2021. Lords. In 2017, my Lord, a tender was called, my Lord, in Madalur, in Shira, my Lords, for a petrol pump. And that petrol pump was under the impression, my Lord, that was an MDR, my Lord, a major district road. Apparently, it transpires that sometime in 2017 itself, it had become a state highway. Subsequently, it was now raised to the level of a national highway, my Lord. In the meantime, I have been given a letter of intent, my Lord. And that letter of intent, my Lord, is not serving any purpose. And this I have put in the form of a letter, my Lord. My Lord, there's a memo of document which I filed on the 18th of July, 2024. And this states my current position, my Lord. If my Lords don't mind, may I read, my Lord?
Yes.
I have
This letter is to bring to your kind attention that following the advertisement issued by you dated so-and-so, seeking entrepreneurs to establish a petrol pump at the location from Madalur village to Gidaganahalli village of Tumkur district. It is now, my Lord, the road from Amravati to Shira, my Lords. I have submitted an application form bearing so-and-so seeking to establish a petrol pump at property number so-and-so. As per the letter of intent issued by you, I have also entered into a lease agreement with the owners. Even to this date, I am paying the rent or the said
Your
land.
application is still pending.
No, letter of intent was given to me. Now, point is, my Lord, that since it has become a national highway, apparently the procedure to establish a petrol pump is little different, my Lord.
Yes.
Therefore, I am stuck. I am stuck in the entire bargain, my Lord.
So you'll have to follow the procedure.
No, not for me, my Lord. Just for the IOC to do that.
What has happened?
IOC, you are for the IOC.
I appear for that.
One is IOC, two is you will have to get the sanction plan as per the, you only have to sign it.
I'll have to sign it, but the problem is the call for the allotment of petrol bunk was for rural quota. And now rural quota, under the rural quota for rural
yes
selections. But now since it comes in a national highway, that purpose is not served.
How would coming in the national highway take away rural quota?
No, that
rural area will continue to be rural
area. It is a rural area, call for rural area, particular proposal was that.
The road change the rural area change.
That is what I had asked for, particulars of documents, and I prepared statement of objections I have sent. They have signed, they had to sign and send
If
it back to
don't
me.
mind, the letter which I have given, Lord, states that I've already expended about 55 lakh, Lord, in the process. Since 2018, I've been paying rent and all this.
Because national highway comes, rural area will not change, Mr. Uday. How will it change?
I get my Lord's point.
It's not become a city or urban area.
I mean, I'll place it on record, my Lord, with the documents.
He'll take your submission on record and reject it and direct you to do the needful, that's all. Why do you want to waste time and paper on that?
I leave it to my Lords. I will board out to whatever my Lord says, because
Petitioner is before this court seeking for the following reliefs. The petitioner had made an application
he's a successful bidder.
Bid ಆಯ್ತಾ ಇದು?
Bid ಆಯ್ತು.
Respondent number 2 had called for applications in local newspaper in respect of LOC number 2424, Madlur village to Gidganalli village for dealer controlled site. The petitioner having bid for the same was declared as a successful bidder. Thereafter, LOI was issued, letter of intent, bracket LOI was issued in favor of the petitioner for establishment of a retail outlet at the said location. Subsequently, application for grant of NOC was made to the IOCL, made by the IOCL to the Deputy Commissioner. Apart therefrom, there are various NOCs which have been issued by the various other concerned authorities in relation to the establishment of the unit in the said location. During the pendency, before the unit could be established, the road on which the unit was to be established, being a district major road, was upgraded to a state highway and subsequently to a national highway. The petitioner had been following up with the IOCL for grant of permission and processing the letter of intent. Lease deed has not been executed. Letter of intent so as to enable the establishment of the unit at the earliest. However, no action was taken in relation thereto. Hence, the petitioner is before this court seeking for the aforesaid reliefs. Learned counsel for Shri Brijesh Kadapa, learned counsel for the petitioner would submit that the petitioner has acted in a bona fide manner, has invested more than sum of rupees 55 lakhs. The petitioner having kept itself ready to do the needful from the year 2021, no further progress has been made on account of the IOCL not taking up the matter, taking the matter forward. And as such, he submits that the reliefs which have been sought for are required to be granted. Shri Uday Prakash Mulia, learned counsel, appearing for the respondent, would submit that since the road has been now
Classified as
classified as a national highway, the application had been earlier called for a rural area. Now that the road is a national highway, the application has not been processed. On inquiry as to whether the area where the unit was to be established has now come under the urban area of any particular city, he submits that it is not so. It is only the national highway. It is only the reclassification of the road as a national highway which has occurred. If that be so, the purpose and intent of calling for the application for rural area has not undergone any particular change. The rural area continues to be a rural area. Merely because the road has been reclassified as a national highway would not change the character of the area from a rural area to urban area or the like, disentitling the petitioner from consideration of the application and issuance of necessary NOCs leading up to the establishment of the unit. In that view of the matter, I pass the following order. Writ petitions allowed. A mandamus is issued directing the respondent to process all concerned and other applications and permissions which are required for the purpose of establishment of a unit of the petitioner as per the applicable rules and statutes within a period of
4 weeks, madam. 4 weeks, because there
4
are
weeks agata. All the NOCs you'll have to get 4 months from the date of receipt of a copy of this order.
some of the NOCs which the petitioner may have to apply will have to be pursued by him.
Only by you.
there are some NOCs, my lord, which they have to pursue.
Correct.
That also they might
Needless to
provide
say,
it.
the NOCs required to be obtained by the petitioners shall be obtained by the petitioners.
Please, grateful. Obliged.
Pending IA stands disposed.
Please.
Serial number 18, SV Prakash.
My lord, I appear for petitioner.
Yes,
My lord, this is a lost case, missing, my lord, of son of the
last
petitioner.
case. Énaಯ್ತು?
The time was taken to, my lord, report what is the stage of investigation and all.
ಹೇಳ್ತಾರೆ ಇರ್ಲಿ.
Placing the
ಮೂರ್ ವಾಲ್ಯೂಮ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
entire document pertains to the investigation.
ನಿಮಗ್ ಭಯ ಪಡಿಸ್ತಾ ಇದ್ದಾರೆ. ಏನಾಗಿದೆ?
One is closed on the ground that, that person.
Your colleague is here, Mr. Prakash.
Yes, my lord, your lordship may kindly have it after vacation. Let me go through it and make submission.
Now, where is your colleague? Please ask it to be collected.
Yes, my lord.
From the AGA. Learned AGA has filed documents in 3 volumes. Learned counsel for the petitioner who appears through VC submit that he would be collecting, he would get this same collected from the learned AGA. Go through the same and make a submission. Relist on 17th January.
Obliged. Highly appreciated.
19, KV Satish.
Respondents, my lord. Would it be called after vacation, Lord? Lord Advocate General.
No calling from the Advocate General submit that you committed a mistake and he'll make his submission.
He's not in station today, my lord. He asked me to take, my lord, immediately after vacation.
Tomorrow. Relist tomorrow.
He's in Delhi, my lord. I don't know whether he's coming back.
He'll be there. If he's not there, you get ready. Or we will pass the order.
Immediately after.
No, Pradeep. तुमने ये न कर पाया. Your officer have
next week.
Right royally, you come forward and say you will do the needful. And you will reduce the price. You reduce the price for everybody and you are registered. You can't be targeting them.
No. Not like that, my lord. My lord, by the time passing of the resolution, my lord, he has already, my lord, deposited that amount.
ಅದಕ್ಕೆ ಇಟ್ಕೊಂಡ್ ಬಿಡ್ಬೇಕಾ?
ಆ ತರ ಅಲ್ಲ, but we have to, my lord,
ಇನ್ಮೇಲೆ ಯಾವ್ದು ಕೋರ್ಟ್ ಫೀ ವಾಪಸ್ ಮಾಡಲ್ಲ ನೀವು. ಪೇಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ವಾಪಸ್ ಮಾಡಲ್ಲ.
Respect of 14 industrial areas, my lord, the refixation of price was, my lord, made. But
You have to go by what you have refixed.
that is true, my
Only
lord.
that amount
Not
is
at all disputing that, my lord. Immediately after vacation, my lord. First
Yes,
week.
tomorrow.
Lord.
Tomorrow. Next.
Serial number 20, Karthik V.
But my lord, of mandamus, my lord, to consider the next A.
Fresh matter, preliminary.
Lord petitioner hearing, my lord, was an accused, my lord, in the.
Ian, what is annexure A?
But we have given annex A to the respondent number 2, my lord, asking him, my lord, the details of the properties which have been sold in auction and what is the amount which has been due to the other investors. My lord, requisition against me was, and I was working as the chairman of Kranti Veera Sangoli Rayana Urban Credit Society.
ಇಲ್ಲಿ ಹೆಂಗ್ ಬಂತಿದು?
ಇದು GM ಇತ್ತು, there is special order, my lord, since the.
ಅಲ್ಲಪ್ಪ, okay, this should be in Dharwad bench ಅಲ್ವಾ?
My lord, the second respondent, my lord, we have given the representation here, my lord.
Oh, he is here.
He is appointed, my lord, as per section 5(1), my lord, of the.
You give the documents.
We are not second respondent. Second respondent is.
Second respondent ಯಾರು?
Lord, he has been appointed by the state.
ಅಲ್ಲಪ್ಪ, ಯಾರ appearance?
Assistant Commissioner. my lord.
Notice ಏನಕ್ಕೆ ಹೋಗು? ನೀವೇ ತಗೊಳ್ಬೋದ? Assistant Commissioner. Competent authority on KPID.
Yes.
Learned AGA accepts notice for respondent number 1 and 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petition. 12th December nim letter.
My lord, no, criminal case ನಡೀತಾ ಇದೆ. Unless I know, my lord, what.
ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಟೈಮ್ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ವಿಲ್ 12 December application, 17 December writ petition.
After in 2017, I was arrested. In November 2024, I was released by the Honorable Supreme Court. Now, my lord.
You have taken 6 years to file application. You don't even want to give them 6 days.
Custody till November 2024.
Submitted an application on 12 December 2024 to the second respondent, which has been received by a second respondent 13 December 2024. Under the said application, the petitioner has sought for details of the properties which have been attached, both movable and immovable. Though the petition has been filed in quite earnest, in as much as the application was submitted on 12 December 24, and no time has been even granted to respond number 2 to respond. I have the considered opinion that instead of dismissing the above petition, a direction could be issued to respond number 2 to consider the application dated 12th December 2024 and issue the documents sought for within 3 weeks from now. In that view of the matter, I pass the following order. Writ petitions allowed. A mandamus is issued directing the second respondent to consider the representation dated 12th December 2024, received by second respondent 13th December 2024, within a period of 3 weeks.
Copy of that may be given to, means the petition may be directed to.
Copy ilva nimge?
We have not.
GS served antide.
Yes, sir, but 24 will go there.
Okay. Kodi, copy kodi.
Further argument, serial number 21, Chandan K and connected matter.
Yes, Chandan. We'll just finish the list and come back to you. Paso.
Further hearing, serial number 22.
Enaitappa, tasdik.
All the lands have been given except 3 acres, 10 gunta. The letter and the details are already sent, my lord, but
All are
been granted under Form 7 and 7A, my lord. There are other 24 Form 26 Form 7s are pending and 24 forms of 7A are pending, my lord.
Inna ivaglunu.
Ivaglunu for the extent of 3.
Today's data, they are giving para number 3, if we read, Form 7 and 7A. ಒಟ್ಟು ಸಂಖ್ಯೆ 50 ಅರ್ಜಿಗಳು ವಿಸ್ತೀರ್ಣ 87 ಎಕರೆ 13 ಇರುವುದಾಗಿ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ವಿಷಯ ನಿರ್ವಾಹಕರು ವರದಿಯಂತೆ ದಾಖಲಿಸಿ. ಇದರಲ್ಲಿ 7 ಅಡಿಯಲ್ಲಿ 26 ಪ್ರಕರಣಗಳು ಇತ್ಯರ್ಥವಾಗಿರುತ್ತವೆ ಮತ್ತು ಫಾರಂ ನಂಬರ್ 7ರಲ್ಲಿ 24 ಇನ್ನ ಬಾಕಿ
ಇರುತ್ತದೆ.
That means, my lord, as of the date of vesting of the land in Mujurai, the data Mujurai register holds good and I was in possession of.
It can't be.
That can't be. ಆದ್ಮೇಲೆ ತಾನೇ our applications ಬರೋದು. So if there are tenants who are seeking for grant of occupancy right, that means you have tenanted it out.
I tenanted up to extent and shown the extent that has been recorded, my lords.
That is what you have declared. Now, if there are claimants for 87 acres, 13 guntas, which they claim that has been tenanted.
That cannot be depriving me of.
ನೀವೇ adjudicate, ನೀವೇ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಲ್ಲ ಹೇಳಕ್ಕೆ. It's against you. You are a party there.
He was a party.
My
Now,
instruction.
You have to be a party there.
and
You have to defend it. ನಿಮ್ against ಇದ್ದವಾಗ.
But what is extent remaining with the land? What is the extent that has actually been tenanted is the question that needs to be answered separately. That cannot be.
Until that answer is made, you can't claim anything. It's a.
Not be clubbed with granting of Tasdik allowance, which is granted for us.
See, we can direct them to grant you Tasdik allowance in respect of the undisputed area.
undisputed area is the temple area, my lord. Temple area and adjacent.
ಬಾಕಿ ಎಲ್ಲ tenanted.
Ella tenanted. Maybe, my lord, petition may be looked into, my lord. Petition at page number 32, my lord. From 32, the RTC runs. No RTC is in the name, means at column number 12, no name is in the petitioner's name at any point of time.
ಇವಾಗ 1/8 ತಗೊಂತೀರಾ without prejudice. ಆಮೇಲೆ if you succeed, depending
Or
on
she
the
can be
outcome, you
demanded
can.
back for her to prove that she is the absolute owner of the land and she is taking the entire income for herself.
My lord, this issues were already considered once by the revisional
was-
commissioner and there was an order that was passed by the revisional commissioner
The-
granting me
Excess-
68,000 rupees as the Tasdik
Lord,
allowance.
that is also under challenge. That she has completely failed to prove that she gets the 100% of the revenue what has been generated. It's only
Yeah, he gets.
sorry.
ಅವರಲ್ಲ party.
He gets. But in the petition itself, my lord, all the RTCs and at column number 12 are in others' name and it has already been dispersed. I have an entire list has been sent to me, soft copy. They will send the copy also. I will file the same before this honorable.
ಇವಾಗ 1/8 ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ until the disposal.
My lord,
After that, you can come. Otherwise, we'll have to hear you. You may not get anything.
Here, I just request my lord to kindly turn to page number 103.
He wants to file all those things. We'll have to give him time to file.
On fifth or sixth, my lord.
Lord AGA
Sixth is.
submits that he has received a
or-
letter on 18/11/2024 on certain documents. He is compiling the same and would be producing
The details of each survey number.
the details related to each survey
Available or not?
number as regards which Form 7 or 7A has been filed, as also the orders passed therein. Relist on
After
ಯಾವ್ದೋ hearing
15th
ಇದೆಯಲ್ಲಪ್ಪ ಇದು?
After 12th or 15th.
16th January,
Much.
2:30 p.m.
Final hearing, serial number 23. Vikram Muni Rajagopal.
Yes.
Yeah, my lord, notice file is missing, my lord, in this. It's I have produced the record. That there is a.
Use the refusal register. Or should say directly to secure the original file containing the notices and the correspondence.
ಏನೋ ಇದೆ ನೋಡಿ ಅಲ್ಲ ಅಷ್ಟೊಂದು ತಂದಿದ್ದಾರೆ ಪಾಪ. Yes.
ಇಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ನೋಟಿಸ್ ವಿ ಹ್ಯಾವ್ ಸೆಂಟ್ ಮೈ ಲಾರ್ಡ್ ಬಟ್ ದಟ್ ಫೈಲ್ ಆಫ್ ನೋಟಿಸ್ ಈಸ್ ನಾಟ್ ದೇರ್ ಇಟ್ ಡೇಟ್ ಬ್ಯಾಕ್ಸ್ ಟು 89 ಮೈ ಲಾರ್ಡ್ 1989
89 notice.
89 ನೋಟಿಸ್ ಫೈಲ್ ಕೇಳ್ತಾ ಇದೆ 89 ನೋಟಿಸ್ ಈಸ್ ನಾಟ್ ಅವೈಲಬಲ್
Like destroy ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಅದೇನ್ ನಾವು ಹುಡುಕ್ಸಕ್ ಹೇಳಿದ್ವಿ ಬಟ್ ಆದ್ರೆ ನಾಟ್ ಫೌಂಡ್ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿರೋದಕ್ಕೂ
ಡಿಜಿಟೈಸ್ ಮಾಡ್ಬೇಕು ಸ್ಫೂರ್ತಿ ಇದೆಲ್ಲ.
ಎಂಟೈರ್ ನಾಟ್ ಓನ್ಲಿ ದಿಸ್ ಫೈಲ್ ಇದ್ರ ನೋಟಿಸ್ ಅಂತಲ್ಲ ಎಂಟೈರ್ ಇದ್ರದೂ ಇಲ್ಲ 2000 ತಕನೂ ಏನೂ ಸಿಕ್ಕಿಲ್ಲ.
But now there is endorsement of dispatch of notice.
Notice was dispatched, order was passed. ಅಷ್ಟೇ
Order ಕೊಡಿ ಅದು. You take inspection.
Petition also extracts.
Take an inspection of the refusal order. But, pursuant to that, your lordship.
No, now that the register is there of having dispatched the notice.
Dispatch on the issue. Petition at page number. Petition.
This is the entry made in the year 1989.
89.
230A reference ಇದೆ.
Yes, that is there. Insofar as the order of refusal being communicated.
1989 this is.
Order of the refusal is of the year 2000, 10/11/2000. There was page 31.
ಅದು 2000 communication ಗೆ?
No, file is not there.
File ಅಲ್ಲ, register ಆದ್ರೂ ಇರ್ಬೋದಲ್ಲ. Similar dispatch register.
I will verify, but dispatch register, if it is available. I will verify.
Dispatch register should be sufficient. 2000 and all we can't expect.
Yes, register will be there. 2000.
AGA submit that the register as regard the dispatch of the notice in the year 1989 is available. Counsel for the petitioner is permitted to take out inspection of the said register. Insofar as the refusal order is concerned, he submits that he seeks for and is granted 2 weeks' time to produce the dispatch
Register after the order is passed.
as regard the communication of the refusal order. Relist on 16th January.
Much.
24. Vice Kiran Shetty.
Yes. Settle.
Settled, my lord. Only thing is, the RFO has to report. In fact, I had given a call to the RFO. He said that, my lord, he will be communicating with Mr. Mukesh.
Who is to report?
The range forest officer. The amount which we have deposited before the honorable court, 75,000. Now.
The Cashew Development Board, yes.
Lordship, settlement process was ongoing. We have instruction regarding that. Whether it is finally settled, we've not received information from the range forest officer actually. It was regarding.
The council seek for and are granted 2 weeks, 3 weeks' time to report settlement. Relist on 17 January.
25.
Regarding supply of sandwood.
Sandwood.
800 kilos.
The remaining 887 kg ಕೊಡಕ್ಕಾಗತ್ತೆ ಅಂತ ನಾವು ಕೇಳಿದ್ವಿ. Officer is present.
ಹಾ.
2 weeks time ಕೊಡಿ
ಕೊಡ್ತೀರಾ?
ಅದಕ್ಕೆ ಆಫೀಸರ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್.
ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರ ಕ್ಲೇಮ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ಬೋದು. ನೆಕ್ಸ್ಟ್ ಯಾವತ್ತೂ ಬರಂಗಿಲ್ಲ.
2 ವಾರ ಟೈಮ್ ಕೊಡಿ ಸರ್.
Taking another birth.
Taking ಬೇಡ.
And AGS seeks for and is granted 2 weeks time to make his further submission. Relist on 15th January at 2:30 PM
Serial number 26.
for further hearing.
27. Mita AN.
My lord, I appear, my lords, in this matter for the petitioner.
Yes.
My lord, there are two applications, my lord. One is an application for early hearing.
Just a moment, Mr.
I'm so sorry.
ನೀವು ಮೈಕ್ ಆನ್ ಮಾಡಿ, ಅವ್ರು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಸಮಾಧಾನ
ಯಾಕೆ?
ಇವತ್ತು ನನಗೆ ರೆಡಿ ಆಗ್ಬೇಕು ಸ್ವಲ್ಪ, ಯಾಕಂದ್ರೆ ದಿಸ್ ವಾಸ್ ಹರ್ಡ್ ಟ್ವೈಸ್ ಅಂಡ್ ಬಿಫೋರ್ 2 benches.
Then you would ready.
Today I got, that's why, after vacation on date fixed. So treated part at released at their instance, again it was treated part of 2 benches, again it was released, it required some time.
It's a matter that has seen, my lords, marathon number of hearings. Probably it has been
Yesterday, I
listed
think.
50 times. We've also done our best, my lords, to try and settle this matter, but that's not been possible, my lords, for various reasons. I'm just requesting, my lords.
You can submit that he is not ready. You have moved the matter. It's not a
Yes,
dated
it's
matter.
moved, they moved, my lord.
So you
So
moved
Any
it
date,
last
Lords.
but one day. You moved it much earlier. The Lord Counsel for respond number 1 seeks for and is granted 2 weeks time to get ready and address his arguments. Relist on 15th January.
The 17th also.
17th January.
Very well, deeply obliged, deeply obliged.
IA 1 of 24 is allowed.
28. H.N. Narendra Dev.
Your Lordship, appearing to the petitioner, may I request your Lordships to kindly pass over the matter.
Also,
I'm here. I'm sorry, I'm here.
29. T. Prakash.
It's 28, I'm here, ma'am.
28.
I'm here for 28.
Ready?
Please.
Who is appearing? Ready. Yes. This has not been taken up earlier.
It hasn't been, ma'am.
We have a parted matter. We'll finish that. We won't take this up.
Very good.
We list on 9th January.
Very well.
29. Trustee.
Appeal for respond bank, my lord. Kindly pass over, my lord. Senior is
Has it been taken up or fresh matter? First time?
No, my lord, that is with regard to one-time settlement, my lord. It was being heard on several occasions. They wanted to produce a letter to show that that concerned manager
Is signed by that
yes, my lord.
Vignesh Shetty.
Yes, ma'am. Kindly pass over. Much obliged.
Serial number 30, adjourn 31.
31. Lordship, with great respect, seeking time, respond number 3.
The request of counsel for respond number 3 released on 17 January.
Obliged.
32.
In this matter.
Yes, Mr.
I
Babu.
beg to appear for the
What
petitioner.
happened?
Let my learned friend may have to make a statement. My learned friend government advocate with regard to para 14 of Obaya Pujari's judgment.
District
The authority concerned.
DC whether is the authority.
Yes, yes. Only to that limited extent.
May make one.
What
has happened is-
May
make one submission, Madam, for your lordship's concern. The contention relating to want of jurisdiction was never taken by the petitioner.
One
In fact, it is
submission
covered
by
with
the
it.
Miss Fine, Mr. Rao.
Madam, it
He
may
has
be
to make that
immediately called
submission.
after vacation, Madam. In the
Pass over.
afternoon, I have some
That's
difficulty.
instead of a Passover, let's may pray it immediately after vacation.
He'll make that submission, we'll take it. That's- Neither of your submissions are required.
Yes.
It's only a submission
Let's,
by
if
Mr.
if my learned friend makes a statement that deputy commissioner is the authorized authority, then let's,
Yes.
your lordship may dispose it of. My presence may kindly be
Please.
dispensed with. highly grateful.
If he says is not the authorized, then we'll have to remit it to the authorized.
Not like that.
Yeah.
My only submission is this. Apart from that, these submissions relating to whether the deputy commissioner was the competent authority or not. Having acceded to the jurisdiction of the deputy commissioner. He cannot question it here before this honorable court. There is the judgment of this honorable court. A division bench ruling is there.
We'll adjourn it.
Yes,
If
madam.
he says it's not.
Yes.
Yes, madam.
Highly grateful to you.
33. Abhinavar.
This is that Melkote matter, my lord. Where petitioner,
Yes, he has to conduct the inquiry.
Lord, that is in,
Directed for the AC to conduct the inquiry.
it is in so far as the petitioner's brother is concerned, my lord.
ಏನಾಗಿದೆ ಎನ್ಕ್ವೈರಿ ಇವಾಗ?
If the allegation of that gold jewelry was modified.
Correct. But enquiry,
Inquiry has to be conducted by the inquiry officer who was previously appointed as transferred. Now the assistant commissioner of revenue is there, madam. It may be directed to.
he is going to.
He is. Maybe
And
directed.
AGA submit that the the previous inquiry officer has been
Under the
transferred.
act, my lord, since it is a A-grade temple, Lord, everything comes to the commissioner. Since it is an A-grade temple.
A-grade temple.
A-grade temple.
AC ಮಾಡಕ್ಕಾಗಲ್ಲ ಆಮೇಲೆ.
ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ my lords have, in the previous order said it should be initiated and concluded ಅಂತ.
Correct. By whom?
But let the commissioner will take a call.
ಯಾವ section?
Lord, section 5, my lord.
No, who is to conduct the inquiry? 5 will ಬರಲ್ಲ.
He will have to, my lord, appoint somebody because, my lord, commissioner will have to appoint somebody.
So that is what he is saying. The assistant commissioner can be appointed anta. Under instruction of the endowment commissioner, he is making the submission.
Assistant commissioner revenue.
ಅಲ್ಲ, but ಏನು?
ಮೊದ್ಲಿದ್ದು revenue.
ಅಲ್ಲ, but commissioner ಅವ್ರು ಹೇಳಿದಾರ?
ಇಲ್ಲ, commissioner.
ಅಲ್ಲ, commissioner will have to take a call.
I will take instruction, I will submit it within 1 hour. With 1 o'clock I will. That is the only.
Because he is the disciplinary authority.
Pasu.
In previous matter, crusher matter, my lord, the DC has no power, it seems, right?
Absolute the judgment of that night is no notification was issued. Appointing or constituting the deputy.
No notification.
No notification.
ಯಾಕ್ರಿ ಕಷ್ಟ ಕೊಡ್ತೀರಾ ಜನಕ್ಕೆ ಹಿಂಗೆ? 32 learned AGA submits that no notification has been issued appointing the deputy commissioner as the designated officer. To enable the councils to make their submissions, relist on 17 January, 33 Passover.
33 interim order.
Passover.
ಒಂದೂವರೆ ಒಳಗಡೆ ನಾನು submit ಮಾಡ್ತೀನಿ.
34. ಮೌಲ್ಯಪೂರ್ಣ.
Kindly pass on, madam.
Passover. We can't take it. ಏನಿದು? What is this matter? Madam, wait. We have not passed it over. ಏನಿದು? ತಗೊಂಡಿದೀವ ಇಲ್ಲ ಅಡ್ಜರ್ನ್ ಮಾಡ್ಬೇಕು. ರೀಚ್ ಆಗಿಲ್ವಾ?
In 34, madam, they are challenging the closure of the inquiry. 34.
Relist on 15 January.
Serial number 35. HR Ananta Krishnamurthy.
Hearing for the respondent, madam.
Yes.
On record, counsel for the respondent have some inconvenience, madam. Kindly matter of
For the year, request of
2014.
he is
Yes.
not well, he has been hospitalized.
Please, madam.
It's submitted that the counsel for respondent is unwell. Relist on 22nd January.
Please.
Serial number 36, Adjourned 37. P. Mahesha.
For respondent, your honors. Panento.
None appears for the petitioner. Relist on 22nd January.
Serial number 38, Adjourned 39.
Respondent number 4.
Yes.
For the petitioner, my lord, this matter may kindly be taken up after vacation, my lord.
The request of counsel for the petitioner relist on 22nd January.
There is interim order, my lord.
Interim order earlier granted is extended till next date.
Serial number 40, Y. Radha.
This 40, Hiriur mutton shop, shipping of mutton.
ಏನಾಯ್ತು?
They have to implement the interested persons.
ಮಾಡಿಲ್ವಾ ಇನ್ನ?
ಇಲ್ಲ.
None appears for the petitioner impleading application to implead the affected parties is yet to be made. If needful is not done by next date, illa last time bandilwala.
No, last time bandilla.
None appears for the petitioner today also. Again, Mr. Mahesh, we'll have to dismiss it ಅಷ್ಟೇ.
ಇಲ್ಲ ನಮ್ಗೇನಿಲ್ಲ ಇಫ್ ಇಟ್ಸ್ ಅಲೌಡ್.
ನೀವು ಅಲೋ ಅಂತೀರ ಅವರೇ ಬರ್ತಾ ಇಲ್ವಲ್ಲ ಏನ್ ಮಾಡೋದು?
ಅದೇ ಬಂದಿರೋದು, ದಟ್ಸ್ ದ ಪ್ರಾಬ್ಲಮ್.
ಅವ್ರ ಪಾರ್ಟಿನೂ ಮಾಡಿಲ್ಲ ಅವ್ರನ್ನ.
ಅವರೆಲ್ಲ unauthorized occupants. The municipality has to take action by itself.
We'll give them one more opportunity to come. Let us see. None appears for the petitioner today also. If none were to appear for the petitioner on the next date of hearing, the petition would be liable to be dismissed for non-prosecution. Relist on 22nd January.
Much obliged.
41, Shankar Narayan Bhatt.
None appears. Relist on 22nd January. Imprimatur is the note.
Serial number 42, V.S. Arbati.
22nd January. None appears.
43, P.M. Haraswamy.
Total mood ಏನಕ್ಕೆ? Who moved it? ನೀವಾ ಅವರ?
It's from my office only.
ಏನಕ್ಕೆ? What is that?
What's urgency? There's an interim order of status quo, my lord. A sister, my lord, filing complaint because of the internal dispute. The property was gifted in favor of the daughter.
Senior Citizen Act.
Senior Citizen Act. Telling.
Though counsel for the petitioner is present, none appears for the respondent. Relist on 9th January. If none were to appear for respondent on that day, respondent number 2 on that date, matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Interim order.
Interim order earlier granted is extended till. Great.
44,
ಯಾಕೆ ಚಂದ್ರಶೇಖರ್ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ?
24 to applicability ನಡೀತಾ ಇದೆ. ಇವಾಗ ಶುರು ಆಗ್ತಾರೆ 2 ವಾರದಿಂದ. ಇವತ್ತು ಮುಗಿತಾರೆ, ಅದಕ್ಕೆ ಅಲ್ಲಿ ಓಡ್ಬೇಕು ನಾನು ಅಷ್ಟೇ.
Not even 5 minutes, my lord. My argument is either they have to refund the money.
Not ask. 2 weeks ರೆಗ್ಯುಲರ್ ನಡೀತಾ ಇದೆ.
ದಿನ ನಡೀತಾ ಇದೆ.
ನಡೀತಾ
ಅಲ್ಲ, ಏನಾಗಿದೆ? My
ಇದೆ.
submission,
ಲಾಸ್ಟ್ occasion
not more than 3 minutes. My argument is not more than 3 minutes.
3 minutes ಅಂತ.
ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅಂತ ನಾನೇ ಮೆನ್ಷನ್ ಮಾಡಿ ತಾವು ಹಾಕ್ಸ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಫೈಲ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅಂತ.
Last time ಹಿಂಗೆ ಆಯ್ತು, ಮಿಸ್ ಆಯ್ತು ನನಗೆ.
ನೀವು ಇರ್ಲಿಲ್ಲ ಅವತ್ತು.
Because I paid the money in the year 2016, my lords, earnest money.
Again time ಬೇಕಂತಲ್ಲ.
ಅಲ್ಲ, ಅದು plots ಇಲ್ಲ ಅಲ್ಲಿ. Let them confirm plots ಇಲ್ಲ. ನಮಗೆ ಕೊಡ್ಬೇಕಾದ್ರೆ plots allotted to somebody else. Let them come tomorrow. Let them say before the court. Let them refund my money.
ಗುಲ್ಬರ್ಗ ಇದು, ಇಲ್ಲಿಂದ ಅಲ್ಲ ಇದು.
ಗುಲ್ಬರ್ಗ
ರಾಯಚೂರು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರರ್.
Actually,
I'm the manufacturer.
ಇನ್ಫಾರ್ಮೇಶನ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ನೀವು?
Here only. KDB.
No, the lands are in Kadachur and Yadgir.
Radchur Industrial Estate, all the information available here only.
Counsel for the KDB seeks for and is granted 2 weeks' time to obtain instruction on availability of plots.
And already allotted, my lords, my submission.
The lordship may record his submission. He said, I do not know. He says it's allotted to somebody else. Then your lordship
And counsel for the petitioner submit that the plots which had been allotted to the petitioner have been allotted to someone else.
Please.
That is their
That view of the matter, counsel for respondent number 2 is directed to obtain instructions as regards whether such allotment has been made. And if such allotment has been made, if there are any other alternative plots available for allotment to the petitioner.
5 acres of the land is enough to me, my lord. All together, all the 3 petitions, 10 acres of the land is enough to me.
ಅಷ್ಟೇನಾ ಸಾಕ? 10 acres. ಇನ್ನೊಂದು 30-40 ಎಕರೆ ಹೇಳಿ, 50 ಎಕರೆ ರೌಂಡ್ ಫಿಗರ್.
Actually,
Relist on ಅಲ್ಲಿಂದ ಬರ್ಬೇಕಾ? Relist on 23rd January.
My lords, 9th or 10th kindly.
ಬರಲ್ಲ ಇನ್ನ. Let him get the information.
Kindly 9th or 10th.
Let him get the information. Wait.
9th, okay. 9th or 10th, kindly. He is also concerned.
ಬರುತ್ತಾ ಅಷ್ಟೊಳಗೆ?
ಅವ್ರು 10th ಹಾಕೊಳ್ಳಿ ಸಂಬಂಧ.
10th January.
Please.
ಅವ್ರು ಯಾಕೆ ಬೇಜಾರು ಪಾಪ
ಅಲ್ಲ ನೀವು ಆಮೇಲೆ ಇನ್ನ ಟೈಮ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ.
ಅರ್ಥ ಆಗಲ್ಲ, ಬೇಜಾರು ಪಟ್ಕೊಂತಾರೆ. ಅವ್ರ ಬೇಜಾರು ಪಟ್ಕೊಂತಾರೆ ಹೇಳಿದ್ರೆ.
ಬೇಜಾರು ಪಟ್ಕೊಂಡ್ರೆ ಪರವಾಗಿಲ್ಲ, ಅನ್ನೆಸರಿ ಲಿಸ್ಟಿಂಗ್ ಬೇಡ.
23rd.
List on 22nd January.
Please.
Get it by then.
Please.
45, H. Mohan Kumar.
None appears. Released on 22nd January.
Lord, I am for the respondent.
None appears for the petitioner.
46, Kashinath JD.
I appear for the respondent number 2 and 3, my lords.
None appears for the petition.
for
though
respond number
counsel
two,
for
my lord.
Respond number 2 and 3 are present. Relist on 22nd January.
Please, my lord, my job.
47.
Petitioner, my lord.
Yes.
My application for to renew the license with respect to the wood cutting, my lord, in timber business has been rejected. I file an appeal, my lord, under rule 163(10). Kindly see the impugned order, my lord, at page 16, my lord. The appellate authority says, my lord, I called for records, you don't submit the records, therefore I'll send the back file to you. Last paragraph, ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ನಿಮ್ಮ ಕಚೇರಿ ಪತ್ರದ ಮೂಲಕ ಈ ಕಚೇರಿಯಿಂದ ಕೋರಲಾದ ಯಾವುದೇ ಮಾಹಿತಿಯನ್ನು ಲಭ್ಯವಿರಲ್ಲ ಎಂದು ತಿಳಿಸುವುದರಿಂದ ಈ ಕಚೇರಿಯಲ್ಲಿ ಯಾವುದೇ ಕ್ರಮವನ್ನು ಕೈಗೊಳ್ಳಲು ಸಾಧ್ಯವಿಲ್ಲ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ಹಂತದಲ್ಲೇ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಲಾಗಿದೆ. Statute appeal cannot be disposed of.
Sent back to the person who has passed the order. ಹೆಂಗೆ?
Page 17, section B1.
Assistant Conservator of Forest has passed the order.
There is
That is under challenge before the Conservator of Forest. Because the Assistant Conservator of Forest has not sent the document, or Deputy Conservator of Forest has not sent the document, he sent it back.
Prayer itself is, my lord, in the writ petition to reconsider my appeal. Prayer B, my lord, is to, A is to set aside, B is to reconsider.
Appellate authority has to consider, you cannot send it back.
After correcting the.
Petitioner is before this court seeking for the following relief.
Section B1 ಅಲ್ಲಿ. Kindly turn to page 17. Vertical ಅನ್ನೋದನ್ನ ಒಂದರ ಅವ್ರು 22 ಮಾಡಿದ್ದಾರೆ.
Yes.
That matter is gone.
Page?
Page 17, this is B1. Our petition. Vertical one or 2 ಮಾಡಿದ್ದಾರೆ.
Now, my lord, may take the orders, my lord, which they themselves have passed. They themselves from 2010, my lord, 2000, I come in.
Sanction ಮಾಡಿದ್ದು ಒಂದಕ್ಕೆ ಮಾತ್ರ.
ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು. You may have a good this one. The conservator had to, ನೀವು ಹೇಳೋದು conservator ಹೇಳಿಲ್ವೇ? He has to pass the order.
Please,
Petitioner is before this court seeking for the following reliefs. The petitioner had challenged the order passed by the Deputy Conservator of Forest, respond number 4. Dated, what is the date?
25/8/2020, man.
No, your 4th respondent order.
Yes, my lord. Annexure G, my lord. Annexure G, page 39, my lord.
39.
Yes, my lord. 25/8/2020.
Dated 25/8/2020. Before the second and third respondent, Chief Conservator of Forest. The Chief Conservator of Forest, while the impugned order dated 29/9/2020, remitted the matter back to the respondent number 4, Deputy Conservator, on account of the Deputy Conservator of Forest not forwarding the file and details pertaining to the matter to the respondent number 3. It is challenging the same, the petitioner is before this court. Admittedly, the order under challenge before the third respondent was the order passed by the 4th respondent, as indicated above. If that be so, merely because respondent number 4 did not forward the files to the respondent number 3, respondent number 3 could not have sent back the appeal for consideration by respondent number 4. Respondent number 3, being the appellate authority, was required to pass necessary orders on the appeal. And if respondent number 4 had not forwarded the files, respondent number 3 ought to have taken necessary action in the administrative jurisdiction as regards the non-compliance by respondent number 4, if not on the quasi-judicial jurisdiction. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued, annexure A bearing so and so is quashed. Third respondent is directed to the appeal papers are restored before the third respondent, who is directed to consider the appeal and pass necessary orders in accordance with law as expeditiously as possible. Respondent number 4 is also directed to forward the files requested of by respondent number 3 within a period of 15 days from the date of receipt of a copy of this order.
Interim order granted by this court to continue pending appeal. my lord.
Interim order granted by this court shall continue until the disposal of the appeal by third respondent.
Obliged.
Serial number 48.
I appeal for respondent number 1, my lords. My lords, the petitioner prayer is that to transfer the cases filed by a wife from Belgaum to Bangalore, my lords. Our first submission is this writ petition is not survived because you have to invoke a section 24 of CPC and file a CP before this honorable court. So the writ petition is not maintainable, my lords.
They have filed, 34 has not been filed at all, is it?
Sorry, my lords.
34 transfer petition hakilva.
Is section 24, my lords. You have to file a transfer, so writ petition is not maintainable.
24. RP ಹೋಗ್ಬೇಕಲ್ಲ, CP ಗೆ ಹೋಗ್ಬೇಕಲ್ಲ. Under section 24 of the CPC. None appears for the petitioner. Perusal of the office objection ಏನಿದೆ?
My lords.
It's under section 24, madam.
Please, my lords, may I make another submission, my lords? The difficulty is that, my lords, since this honorable court granted a stay with respect
I
to my
think we'll place
maintenance.
it before the roster judge.
Please, my lords.
We'll place it, it's a CP.
Please, my
We'll have
lords.
to go before that roster judge.
Please, my lords, but since this honorable court granted a stay in my maintenance petition, I'm not getting a maintenance since from 2021, my lords. My application for interim maintenance is not also considering by the trial court. That is the difficulty, my lords.
ಬರ್ತಾನೆ ಇಲ್ಲ ಬೇಕಂತ. Petitioner is before this court seeking for the following. Perusal of the order sheet indicates that none has been appearing for the petitioner on the earlier occasions also. The office objections have also not been complied with. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Pending IA stands disposed.
Grateful.
Thanks. There are dear.
For the petitioner, page 32 is my prayer. It's the illegal changes in the sale deed. My lords, I've sought to initiate necessary inquiry because the concerned vendor, that is the respondent number 2, Bangalore City Chickpet House Building Cooperative Society, they have specifically admitted that there is no sale deed with respect to the extent that is provided by the respondent number 5. The endorsements, your lordship.
You
may
filed your
kindly-
objections? You are appearing for whom, Mr. Satyanand?
My lord, BBMP and respond number 2, Chickpete Housing Cooperative Society has to file, my lord. I'm appearing for 1 and 3, my lord.
R2 served. R5 served.
Yes,
So only your official respondents are present.
The official respondents are. What is under challenge, my lord, is the sale dates, are the sale dates before your lordship.
No, no, the
Not
illegal
challenge
changes
sale
in
deed,
the
about
sale
the changes made to the sale deed.
That's right.
Where is the sale deed?
That's the sale deed is at page number 63. This is by the
Relevant portion?
relevant portion is at page number 71.
Cannot be.
108/3 ಮಾಡಿದಾರಾ?
ಹೌದೌದು. The grievances, let there be a necessary action because the very official respondent number 2 themselves have admitted by issuing necessary endorsements at page number 159 annexure W. The check which is also shown in the subsequent sale deed is not utilized for the said sale transaction.
How are you concerned with this?
Because adjacent, my lords, there is my property. He has encroached my property also. And the very respondent number 5 has initiated a suit for permanent injunction. That is also.
This
annexed.
108/3
Correct.
is owned by you?
No, no, no. I am the adjacent owner, my lords.
Then how can you come here?
No, my only grievance is she is encroaching my extent of land, which is site
That's
number
a civil
8.
remedy that you have.
Correct, that is already initiated.
Yes.
Therefore, my lords, I have initiated action because she has made illegal changes in the sale deed and encroaching upon my property is my case.
This is a registered document.
That's right.
You are not a party to it.
I'm not a party, but annexure.
It doesn't
W-
affect any of your property.
But she is alleging, my lords, that it is this property which belongs to my property. So my property is site number 8. Our property is site number 108. And she alleges that another extent of
Your
land.
property is 108,
No, only 8.
only 8.
Only 8.
If she is trying to encroach your property, you have a civil remedy. And if you want to challenge that sale deed, you will have to challenge the sale deed in those proceedings, not like here. Because you are not affected by any of this.
Absolutely, my lords. The only concern is because the very respondent number 2 themselves have issued 2 endorsements, my lords. I'll only read that and
Elide
annexure W page 159.
159.
Melkanda.
Sale deeds.
Page number 159 annexure W.
PMG. Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮ ಸಂಘವು ಮಾಗಡಿ ಕಾಡ್ರೋಡ್ ರಸ್ತೆ ಹೋಬಳಿ ಬೆಂಗಳೂರು 40ರಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ಬಡಾವಣೆ ಪಕ್ಕದಲ್ಲಿರುವ ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್ ನ ಬಗ್ಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. 2009ನೇ ಸಾಲಿನಲ್ಲಿ ನಮ್ಮ ಸಂಘದಲ್ಲಿ ಶ್ರೀ MR ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್ವೆ ನಂಬರ್ 557512 2ನೇ ಕ್ರಾಸ್ 6ನೇ ಮುಖ್ಯ ರಸ್ತೆ ಸ್ಕೆಚ್ ಗಿರಿನಗರ ಬೆಂಗಳೂರು 85 ಇವರ ಸಂಘದ ವೇತನ ಕಾರ್ಯದರ್ಶಿಯಾಗಿದ್ದು ಇವರು ತಮ್ಮ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆ ನೀಡಿದ್ದು ದಿನಾಂಕ 3/2/2013ರಂದು.
Let her go to a civil court, not for this court.
And subsequently also only
This is by society.
correct.
Not by any government organization, not by BBMP.
Very society also.
By the state.
Very society also.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that respond number 2, the Bangalore City Chickpet House Building Co-op Society Limited has executed a sale deed in favor of respond number 5. And in the said sale deed, there's a manipulation made of the site number by inserting certain a marginal land, on which basis respond number 5 has sought to encroach upon the property of the petitioner. The allegations which have been made in the above petition are relating to a house building cooperative society and a private individual as regards a document which has been registered in the office of the sub-registrar. Whether there is a manipulation or the like cannot be ascertained in a writ proceedings. And as such, the prayers which have been sought for in the above petition are not maintainable. Reserving liberty to the petitioner to agitate the rights of the petitioner in appropriate civil proceedings, the petition stand disposed. The petition is however granted the benefit of section 14 of the Limitation Act for the time spent in prosecuting the above petition.
I'm grateful.
Prasanna VR. Petitioner.
Yes,
Fourth respondent. Connected matter.
connected matter. Connect with so and so.
6 of 2022.
Who is forming the road?
The fourth respondent is forming the road, my lord, society.
The forest.
That's the allegation. In the other petition, his allegation is that I have encroached a portion of an adjoining temple to form this road. And the interesting part, my lord.
So you're doing both, 2 encroachment, forest and temple.
Any of the fact is, my lord, when the license was issued for this construction, This very gentleman was president of the Panchayat, but it was granted on the 24th of June 2019.
Connect with so-and-so, relist on 10th, learned AGA is directed to obtain instruction. You have filed your statement of objection. ಹೇಳಿದ್ದೀರಾ?
No forest land is involved. He falls out of this society, because he was declared as a defaulter. Then there are.
They have said that there is no encroachment of any forest land.
I have not received the statement, my lord.
Statement was filed in 3/1/23.
I have not received the statement. Moreover, as per my instruction, my lord, they have formed the road on the forest land, my lord. I have,
Date itself is saying that, so unless you produce some document to show that they have encroached,
I will go through it, my lord. I will.
connect with so-and-so, learned counsel for the petitioner seeks for and is granted 3 weeks' time to go through the statement of objection filed by the state that there is no encroachment, wherein it's categorically stated that there is no encroachment of the forest land and make a submission. Relist on 22nd January.
The connected matters, local one.
ಯಾವ್ದಾದ್ರು ಇರ್ಲಿ. ಯಾರೋ ಒಬ್ರು ಮುಂದೆ ಹೋಗುತ್ತೆ.
Serial number 51. Vinod Kumar.
For the petitioner, my lord.
Yes.
My lord, I was allotted BDA site in 2004, my lord. BDA had not fully developed the site, my lord. My lord, now, my lord, the DC has transferred that particular site, property
Krishna,
for electric,
where is Mr. Krishna? Your relief is against VDA.
yes, BDA, and the order, I am challenging the order of passed by the DC. my lord.
Pass over. Barli.
52. P. Seshagiri Rao.
This is the state's order, my lord. Order passed by the state. DC has passed the order.
They are contesting respondent, are BDA na?
ಇಲ್ಲ, state.
BDA. BDA. Pass over.
So has to answer.
ಇವತ್ತು
Government-
ಎಲ್ಲಿ ಕೃಷ್ಣ ಎಲ್ಲಾ ಕಡೆ ಬಿಸಿ ಇರ್ತಾರೆ ಬರೋದು.
52. P. Seshagiri Rao.
Beg leave, Not this is not a case where not the exercise of powers under the new section 22B of the Registration Act is to be considered. Not someone has impersonated and forged the agreement of sale, that is standing in the encumbrances. I tender a representation to the authority. And the police complaint also reveals that there is a forgery, but they're not able to trace the person. For these purposes, the new amendment of 22B Registration Act for a moment.
Where is the sale deed?
Not a sale deed.
Agreement of
34. 34. This is continuing to stand because it is affecting.
Impersonated whom?
It's impersonating the petitioner. The photos may be kindly seen at 37. 37 minutes, column 2. It looks
That's
like
not your photograph.
no, it looks like some Santa Claus there. Looks like some Santa Claus. It's very deliberate. It's very deliberate. My photo minutes is in the gifted here for a moment because it's not clear. But 25 minutes. Manoj may compare the
122 registration.
Please, minutes. And one more thing, there's a new amendment to the Registration Act minutes. May I just pass this one?
Good.
Good, sir. Ide.
Yes.
22C for a moment. Cancellation of registered document in certain cases, the district registrar either suo moto or on a complaint.
Is it challenge pending?
It's
challenged or?
No, this is
22C.
not challenged, but this is recently approved. The presidential approval was given in the month.
Something which had come saying that it is challenged. 22C.
It's challenge agilla.
Live law ಎಲ್ಲ ನೋಡ್ದಂಗ್ ನಾಪ್ಕ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಅದು ಹಳೇದು ಇದೊಂದಿತ್ತು but this is the presidential approval is granted very recently. March in it was pending approval.
The power to the registrar to cancel the sale deed.
Yes, by the complaint of an aggrieved person. Emerging jurisprudence, everything cannot go to the civil court sometimes, especially in matters like this.
where we are not able to trace the person at all. Definition of forgery, my lords, is relatable to the same IPC definition.
Yes. If that is the amendment brought about, you will have to implement that amendment. Learned counsel for the petitioner submit that in view of
22.
the inserted section 22C to the Registration Act 1908 by way of the Karnataka amendment, action would have to be taken in terms thereof. Learned AGA seeks bond is granted 2 weeks time to obtain instruction, make a submission. Relist on 17th January.
To consider the representation submitted by the petitioner to initiate to prosecute the respondent's murder by filing representation.
Prosecute the respondents. Prosecute respondent illing.
Respondent number 4, 5, 6, 4 to 4, 5 and 6, madam. That is police inspector and Arjit.
Representation ಹೆಂಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಅಲ್ಲ ನಾನು ಇವರು ನಾನು ಇಲ್ಲಿಗಲ್ ಆಗಿ
B is addressed to Chief Justice of Karnataka. B1 is to Home Secretary. B2 is to Commissioner of Police. ಇವರಿಗೆಲ್ಲ ಕಳ್ಸಕ್ಕಾಗ ಸ್ಟೇಷನ್ ಹೌಸ್ ಆಫೀಸರ್ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಲ್ವಾ?
B1 consider ಮಾಡಬೇಕು. Home
can it
Department,
be?
Secretary. Secretary to the Department of Home, permission to prosecute Prashant, police, then in charge Mahalakshmi.
You cannot be, your reliefs that you are asking for are completely. ಏನ್ ಮಾಡ್ತೀರಾ? ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ? ಏನ್ ಮಾಡ್ತೀರಾ?
I will file a better.
Better ಅಲ್ಲ, you go file a complaint.
Complaint PCR ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
PCR annexure A ಮೇಲೆ.
ಮತ್ತೆ PCR order ಆಗತ್ತೆ.
ಅಲ್ಲ,
Depending
PCR
on that order.
against government servant ಮೇಲೆ I have to seek prior permission of the government.
Seek permission.
ಹೌದು, ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯೀಸ್ ಆಗ್ತಾರೆ. They are all government. 197 ಕೆಳಗಡೆ.
So ಯಾರಿಗೆ ಕಂಪ್ಲೇಂಟ್, ಯಾರಿಗೆ ಪರ್ಮಿಷನ್ ಕೇಳಬೇಕು ನೀವು?
ಗವರ್ಮೆಂಟೇ ಕೊಡಬೇಕು.
ಗವರ್ಮೆಂಟ್ ಯಾರಿಗೆ ಮಾಡಿದೀರಾ?
ಇದು annexure B1 ಹೋಮ್ ಸೆಕ್ರೆಟರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್
ಹೋಮ್ ಸೆಕ್ರೆಟರಿ ಮಾಡಿ, ಎಲ್ಲಿದೆ?
annexure B1 ಮೇಲೆ ಲಿಂಕ್ ಪೇಜ್ ನಂಬರ್ 24.
24, ಓಕೆ. ಚೀಫ್ ಜಸ್ಟಿಸ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಗ್ರಾಂಟ್ ಪರ್ಮಿಷನ್.
My party.
Consider B1.
Annexure
There is an appeal that there are almost 7 to 8 crimes are.
Pass orders.
Allegations.
You have to pass orders rejecting it. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the application filed by the petitioner for permission to prosecute a police inspector made to the Home Secretary, Department of Home at annexure B1 has not been considered. In that view of the matter, respond number 2, respond number 2, respond number 1 is directed to consider the representation made by the petitioner dated 6/12/2021 at annexure B1 and pass necessary orders in accordance with law within a period of 4 weeks from today. This court, it's made clear that this court has not expressed any opinion on the said representation. Date of receipt of the court.
Connected by.
53.1 ಏನು?
53 ಅದರಲ್ಲಿ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಪರ್ಮಿಷನ್ ಕೇಳಿದ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಒಳ್ಳೆ ಕತೆ, ಅದು ಫಸ್ಟ್ ಹೇಳ್ಬೇಕು.
ಪರ್ಮಿಷನ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇನ್ನೊಂದ್ಲಾಗಿ ಇದು ಡಿಫ್ರೆಂಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್, ಯಾಕಂದ್ರೆ ಡಿಫ್ರೆಂಟ್
13611 does not survive ಹಾಗಾದ್ರೆ.
ಈಗ ಅದು ಇದಾಯ್ತು. ಇದರಲ್ಲಿ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಫಾರ್
ಹೇಳ್ಬೇಕಲ್ಲ ಮಿಸ್ ವಂಶ.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
53, what the petitioner is before this court seeking for the following reliefs. The representation which had been made by the petitioner had been considered and rejected.
ಅಲ್ಲ 53 ಬೇರೆ 54 ಬೇರೆ.
54 ಅಲ್ಲ 53.1.
53.1.
ಹಾ.
14,964. It was reject ಮಾಡಿದೆ ಅದನ್ನ ಕ್ವಶನ್ ಮಾಡಿದೆ. Rejection is.
Rejection will consider.
Please, madam.
But 53 will have to go.
Yes, madam.
Has been rejected. Wide, letter dated 6/6/2023. Issued by respondent number 3 in WP 14964 of 2023. In that view of the matter, the release which have been sought for do not survive a consideration.
Well, I am questioning here to quash this and permit me to prosecute
The
them.
cost survey ಮಾಡಿ ಆಮೇಲೆ ನೋಡೋಣ.
ಅಲ್ಲ,
Petition does not survive consideration, stands dismissed.
Well, if it is rejected, my lord, my writ petition will become infectious. ಇದು
ಇಲ್ಲಿ ಇವಾಗ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ.
ರಿಜೆಕ್ಟ್ ಆಗಿರೋದನ್ನ ಕ್ವಾಶ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅದಾದ್ಮೇಲೆ ನೋಡೋಣಂತೆ. So rejection what are your grounds?
My grounds is that, my lord, your lordship can say petitioner is animal activities, my lord. My lord, he was doing animal activities and also apprised the BBMP officials with regard to menace, garbage menace, and also not sterilizing the dogs, my lord. It is revealed by the employees, my lord, that they are poisoning the dogs and killing them, my lord. This was recorded by the petitioner, and he has uploaded the same and lodged complaint to the Commissioner of Police, my lord. Thereafter, my lord, he has also filed a public interest litigation for illegal order by the state government for killing of 6 cheetahs, my lord. My lord, the police officers, my lord, they all of a sudden.
Cheetahs ಎಲ್ಲಿಂದ ಬಂತು? ಈಗ dogs ಅಂದ್ರೆ cheetahs ಹೋದ್ರೆ.
ಅಲ್ಲ, ಅನಿಮಲ್ ಆಕ್ಟಿವಿಟೀಸ್ ಇದೆಲ್ಲ ಮಾಡ್ತಾ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾ ಇದ್ರು. ಅದರಿಂದ ಏನ್ ಮಾಡಿ the police have warned that they will fix the petitioner in false cases, my lord. My lord, all of a sudden, my lord, when he made a file writ petition seeking public PL against the officers and the state government for ordering for killing of 6 cheetahs, my lord, they came and they were arresting the petitioner at the instance of Amit Shah, stating so, my lord, they were arrested and handcuffed and produced before the judicial magistrate and remanded him to for close corner for a period of 1 month. Without there being any medical document, without obtaining any medical report from the concerned doctor, they have all of a sudden they have ordered for magistrate order for to prison him in the close corner of my lord. Therefore, my lord, I have lodged a complaint and also sought for punishment. But they have they have not only handcuffed him, my lord, they have dragged him in the dress. Though they have this thing, my lord, made several requests of family members, my lord, they have dragged him, they have seized all the mobile phones and also destroyed the DVR and CCTV, everything they have taken away, my lord. With this regard, my lord, I have lodged complaint, my lord. But for the vengeance, my lord, this has been
Filed
taken.
your objections?
They have filed objections.
ಅದೆಲ್ಲ. Then AGS seeks for and is granted 3 weeks time to file a statement of objection to both the petitions.
Right.
Objections, if any, by 17th, relist on 23rd.
Your Lordships, I appear for respondent number 1 in this matter, Your Lordship. Senior is head up in another court, Your Lordship. I seek for a passover.
Passover will not reach.
Miller.
What is this impleading application?
It's an impleading application to implead this proposed respondent who has given the notice, my lord. This writ petition
Who is
was
the
filed.
proposed respondent?
This is the KSPCB environmental officer of Ramnagar, my lord, Ramnagar zone. This writ petition was filed.
Accepting
by
the reasons stated in support of IA number 1 of 24. This application is allowed. The officer name therein is brought on record as respondent number 3. Counsel for the petitioner to carry out necessary amendment, file amended cause title. Shri V. Sanjay Krishna, who has appeared for respondent number 2, accepts notice for respondent number 3. For respondent number 3 also, registry direct print his name as such.
No, my lord, My non-friend is representing respondent number 2, my
Who
lord.
is appearing for R1? Shri A. Mahesh Chaudhary, who has entered appearance for respondent number 1, accepts notice for respondent number 3 also. Please see that print his name as such.
My lord, there is an IA for stay of the operation of this notice, my lord. What?
Is a 22 matter. Now you
Yes, my
can
lord.
relist on
My lord, there is a,
22nd January.
my lord, there is an IA for to stay the operation of this notice, my lord.
Yes, 22 matter, there is no stay which has been granted.
No, my lord, it is issued now. This notice is 28th November 24.
28
This is,
November 24.
yes, my lord. This is issued by the respondent number 3, my lord, the proposed respondent. Because I have filed the complaint against the respondent number 1, 2, and then to direct the respondent number 1, my lord, to oversee the operations of modifications of the STP.
Your lord,
Since this handing over is still pending before the RERA court, my lord, and then meanwhile, this notice is issued by the proposed respondent, my lord.
your lordship, I have two submissions to that effect.
Hmm.
First, it's an NPD, your lordship. It's a show cause notice where they will be appearing for personal hearing, your lordship. NPD cannot be stayed. Second, your lordship, I'll produce this circular of our High Court. Matters pertaining to Pollution Control Board and Environment will go before
They have to go before the division.
division bench, your lordship.
Why is this here before us? This has to go there.
Earlier, the prayers were different, your lordship. Now that they are filing this, challenging the
What was the earlier prayer?
STP, monitoring of STP only.
Monitoring of the STP handing over, my lord.
So this will have to go before the division bench.
Please, your lordship.
Why did IA 1 of 2024, 2 of 2024, stay of a notice issued under section 33 capital A of the Water Prevention and Control of Pollution Act 1974 has been challenged. The registry is directed to place the above matter before the concerned roster bench. Since the Environment Protection Act, since a act relating to pollution, since a notice issued under the Water Act is
Water
under
Act.
challenge.
Please, your lordship. Great.
Serial number 55.
My lord, I appear for petitioner.
Mr. Prakash,
My lord, I have challenged, my lord, the sale of the primary properties, my lord. And also, my lord, a mandamus to, my lord, matter requires, my lord, some time, my lord. Today may not be possible.
relist on 22nd January.
God bless.
Serial number 56. Umapati.
My lords, this matter is regarding the police complaint authority, my lords. On the last occasion, your lordship has directed the AGA to place the details regarding the functioning of the authority.
Police authority and I.
Police authority is constituted. The relevant notification is not available as of now. It is constituted, headed by a retired High Court judge. As contemplated the judgment of 1996. I'll place that particular notification.
And AGA submit that the police authority has been constituted and a retired High Court judge has been appointed as a chairman in terms of the order passed by the Honorable Apex Court in Prakash Singh and others was the Union of India and others dated 22nd September 2006. He seeks for and is granted 2 weeks time to place the notification on record. Relist on 16th January.
57. Parmeshwarappa C.
None appears. Relist on 23rd January.
58.
Copy was directed to be provided to me, but not served, my lords.
Not served. Why haven't you served, Mr. Patina?
I think is it. I have not received it.
Hmm?
On 13/12. I have not received it.
13/12, we had directed him to take notice and we had directed you to serve copies.
I have not received it.
What you have not received?
Copy, sir.
You have to serve him copy. He is answering respondent.
Okay.
Your grievance was that prayers are not being permitted to be held.
Yes, Your Honor.
And Christmas is fast approaching. So you have to serve it on him.
I'll do it here.
If you don't serve it, then how will...
In meantime, my fundamental rights has been curtailed. They may allow me to
celebrate my Christmas here.
My lord, my instructions that conduct, though he's conducting a prayer in a place having around 100 to 200 members. It's a small space and we are getting complaints by the neighbor people.
Is there a church established there?
Yes, Your Honor, this is established.
Validly, legally?
Yes, it has been established.
Yeah, they said to have filed an application before the R4 for permission to construct.
You serve it on him today, tomorrow. Learned counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexes on the counsel for respond number 4 today. If the same is furnished by end of day today, counsel for respond number 4 is directed to obtain instruction and make a submission as to whether there is a church validly established in accordance with law in survey number 5/3 Gadalle village, Shaniwara Sante Obli, Somwarpet Taluk, Kodagu district. Relist 20th
2:30
December
can be at 2:30 minutes or
at 2:30 PM.
provided he gives me a copy minutes. Provided he gives me a copy minutes.
Provide, if he gives Santa, give him a copy. You should have given it to him by now.
Passed over matter serial number 33, my lord.
Huh?
In this, my lord, the revenue AC 33.
Huh?
Case.
Abhinav Velli.
Abhinav. Revenue AC was appointed by the commissioner itself for conducting the inquiry, as he was the administrator and he is the administrator as on today. So revenue AC has to conduct the inquiry.
33. Learned AGA submits on instructions that the commissioner, endowment commissioner, as authorized would be authorizing.
Already authorized revenue AC.
Had appointed the earlier assistant commissioner revenue.
Yes.
Of Mysura, Srirangpatna. Of Srirangpatna to be an inquiry officer. The said officer having been transferred, the inquiry could not be completed. The appointment of the inquiry officer had been made as per the designation.
Yes.
It is for the present assistant commissioner to complete the inquiry and submit a report. In that view of the matter, the assistant commissioner revenue Srirangpatna,
and he is the administrator.
who is also the administrator of the temple concerned, he is directed to complete the investigation and submit his report within a period of 2 months.
6 months.
6 months. Here the 60 gram gold difference. ಅದಕ್ಕೆ ಅಷ್ಟು ದಿನ ಬೇಕು. 6 months ಏನಕ್ಕೆ ಒಂದೊಂದು ತಿಂಗಳಲ್ಲಿ 10 ಗ್ರಾಮ್ ಹುಡುಕ್ತೀರಾ? ಇರೋದು 60 ಗ್ರಾಮ್ ಡಿಫರೆನ್ಸ್. 2 months and submit his report. 2013 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
At least 4 months.
Report to be submitted.
Revenue AC, they have requested first.
By 28th February 2025, relist on first week of March. ನಿಮ್ಗೆ 6 ತಿಂಗಳು ಮತ್ತೆ ಇನ್ನೊಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತೆ ಮಾರ್ಚ್ ಅಲ್ಲಿ. ಅದಕ್ಕೆ ಮುಂಚೆ ಹೇಳ್ತಾ ಇರೋದು.
Lordships kind leave.
Is not designated and notification ಇಲ್ಲ.
Time for meeting dates.
We'll hear both of you.
Apart from the, we personally feel that there was one meeting of the government subsequent to the order passed by the division bench of the historical court. We'll be giving directions. In that proceeding, I have a copy of that proceeding. In that proceeding, there is no specific mention about adjudication of claims. Maybe subsequently there will be something else.
The issue was whether the deputy commissioner was authorized in terms of the decision, notification was issued, subsequent division bench's judgment. Notification kottilla.
But notification kottilla annodukku let me ascertain, because normally he would not have passed any order without any such.
AGA submitted that there is no notification. Adadmele, Mr. Rao, how can you say anything?
Verify from the office of the DC. My request was, let him verify with the office of the deputy.
Verification ಮಾಡಿ ಹೇಳ್ತಾ ಇರೋದಲ್ಲ ಅವರು.
Deputy commissioner office.
I have taken instruction to the.
ಅವ್ರು ಸುಮ್ಮನೆ ಹಂಗೆ, why will he make that submission?
I ಹೇಳ್ತಾ ಇಲ್ಲ, because no the government authority will do anything without there being some authority.
ಇವಾಗ ಏನಪ್ಪ ರೆಕಾರ್ಡ್ ಮಾಡೋಣ?
Once again asserted. Instruction that no such notification or.
ಯಾವುದು serial number?
32.
32. At the request ಅದು ಆವಾಗಲೇ ಇದು ಮಾಡಿದ್ದು ಹೊಡೆದಾಕ್ಬಿಡಿ. At the request of the learned AG, a relist on 16th. ಅದೇನ್ ಡೇಟ್ ಇದೆಯೋ
Lordships kindly.
ಸಬ್ಮಿಷನ್ ಮಾಡಲ್ಲ.
I thought if there
I
is
had 16.
we may get some from you.
Yes.
With Lordship.
Serial
Yes,
number
Mr. Bhatt.
41 Miller.
41.
Yes, Miller.
In 41 withdraw ಮಾಡ್ತಾರೆ. 41 petitioner is before this court seeking for the following reliefs. A memo dated
Today,
19/12/24 has been filed signed by the petitioner and the counsel for the petitioner, which reads as under. Accepting the said memo, petition is dismissed as withdrawn. Pending IA stands disposed.
Serial,
Disposed.
serial number
13. 13.
1-3.
Pastor, some inconvenience in the afternoon.
Mr. Jagdish?
I'll inform him.
Registry is directed to print the name of Sri C. Jagdish as that appearing for the respondents and relist on 16 January.
Grateful.
13.
serial number 51, my lord, that burial ground was declared. 51, my lord,
51.
51.
Burial ground.
BD allotted site ಅಲ್ಲಿ now the DC wants to make it as a burial ground ಅಂತ ಇದೆ. ಅದೇ
ಅವ್ರಿಲ್ಲ ಇವಾಗ. ಆವಾಗ್ಲೇ ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ. Once he comes, we'll take.
Yes.
ಅದು ಇನ್ನೊಂದು ಪಾಸ್ ಓವರ್.
Past over matters. Number 1, serial number 8. Kiran BS.
ಪಾಸ್ ಓವರ್.
Serial number 11. XM Joseph and connected matter.
Please, my lord.
Yes.
Sorry, my lord, this morning I was not able to.
Now they are not here. Pass over.
51.
Yes, Mr. Chandra.
With your lordship's permission, I'm filing a list of dates and events and citations.
One more set. They have filed one set.
There are certain things which has not been mentioned in their list of dates and events, which I have covered in this.
Allah, these documents are not there in that set.
Documents are there, but in the list, it has not been mentioned.
We'll refer to only one set of documents.
No, documents is one set itself, but the list, it is only a list, my lord. These are citations.
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 Documents ಮತ್ತೆ ಕೊಟ್ಟು ಅದು ಇದು.
ಇಲ್ಲ ಇಲ್ಲ documents ಅಲ್ಲ documents ಅಲ್ಲ.
ಈಗಲೇ ಬಹಳ documents ಇದೆ. Documents volume.
Now, my lord, take your lordship to the list of date and events. My lord, there is a lot that has been said with respect to what has transpired. I would like to only take this to your lordship so that what has transpired can be clearly understood and how this whole thing has gone. Now, my lord.
ಒಂದು ನಿಮಿಷ. ಇದೇನಿದೆ ಕಂಪೇರ್. Convenience volume 1, volume 2 ಅಲ್ಲ? Yes, ಇನ್ನ ಒಂದು ವಾಲ್ಯೂಮ್ ಇದೆ. ಇದು ವಾಲ್ಯೂಮ್ 1, ಇದು ಯಾವ ವಾಲ್ಯೂಮ್? ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
Okay.
Yes.
Now, my lord, the bone of contention here is with respect to survey numbers 68 and 69 of Chikkasane village. Now, my lord, in the year 1918, the survey numbers were resurveyed and survey number 66 and 67 was renumbered as survey number 68 and 69 in the year 1918. Thereafter, my lord, they claim that a notification was issued under section 4 on 25/2/1919, which is the next year after the survey numbers were resurveyed. However, in the said notification, there is no mention of any survey numbers in the section 4 notification. It is only saying that certain extent of land. My lord, I would like to take your lordship to page number 72 of the paper book, my lord.
Yes.
72, the last one, my lord, there are other notifications. The last one is what they claim, my lord, that is 25th February 1919. Here your lordship may see that there is no survey number, only extent and name of the block. They say Bhuvanalli, they say Devanalli and Bhuvanalli. Again, there is no mention of Chikkasane specifically here. This is the section 4 notification as per the 1900 Forest Regulation Act. This is what they claim. However, there is nothing pertaining to either the survey numbers or which land it is, which village it is. They only say Devanalli and Bhuvanalli and they call it as Bhuvanalli block. Now, my lord, further they say, however, further they say on 18/1/19, my lord,
north, starting from the southwest corner of survey number 7 of Bandarmanalli village, the line runs southeast, northeast, and north along the south side of said survey number to the southwest corner.
Yes, my lord. They say this.
Village, then east along the south side of the said survey number, east, then south along the west side of survey number 69 and 68. Idella.
My lord, there is discrepancy even in these boundaries, what they mentioned, when you compare it with the section 17 notification as well as section 4 notification. I would show that, my lord. This is section 4 notification.
No, you cannot say the survey numbers are not there because survey numbers are mentioned.
No, that is on the boundaries, my lord.
Yes.
Which survey numbers encompass those boundaries is not mentioned.
That is clearly seen. That was the way that it was being depicted then.
Yes, my lord, but there are discrepancies even on that. I would show.
Show us the discrepancies in order to show that your land is not part of it.
Because, my lord,
not just mere discrepancies.
Yes, my lord.
This is a 100-year-old document.
I understand, my lord. But there is discrepancies on which I will show, my lord. This is the first aspect. Secondly, my lord, they claim that on 18/1/1921, a notification was issued under section 17. That is at page 67, my lord, of the same document.
Yes.
67, 68 is the relevant portion, my lord. Here again, my lord, if now we look at the boundaries, starting from the tri-junction bund of Palya, Bandramanalli and Chikkasane, the line runs. This is what they say, which is completely different when compared to
north.
Starting from southwest corner of survey number 7 of Bandramanalli, they say. Here they say tri-junction bund between Bandramanalli, Chikkasane village. There is discrepancies even here when we compare it with all the boundaries. And the very important thing to note here, my lord, the survey numbers which they claim, 66 and 67, as on that day, my lord, when the notification was there, even if considering that the notification is true, though I'm not admitting that, as on that day, survey number 66 and 67 were some other lands because the resurvey had happened in the year 1918 itself, much prior to even the preliminary notification under section 4. Thus, they did not, neither there is a clarification thereafter or in the 1921 notification, there is nothing of, or there is a clarification saying that this is what it is and this is what we have covered. There is nothing after that. This is the end of it. Now, my lord,
let us go to your first 1918 document. Where is that document?
That document is, my lord, at page 362, my lord.
Yes. What do you want, what is your submission on that? Was prepared showing that survey number 66 and 67 was renumbered.
Yes, my lord.
How do we say that? How do you get to know that it is renumbered?
My lord, I would like to take your lordship, my lord. This is a 1918 survey, my lord.
Yes.
This, my lord, are the two survey numbers, my lord, at this end corner.
Yes.
And those are 68 and 69. As on 1918, my lord, this is a 1918 resurvey. And there is no dispute on this, my lord. Even the respondents have admitted to this fact.
How do you say 66 and 67 were renumbered as 68 and 69 on the basis of this document?
Well, not on the basis of this document, my lord. There is one more document which I will take your lordship to. That is, my lord, at page number 267, my lord.
of 267 of the paper book, there is some difference. Oh, there is some difference here.
I'm sorry, my lord, there is some confusion with the page number. Exhibit D78, my lord. D78 is at page number 467, my lord. I'm sorry. My lord, this is a letter issued by the Office of the Superintendent of Land Records on 27/8/1979 to the Divisional Forest Officer, Bangalore Division. Now, my lord, here, the second column as per resurvey. First, they say survey number 67 as per Chikkasane village 67, 16 acres, 18 guntas, net 16 acres, 18 guntas. They say dry and they say assessed wasteland. And they continue the same with respect to survey number 67 and 14, measure informing the extent of these lands, and they say these are also assessed wasteland. Now, my lord, as per resurvey, next column, my lord, Chikkasane 66 became after resurvey 68, 67 became 69 after resurvey. This is what they say. And further, they continue to say these were assessed wastelands.
Forest antanu ಬರ್ದಿದ್ದಾರೆ.
My lord?
Forest.
Forest anta ಬರ್ದಿಲ್ಲ.
9 guntas forest.
My lord?
34 acre 9 gunta forest ಅಂತ ಬರ್ದಿದ್ದಾರಲ್ಲಪ್ಪ.
34 acre 9 gunta railway line passes through survey number.
There's forest also written there in handwriting.
That is with my lord, the last two lines may be read. My lord, old survey number 66 and 67 of Chikkasane village have not been shown as forest survey numbers even at the time of giving new survey numbers. This is what they clearly say. The last two lines, my lord. And they have classified these land as assessed waste continuously. They clearly say that these were not classified as forest lands even at the time of reassessment.
Not been shown is different.
Shown as forest lands. They were never shown as forest
lands. Not
lands.
been classified as different.
They have never shown it as forest lands. They were always classifying it as assessed waste. That is their submission.
What is assessed to waste?
These were government lands, my lord. That is what they have classified. And they have classified it as, it has been assessed wasteland.
So that's a government land.
That's a government land. That is what they have classified.
37.
Yes, my lord. Now, my lord, I would like to take your lordship. Then, my lord, in the year 1924, 22/10/1924, Government of Karnataka releases the suit schedule property, in the sense the property subject matter of this particular case, totally measuring 45 acres, 24 guntas in survey number 16, 69, and also, my lord, the other case measuring 16 acres, my lord, survey number 68. Exhibit D11, my lord, page 263 of the paper book.
45 acres, 24 guntas.
In survey number 69, my lord.
But survey number 69 from what you show as a D78 is 43 acres, 24 guntas.
My lord, that is after reclassification and there are certain lands that has been taken for the railway line, my lord. Certain lands that has been taken for the railway line.
So what was available after the reclassification was 43 acres.
My lord, this is a
24
stage as on 1979, my lord. This is 1924.
When the railway was not there.
Yes.
Yes.
My lord, page 263, my lord. Page 263 is the Hetwar register, my lord. My lord, in my compilation of extracts and memo citation, I have produced a typed copy of this, my lord.
Page number?
Page number 163, my lord, in that compilation.
Yes.
My lord, they write it from the right-hand side. The Hetwar register, that's how they maintain it. That is what I have been informed. 68, this is pertaining to survey number 69, my lord. They say 68 number nante. E number military ilake camping ground iddanu register madiruttade. This is the first endorsement. Then, my lord, the next column, E number na camping ground list ninda ವಜಾ ಮಾಡಿ ಸಾಗುವಳ್ಳಿ ಅಥವಾ ಇತರೆ ಜಾಗಕ್ಕೆ ವಿಲೆ ಮಾಡಬಹುದೆಂದು ಮೇರ ಕಸರವರು ನಂಬರ್ RDS 3332 ದಿನಾಂಕ 4432 ನಂಬರ್ ಹುಕುಂ ಅನುಸರಿಸಿ 41ರಿಂದ 122 ಸೋ ದಿನಾಂಕ 1352ನೇ ನಂಬರ್ ಬದಲಾಯಿಸಿರುತ್ತದೆ. Then further they come, my lord. ಇದರಲ್ಲಿ 2 ಎಕರೆ ಸಿಲ್ವರ್ ಜೂಬ್ಲಿ ತೋಪನ್ನು ಸರ್ವೆ ಮಾಡಿರುತ್ತೆ, ಪೂರಾ ಖರಾಬು ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. Then they further write 34, 35, 35, 36ನೇ ಸಾಲುಗಳ ಕಂದಾಯದ ಬಾಕಿಗೆ ಹರಾಜಾಗಿರುವ ಸೂಚನೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಸುಬ್ಬರಾಯ ಮುದಲಿಯಾರ್ ರವರ ಹೆಸರಿಗೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. The last, my lord, ಈ ನಂಬರ್ನ ಮಿಲಿಟರಿ ರೂಲ್ಸ್ ಪ್ರಕಾರ ಕೊಡಿಸಬೇಕೆಂದು ಶ್ರೀ IV ಮಾಣಿಕ್ಯರಾಜು ಇವರ ದರಖಾಸ್ತು ಕೊಟ್ಟಿದ್ದರ ಮೇಲೆ ಮಂಜೂರಾಗಿ ಸೋ ಅಂಡ್ ಸೋ 807-32-33 ನಂಬರ್ ದಿನಾಂಕ 17-11-32 ಹುಕುಂ ಮೇಲೆ ನಂಬರ್ ಹುಕುಂ ಮೇಲೆ ಈ ನಂಬರ್ ಆದೇಶದ ಮೇರೆಗೆ ಸಾಲಿಗೆ ಅಪ್ಪಣೆ ಮೇರೆಗೆ ಬಿಟ್ಟು ಕೊಟ್ಟಿರುತ್ತಾರೆ. So first what happens, it was granted to a ex-military official, Mr. Manikya Raju. Then he doesn't pay revenue for the years 34 and 1934, 35, 35, 36, and hence it was auctioned to Mr. Subbaraya Mudaliar by the government. This happens in the year it starts from the year 1924, my lord, where it is released for military camping ground, then for agricultural activities, then granted to one Mr. Manikya Raju, who is an ex-military official, who doesn't pay land revenue, and then it is auctioned to Subbaraya Mudaliar. All this transpires between 1924 to 1936, in the period of 12 years. After this grant, my lord, after this sale from the government, by way cultivates this land or keeps it dry, but however, he is in possession of this land and holds it till 1952. And in the year 1952, my lord, serial number 4, 5, 6, and 7 is what that I had explained now in my list of dates and events.
Yes.
And even 8, my lord. Now 8, I will say 1911-36, a sale certificate has been registered in favor of the said Subbaraya Mudaliar by the government, my lord, and that is available at page 223 of the paper book. 223 is a paper book, my lord. Lordship has it.
Yes.
Certificate of sale of immovable property. This is to certify that V. Subbaraya Mudaliar residing in Bangalore city, in the Bangalore district, having purchased at a public auction held by the Amildar of Devanalli Taluk, the undermentioned immovable property sold for arrears of revenue due by TV Manikya Raj, a landholder in the undermentioned village, and having paid the full amount of the purchase money, the said property has been this day registered in the name of the said TV Mudaliyar. And the details of the land, place Devanalli, village Chikkasane, the columns, my lord, first one. Then the nature of land dry, survey number 69, extent 43 acres 24 guntas, and conducted on the last column, my lord, date of sale, conducted on 39/1936, confirmed on 19/11/36. And this sale certificate has been registered. It's a registered document.
When was it registered?
My lord, this was registered on 19/11/1936, my lord, on the date of confirmation.
Where do we get that? Registration date?
I'm sorry, my lord, it is on 10/12/1936.
10/12?
10/12/1936. Oh, I'm so sorry, my lord. It's the first one, my lord, on the top. Number has been given and it has been mentioned as 8/3/1937.
Where is that date?
My lord, the top portion, my lord. Next page, my lord. Next page, the top portion. There is an endorsement.
Book 1 1039.
Book 1 1039, 3637, 8/3/1937.
Yes.
This has been registered on that day. And from then on, he is in continuous possession of these lands. And my lord, the first sale he conducts on 27/3/1952, my lord, which is in serial number 9 that I have explained, wherein he sells the complete extent of 43 acres 24 guntas in favor of 3 people, Ashwath Narayana, Uma Shankar, and Raghuveer, by way of a registered sale deed. This happens in 1952. Now, my lord, these documents are mentioned. These documents are not disputed. If your lordship wants me, I will take you to each of those documents. However, there is no dispute on these documents. These are registered documents, my lord.
All typed copies are not produced.
Typed copies of these documents are not produced, my lord. I would place it on record, my lord. Should not be a problem.
We'll have to go through them. So you'll.
Grateful, my lord. I will place it on record. Then, my lord, thereafter in 1964, those 3 people sold an extent of 10 acres to one Vanajamma. Then in 1965, again, the said Vanajamma sold the said 10 acres to another 3 people, Ayachittiras M. Karyappa, Muttanna, and Ganapati. Then in 1965, the same Ashwath Narayana and their family members sold it to the same group, Ayachittira Muttanna, an extent of 33 acres, 24 guntas, which was the remaining extent. Thereafter, my lord, these people sold these lands to the petitioners herein in 1977, 1908, 1977. 3 extents, my lord. One, the first one is sold to Muhammad Sanaullah, an extent of 8 acres, 35 guntas. Next, 3 extents of 10 acres each to Muhammad Khalilullah, Muhammad Amanullah, and to Muhammad Ataullah. That covers serial number 16, my lord. 10 acres each, totally 38 acres, 35 guntas is sold in the year 1977. Now, my lord, till then, no action has been taken either by the forest department, nor there is any claim, nor there is any action. Nothing has been taken. My lord, 1936 is a confirmation of sale. Sale deed register in the year 1937, sale certificate. Then till 52, he holds it. Then he sells it. Various transaction happens. Finally, the petitioners purchased this land in the year 1977, 1908, 1970. In the year 1979, my lord, the letter I refer to at page 467, wherein they write a letter to the Assistant Superintendent of Land Records to verify what kind of land is this. That's the first action that they take in respect of these survey numbers. The reply is clear. He says these are the lands, these are the extents available, and these are assessed wastelands, and survey number 66 and 67 were not shown as forest lands even at the time of resurvey. They don't take any action thereafter, my lord. Then what I do, there is an interference in the land. So I file a suit for injunction against the respondents herein in OS 600 of 1981. This I do in the year 1981. File a suit for injunction, restraining these people from interfering with my land. At the first instance, my suit gets rejected. Then, my lord, that rejection, they file the written statement. I will read that written statement, my lord, which is available at page 279 of the paper. Lord, I would like to take your lordship to paragraph 4. It is stated, it is denied that the cashew tree belongs to the plaintiff and that they are in survey number 69 of Chikkasane village. Further, they say defendants never prevented the plaintiffs from digging any well in the land as alleged by the plaintiff, alleged in the suit by the plaintiff. But the plaintiff was prevented from trespassing the government cashew nut plantation, which is in the government land in the forest department. They say, one, they are only concerned about the cashew trees. Two, they say they never prevented us from digging a well in our land. Three, they say that they were only prevented from entering into the cashew plantation. That is what they say. And further, my lord, the claim of the plaintiff for 2 acres in which the trees are is illegal. What is stated in the plaintiff is contrary to the written statement is hereby denied. This is a simple 7-paragraph written statement that they have filed, and their claim is that in 2 acres with respect to where the claim is the cashew trees is not proper, illegal is what they say. So the whole contention is there is some cashew plantation in 2 acres of land, and the plaintiff, that is the petitioners herein, his claim with respect to those 2 acres of land where cashew plantation has been made out is false and illegal, is the crux of this written statement. Now, my lord, on 13/12/1985, the suit was dismissed initially by the trial court. Then a file of regular appeal in RA 10 of 1986. And in that regular appeal, my suit is decreed. A permanent injunction has been granted, wherein my position with respect to these lands has been confirmed, and based on my position in these lands, especially, my lord, there the issue was only with respect to 8 acres 35 guntas belonging to Mr. Muhammad Sanaullah, because that is where the interference happened. So only he had filed a suit. The first instance, it was dismissed. He files an appeal. Appeal gets allowed. Suit gets decreed. A permanent injunction is granted. Against that, the respondents file RSA 673 of 96, challenging that. However, they withdraw that RSA, saying that they have filed a comprehensive suit and hence they would not to proceed further on the RSA. Now, my lord, these are incidents I am saying. And taking your lordship to each of these documents, I personally felt would eat up more time. The facts are not disputed by the respondents either, because it is their own appeal that they had filed, which they had withdrawn. Now, my lord, they file a suit thereafter in the year 1997, bearing OS number, this is, my lord, serial number 24 of my list of dates and events that I am reading, which was earlier numbered as OS 34 of 97, later renumbered as OS 1424 of 2007. Now, my lord, the petitioners herein filed their written statement in the suit denying that allegation that these are forest lands or whatever it is. And here an important thing happens, my lord. During the course of the proceedings before the trial court, a hadbast is ordered and a joint survey has been conducted, which is available at page 432, my lord, which is marked as Annexure D65 in the suit. page 432, my lord.
Yes.
This is the report that has been given after conducting Hadbast, my lord. Here we can see that even the forest department were present. In fact, my lord, I secured this document from the forest department itself thereafter. Okay, my lord, the report given to the government was Devanalli Talaku, Kasaba Hobli, Chikkasane Gramada, M.A. Muhammad Amanullah, M.A. Muhammad Sanawullah, Muhammad Khalilullah, ಮತ್ತು Muhammad Atawullah, son of so and so ಆದ ನಾವು ಸದರಿ ಅವರ ಸಮಕ್ಷಣ ಹೇಳಿ ಬರೆಸಿದ ಹೇಳಿಕೆ. ಇದೇ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಚಿಕ್ಕಸಾನೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 69/2-3-4-5. By now, my lord, the survey number would have been bifurcated because these four people have purchased independently. ಹದ್ದು ಬಸ್ತು ಹದ್ದು ಬಸ್ತಿಗೆ ಅರ್ಜಿ ಕೊಟ್ಟ ಮೇರೆಗೆ ಸರ್ವರು ನಮಗೆ ಮತ್ತು ಅರ್ಜಿಯಲ್ಲಿ ಕಾಣಿಸಿದ ಬಾಬ್ತುದಾರರಿಗೆ ಮುಂಚಿತವಾಗಿ ನೋಟಿಸ್ ಮೂಲಕ ತಿಳಿಸಿ ಈ ದಿವಸಗಳಂದು ಜಮೀನು ಬಳಿ ಹಾಜರಾಗಿ ಅರಣ್ಯ ಇಲಾಖೆಯ ವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿಗಳು ಮತ್ತು ಸಿಬ್ಬಂದಿ ಹಾಗೂ ಅರಣ್ಯ ಭೂಮಾಪಕರು ಸಮಕ್ಷಮ ಸರ್ವೆ ನಂಬರ್ 69/2-3-4-5 ಹದ್ದು ಬಸ್ತು ಜಂಟಿ ಅಳತೆಯಿಂದ ನಿಗದಿಪಡಿಸಿ ಸರ್ವೆ ನಂಬರ್ 69/2-3-4-5 ಗಡಿಗಳನ್ನು ತೋರಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಗಡಿ ಗುರುತುಗಳನ್ನು ನೋಡಿ ಕೊಂಡಿರುತ್ತೇವೆ ಎಂದು ಬರೆಸಿದ ಹೇಳಿಕೆ. Now, my lord, next is the Hadbast at page 433, my lord. Each sub numbers have been marked, and the last portion, my lord, column number, serial number 3 in this document, my lord, each document. Survey number 69/2 ಒತ್ತುವರಿ ಇರುವುದಿಲ್ಲ. This is the same with respect to each.
Forest department part of this?
Yes, my lord, that is what they have said in this.
Where is the signature? That is what you said in your table.
My lord, 1 second, my lord. Here, my lord, RFO ಅಂತ sign ಮಾಡಿದ್ದಾರೆ. The first document, my lord, at page 432.
FO is there.
Yes, my lord. Now, my lord, survey number 69/2 ಒತ್ತುವರಿ ಇರುವುದಿಲ್ಲ at page 433. Survey number 69/3 page 434 ಒತ್ತುವರಿ ಇರುವುದಿಲ್ಲ. Again, the same thing, my lord, with respect to survey number 69/4 and survey number 69/5 at till page 436, my lord.
Yes.
And this survey was conducted on 5/1/2009, my lord, during the course of the proceedings, which is available at page 438, my lord. Because we did not have these documents, we applied for copies of this under RTA to the forest department itself. And what has been asked and what has been given has been mentioned here at column 1. ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ವಿಭಾಗದ ಉಪಾರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳ ಸಮಕ್ಷಮ ದಿನಾಂಕ 5/1/2009 ನಡೆದ ಜಂಟಿ ಸರ್ವೆ ಬಗ್ಗೆ ದೇವನಹಳ್ಳಿ ವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿಗಳಿಂದ ಜಂಟಿ ಸರ್ವೆ ದೃಢೀಕೃತ ನಕಲು ಒದಗಿಸುವ ಬಗ್ಗೆ, and they gave us these documents from their custody. Now, my lord, after this survey was conducted, they did not further take any action. They kept quiet. Now, my lord, originally for the first time on 8/3/2012, the suit that they had filed was dismissed by the trial court. And they had initiated forest offense proceedings, as they have initiated here, my lord, which was challenged in criminal petition numbers 1852 to 1857. My lord, those orders in the criminal petition have been mentioned at page 454, my lord, of the paper book.
Yes.
Now, my lord, this order has been referred very largely to say that liberty was granted to them basically to conduct a resurvey and all those things, my lord. But the crux of this order, the observations made in this order has been missed. I would like to take your lordship to page 459 of this order, my lord. From para 2, in these petitions, petitioners have sought for quashing the proceedings in FOC number 7, 8, 9, 13 and 14 pending on the file of so-and-so. The allegation in the complaint is that petitioners have encroached upon the forest land and accordingly case was registered in FOC number so-and-so for the offences punishable under sections 2G, 24G, 24G, 73D of the Karnataka Forest Act and Rule 41 of the rules made thereunder and section 41(2) of the Karnataka Conservation of Forest Act and section 2 of the Central Forest Protection Act as against the registration of the cases that petitioners are before this court. Now it's very important. The facts which are not in dispute are that in the year 1936 itself, it appears that public auction conducted court proceedings for public auction conducted in, sorry, my lord, in court proceedings for non-payment of the revenue. In the court proceedings, once Subbaraya Mudaliar purchased the properties, thereafter these properties have, these petitioners each have purchased a portion of the properties in the year 1977. It is also not in dispute that the forest and state had filed a suit against one of the purchasers in verse so-and-so seeking declaration and the land in declaration that the land in possession of said properties, land encroached upon by the petitioners. It is also not in dispute the suit has been dismissed. If really forest department finds that there is any encroachment which the petitioners or this predecessor were in possession for more than half century, it is open to the forest department to conduct survey of the land in the presence of the occupier, owner, purchaser of the said property, and based on the survey, if they find there is any encroachment, they can proceed against the occupier in accordance with law. Further, considering that even before the purchase of the properties by the petitioner, the title deeds were in the name of the vendor. These petitioners have been in possession for over more than 50 years. As such, the complaint ought not to have been filed without proper verification. Hence, I find complaints filed by the forest authority are perverse and liable to be quashed. Now, my lord, one important thing I would like to take your lordship's note. The FOC numbers that were quashed and the FOC numbers that I have challenged in this petition are the same.
Are the same?
Yes.
FOC 7, 8,
FOC
9,
number
13.
7, 8, 9, 13 and 14. The one that I have challenged before your lordship is also the same FOC numbers. What has been quashed, they have reopened it without any reference to that. My lord, WP 392, my lord. The ones that I have questioned are at A1, page 22, my lord.
390. We'll come back.
Yes.
View of the court.
Yes, Mr. Sunge, yaudu? ಆಯ್ತು. ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ವಾ ನೆನ್ನೆ? ಅರ್ಜೆಂಟು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವ್ರು ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತಿನ್ನೇನಕ್ಕೆ? ಇಲ್ಲ ಹಂಗೆ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರ ಇಲ್ಲ ಕೇಳ್ಬಿಟ್ಟು ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರ? ಒಂದೇ ಸತಿ ಆಯ್ತು, ನಾಳೆ ತಗೊಳ್ಳಿ.
My lord, with the leave of the court, serial number 48.
48
was dismissed for non-prosecution.
ಯಾವುದು ಇವತ್ತಾ?
48, yes, my lord.
Yes.
None appears dismissed
for the petitioner. Yes. ನೀವು ಯಾರಿಗೆ?
For the petitioner.
Cyril Prasad.
Cyril. I had undertaken to argue the matter.
But you not paid the maintenance amount and did the
No question, not a question of maintenance. It's
civil
a transfer.
petition. Civil petition, how can it come before this court?
My lord, there are criminal cases and civil cases pending, which I want all before the Bangalore courts. Therefore, I can neither file a CP nor...
The counsel for the petitioner appears at 1:30 and submits that he would like to make a submission. Relist on, hence the aforesaid order dismissing the above petition for non-prosecution is recalled. Relist on 17th January.
My lord may have it a little earlier because He has been in hospital in.
10th January.
In fact, I moved the matter.
10
in
January.
10 January. Okay.
Madam,
ಇಲ್ಲೇ ಇರ್ಲಿ. ಅವ್ರದ್ದು ಕನ್ವಿಕ್ಷನ್ 302 ಈಗ ಏನ್ ಯಾರು
ನಾವು ನಮ್ಮಲ್ಲಿ ಯಾವುದೋ ಫೆಡರಲ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿಲ್ಲ ದೇವಿಂದ ಮತ್ತೆ ಹೈಕೋರ್ಟ್ಗೆ ಅಪ್ರೋಚ್ ಆಗ್ಲತ್ತಾರೆ ಎಲ್ಲರೂ 2023 ಅಲ್ಲಿ ಸುಸೈಡ್ ಐಟಮ್ಸ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಒಂದು FIR ಆಗಿದೆ, ಕಮಿಷನ್ ಬುಕ್ ಆಗಿದೆ, ಅದೆಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿ. ಬಟ್ ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ ಸ್ಪೆಷಲ್ ಇಷ್ಟೆಲ್ಲ ಚೆಕ್ ಮಾಡ್ಕೊಬೇಕು, ಇಷ್ಟೆಲ್ಲ ನಾವು ಇದೆಲ್ಲ ಇದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಅದ್ರಾಗ ಇಟ್ಬಿಟ್ಟು ನಮ್ಗೆ BC ಅಟೆಂಡ್ ಆಗಿ ಬರ್ತೀನಿ.
ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್, ಆಮೇಲೆ ಎರಡು ಬಂದು
ಏನ್ ಮಾಡ್ತೀರಿ ಸ್ವಾಮಿ? ಊಟ ಹೆಂಗಿದ್ದಾರೆ ನೋಡ್ರಿ. ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ನವ್ರಿಗೆ ಮಾದರಿ ಪಾಟೀಲ್ ಅವ್ರಿಗೆ ಅರಿವಿ ಹಿಂಗೆ SH ಮ್ಯಾಟ್ರ್ ಇಲ್ಲ. ಬೇರೆದಾದ್ರೆ ಆಂಟ್ರಿ ಆದ್ರೆ ಬೇಗ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
41 ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಸರ್. ವಿಡ್ರಾ
ಕಮಿಷನ್ ನೋಡ್ಬೇಕು. ಮಾದರಿ ಪಾಟೀಲ್ ಪ್ರಕಾರನೇ ಮಾಡ್ರಿ. ಆರಾಮ ನಡೆದ ಅನ್ಲೆಸ್ ಟ್ಯಾಕ್ಸ್ ಪೇಮೆಂಟ್ ಅದೇ ತರ ಫಾರ್ಮುಲೇಟ್ ಪ್ರಕಾರನೇ ಮಾಡೋದು. ಅಲ್ಲಿಂದ ಕಮಿಷನ್ ಯಾರೋ ಬರ್ತಾರೆ, ಕ್ಯಾಬಿನೆ ಜಾವ್ ಅಂತ ಸರ್ಕಾರದವ್ರು ನನ್ ಕಳಿಸ್ತಾರೆ.
ಫೋನ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಅಲ್ಲೇ ಇದ್ರು ಸ್ಕೂಲಲ್ಲಿ ಎತ್ತಲ್ಲ.
Lordship's kind permission, serial number 29, my lord, Vignesh Shetty is here. He says that he has no document to produce.
So you'll have to wait. You can't mention it now when
No,
it reaches.
Sorry.
Dharwad bench matters. Serial number 1, Arvind Kulkarni.
Lords, in this matter, I appear, Lords.
Yes, Mr. Upar.
Lords, last time Additional Advocate General appeared, Lords. Now, Lords, yesterday I got the information that, Lords, they need some another 3 weeks time, Lords. Committee has already been constituted and, Lords, the process is still going on.
Praveen Upar and AGA submit that the committee is deliberating on the matter, and given 3 weeks' time, the compliance affidavit would be filed. Relist on 30th January at 2:30 p.m.
Grateful, Lords.
Serial number 2,
Yes, Mr. Upar.
Lords, Additional Advocate General, Lords, from Bangalore, Lords, she has appeared.
Yes.
Pratima Honnapur, Lords. If there is no information, Lords, your Lordship, Lords, grant 2 weeks time, Lords. Meanwhile, Lords, I'll inform.
And AGA seeks for and is granted 3 weeks' time. Relist on 23rd January at 2:30 p.m.
Please, Your Lordship.
admission, serial number 3,
Lord, I
Jay Kumar.
bought the judgment.
Yav para?
Para, my lord, 22, my lord. That Madhuri Patil case was questioned before the Supreme Court. Lord, where they have questioned that, Supreme Court has stepped into the legislature and legislated the law. What the Supreme Court has said, my lord, the area is vacuum. Therefore, invoking Article 32 and 142 of the Constitution of India, since there is a vacuum, a fundamental right of the SC/STs cannot be deprived and the court can't be a mute spectator. Therefore, we have legislated law. That's what the Supreme Court has said. And another direction which was issued, my lord, ultimately against the order of the Caste Verification Committee.
What was the direction which was issued?
My lord,
Direction 1 to 15.
1 to 15. Kindly turn to, my lord, page number 344, my lord. 3 issues has been framed while considering in Dairam's case. In view of the reference order, the following questions arise for consideration.
Para 7 is
The
the
direction, 1 minute. Whether directions 1 to 15 of the Madhuri Patils are impermissible, being legislative in nature. That has been negated. Whether the direction 11 and 12 in Madhuri Patil exclude the jurisdiction of the civil court to entertain the suit challenging the decision of the scrutiny committee, violate section 9 of the Code of the Civil Procedure, that's also negated. Whether direction 13 in Madhuri Patil, barring intra-court appeal against the decision of the learned single judge in the writ petition, when such appeals are specifically provided for it, in a state enactment or letter patent is valid or proper. That they have said, my lord, appeal is maintainable because it's a fundamental right. Now, my lord, now we'll kindly turn to page number 26, my lord.
26 of?
Page number, para 22, my lord, I'm sorry.
Para 22.
Page 349.
Yes.
May I read, my lord?
All of them were held to be valid.
Held to be valid unless, my lord, the states are the concerned states formulate the law contrary to that. That has been reiterated again at para, my lord, 36. That vacuum may be filled. It is open to the state government to fill the vacuum if there is any lacuna in the directions issue.
Yes.
Now, my lord, the state has enacted a statute called, my lord, the Karnataka Shulka Shultra Weather Backward Classes Appointment Act, where my learned friend has canvassed the point that it does not include the central government. Another judgment of the division bench of this honorable court, which have placed it before my lords, in Uttar Kannada Jilla Mogair case.
Yes.
There, my lord, para 5 may be kindly seen, my lord, last para. Two castes were going by same spelling, phonetic spelling, Mogair. One is Dakshina Kannada and other is, I don't want to, my lord, harp upon that. In para 5 it says, it is well settled law that a certificate of a caste issued by the competent authority is always subjected to the scrutiny by the verification committee. Therefore, we find no wrong about the second part of the circular dated 4th November 2019. All that we have said is, my lord, in the light of the law laid down by Kumari Madhuri Patils, read with the Karnataka Shulka Tribe Act 1990 and the rules 1990, we will verify the caste certificate which has been obtained for any purpose. In the instant case, petitioner has obtained a caste certificate under this act, Rule 3 Act. My learned friend claims that it has been obtained much earlier to the act came into force. For that, my lord, my answer is Gitanjali's case. Even if the my lord, it has been obtained much earlier to the act came into force, committee alone has got jurisdiction. That's what the division bench of our High Court has held, following the judgment rendered in the Vishwanath police case. And the last occasion I have read it over, para 9. My submission is whether he has obtained the certificate under this act or otherwise, prior to the act. My lord, what the Supreme Court has laid down the parameter in order to, my lord, invalidate a person who has obtained a caste certificate. That has to be subject to the verification by the committee. If the deputy commissioner, my lord, as my learned friend has relayed that, what authority he has got? Whether he has got an anthropology expert to, my lord, to verify the caste status? Nothing. Therefore, the Supreme Court has given a direction that matter has to be constituted strictly in accordance with the 15 direction which has been issued. And, my lord, the district caste verification committee headed by 4 persons. One is the, my lord, the deputy commissioner, as my lords are aware. Another is the deputy secretary, Jilla Panchayat. Another person is the deputy director of social welfare and the concerned Tahsildar. Still, if the committee found, my lord, there is any flaw in this or a doubtful, they will refer to the matter to the director of civil rights enforcement. In empty number of cases, my lords have held that. In order to elicit the truth, matter has to be referred to the DCVs.
Illy distinction is between the state government and the central government.
Central government. Well, once the certificate is obtained by the state authority, under which provision he says that, no, you don't verify this. Whether he is not stopped from taking that contention.
He's not saying don't verify it. He's saying that the verification has to be done by the deputy commissioner in terms of the notification issued by the central government.
As on the last occasion I pointed out, central government has lost sight in reading the judgment of the Supreme Court in Kumari Madhuri Patils. If they have referred to, and they have said, well, you let the deputy commissioner verify this, means I can understand. There is no whisper that they have referred to. Under such circumstances, which will prevail? The judicial order passed by this court as well as the Supreme Court will prevail on the authorities. A body has to be examined. I often argue, my lord, in similar case in Mogera case, 2 spellings were going on. One is Mogair in Dakshina Kannada, which is notified as scheduled caste. Another Mogair in Uttara Kannada, which is a fisherman which comes under the synonymous of a besta. They claim don't verify. I placed the, my lord, proposition before the courts, including the Supreme Court, saying that 2 yellow metals are glittering. Both of them are claiming a gold status. We confused. We got subject to the verification before the, my lord, the goldsmith. Goldsmith has said one is gold and one is brass. Brass is shouting, give me a status of a gold. This is how the things is happen here. If it is verified, what's wrong in that?
By verification by whom is the question?
That's my lord.
Deputy commissioner or the DCVC?
That has to be by the DCVC, because in Dairam's case.
Verification, Mr. Vijay Kumar has no issue.
No.
It is only who will do the
Jurisdiction
verification.
point. Yes, my lord. Jurisdiction, when the competent authority in the light of the law laid down by the Supreme Court, a committee has been constituted. Whether the deputy commissioner alone can do that, he can't. My responsible submission is. because there is no reference of Kumari Madhuri Patil's case and also Dayaram's case. Often circulars issued by the Union of India, as my lords are aware, my lords have also come across with umpteen number of circulars.
Yes, Mr. Vijay.
Lord, with regard to section 617, my lord, what is the definition of government company I have secured? My lord? And also what is the railway, Indian Railways, my lord?
My lord, I'm sorry to intervene. My lord,
ಏನ್
kindly
ಹೇಳೋದಕ್ಕೂ ಮುಗಿಸ್ಬಿಡಿ ನೀವು, ಆಮೇಲೆ ಅವ್ರು ಕೇಳೋಣ.
ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ಒಂದೇ
ಹೇಳ್ಬಿಡಿ, ಎಲ್ಲ ಹೇಳ್ಬಿಡಿ.
The lordship may kindly turn to my lord, para 4 of the Geetanjali's case. The full bench of this honorable court has held that the
ಗೀತಾಂಜಲಿ
committee alone.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ sir. Last occasion I given a copy of that.
ಅಲ್ಲಿದೆಯಾ ನೋಡಿ. Yes.
Para 4, my lord. We shall now move on to the aspect of the other questions, namely whether it is legally correct and proper to accept the correctness of a genuineness of a caste certificate as per the conclusion arrived by the DCVC, or whether the caste certificate has been issued by a Tahsildar in accordance with the then prevailing law, whether it is only a Tahsildar to whom it can be reverted and whose opinion would be prevail. In this regard, we also have the advantage of the decision of the full bench rendered in so and so, unquestionable and relevant for the determination of the present controversy. A perusal of the said judgment makes it manifest clear that the full bench in Savita's case of this honorable court, my lord, DCVC conclusion, it refrains from going through quantum of whether the decision of the DCVC would prevail over that of its Tahsildar. Full bench has also taken a decision that the DCVC alone is competent.
But before the statute creating DCVC was promulgated.
Yes.
Yes.
After the statute only, my lord, the Savita's case, the full bench has held that the committee alone has got jurisdiction. Earlier, there was a confusion. Even in the judgment which my learned friend has relied, it says that the Tahsildar, once he has issued, he alone is competent. A conflict view was expressed by the division bench of this honorable court, where it has said, my lord, Act came into force in 1990, rules came into force in 1993. Therefore, any certificate obtained much earlier to the Act came into force, the committee has no jurisdiction. That has been answered in full bench in Savita's case. Thereafter, my lord, again the learned single judge referred to a larger bench. The division bench of Harai Court, relying on the judgment of Vishwanath Pillai, said, any certificate which is obtained much earlier to the Act came into force, committee alone has got jurisdiction. That's what in para 9 has held.
Yes.
That's all. But section 617 of the Companies Act, which has been referred to in section 2(3) of the 1990 Act, that defines government company.
Yes, really.
This, my lord, the government company means any company in which not less than 51% of the paid up capital is held by central government or state government or governments or partly by the central government. Lord, this companies, my lord, coming under section 617 are governed by the 1990 Act.
This Act, 1956 Act you are speaking.
No. Section 2(3), your lordship may kindly see, they specifically say the companies. Section 2(3).
Yes.
What it reads is the companies, what is a
government company within the meaning of section 617.
Yes, madam.
The Act, when did it come into force? Date, you know?
91.
91 alla date nenne kelidvalla.
Date was is not available in the book.
It's not been
ಅದೇ ನೋಡಿದ್ರಿ ಹೇಳ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ. Because we need two
Prove
dates. One
ಹೇಳ್ತೀವಿ
is
ಅಂತೀವಿ.
Madhuri Patil's judgment when it was pronounced and when this act came into force.
Act much
Madhuri
earlier to
Patil
that.
1993.
Subsequent amendment came to be made to this. In persons of the law laid down by the.
ಮೂರು ಡೇಟು ಬೇಕು.
ಹೌದು.
ಒಂದು ಡೇಟ್ ಇಸ್ Madhuri Patil, 2 is the act, 3 is the amendment.
Yes, my lord.
ಮೂರು ಡೇಟು ಬೇಕು.
Kumari Madhuri Patil's judgment, my lord, I will.
1990.
ಕೊಟ್ಟ ಸ್ವಾಮಿ. ಇದೆ ಅಲ್ರಿ ತೋರಿಸಿ.
Whereas
Has
the
been decided on
inter-alia, my lord, is a fully
1994.
owned central government company, my lord, that have produced.
ಆಯ್ತು.
Dates ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಡೇಟ್ಸ್ ಕೊಡಿ.
2/9/1994.
2/9/94 is
My lord, the Supreme Court judgment.
ಅಲ್ಲಿ ಆಕ್ಟ್
Act 90 ಅಲ್ಲಿ ಬಂತು.
2/9/94.
which
Act
came into
date
force
ಒಂದು
of
ಕೊಡಿ, ಆಮೇಲೆ
1991.
amendment date
Date ಇಲ್ಲ.
ಎರಡು ಡೇಟ್ ಕೊಡಿ. ಎಸ್ 617.
Then the amendment to the my lord of the committee is constituted.
ಹ್ಮ್.
This came into force.
On
My lord 4C.
ಡೇಟ್ ಏನು?
ಹೇಳ್ತೀನಿ.
ಇಲ್ಲೂ ಡೇಟ್ ಇಲ್ಲ ಅದು.
Four C was already
ಇಲ್ಲ.
there.
4C amendment ಇಲ್ಲ ಇತ್ತು.
Already there. 4C was not amended.
4C was not
4C was existing.
existed. 4D was amended.
Yes.
4D was amended.
That is 23 to 2004.
2004 ಅದು.
Some amendment, my lord, of the record. When this government sought, we proposed that this has to be amended.
ಇದು ಏನಿದೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಅದೇ ನೋಡಿ.
ಅದೇ.
ಪ್ರಪೋಸಲ್ ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ಡೇಟ್ಸ್ ಆರ್
ಇದರಲ್ಲಿ committee came into force, my lord, the caste verification committee, rule 4 may be kindly seen, my lord.
2/9/94, but this act is 1990.
11/11/1993. District caste verification
Karnataka
committee came
Act
to be
7 of 91 ಅಂತಿದೆ.
ಹೌದು. ಅಲ್ಲ ತಾವು rule 4 ನೋಡಿ.
Rule 4.
This came into force on 11/11/1993. That is caste verification committee. This you lordships will find an bottom of that. Rule 4 and
ಯಾವ್ದು
5.
ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಜಗದೀಶ್?
Rule 4, my
Rule
lord.
4, my lord.
ಹಾ.
Caste
92
verification
rules.
committee.
92.
Rule 4, sorry.
Yes.
Rule 4.
Rule 4. ಯಾವ ರೂಲು?
Karnataka SC, ST
tribe. ಅದರಲ್ಲೇ ಇದೆ sir.
and other backward classes.
Reservation of appointment rules.
Yes, yes.
Rules.
92 rules.
Yes.
Page number 27 ಅಲ್ಲಿ ಇದೆ.
ಅದು ಇದಕ್ಕೂ ಡಿಫರೆನ್ಸ್ ಇದೆ ಅದಕ್ಕೆ. ರೂಲ್ 4
Caste verification committee.
ಜಾತಿ ಪರಿಶೀಲನಾ ಸಮಿತಿ 1993.
11/11/1993.
11/11/93. Madhuri Patil was 2/9/94.
1994 ಏನಿದೆ.
2/9/94.
SLP decided on 2/9/1994.
So this rule,
Prior to.
the act was prior, the rule was also prior to
Prior.
Madhuri Patil.
That in consonance with my lord, similar to this.
That judgment was in relation to states where these kind of rules were not available.
And
Not as
subsequently,
regards
some
states.
amendment was also, my lord, incorporated in similar lines. Rule
ಅದ್ಯಾವ್ದು?
3A may be,
ಅದ್ಯಾವ್ದು?
Rule 3A may be kindly seen, my lord.
Rule?
Rule 3A.
ಜಾತಿ ಪ್ರಮಾಣ
2000.
ಅದು
8 to 2000.
ಇಲ್ಲ, 2000 ಅಲ್ಲಿ ಮಾಡಿದ್ದು.
The 8 to 2000.
ಇದಕ್ಕೆ
Not after.
ಇದು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಇಲ್ಲ.
After Madhuri Patil. 94. ಹೌದು.
7391. Rule 3A.
Rule 3A, issuance of the caste certificate.
That was
That came
amended
into force on 8/2/2000.
2000. That is
Rule
directive
7
one
also.
of Madhuri Patil.
Yes, my lord.
Hmm.
Rule 7 also. That was also, my lord, on 2000. 8/2/2000.
Siddhanta Pramana Patra. This is verification certificate.
Yes, my lord. Validity certificate.
Validity certificate, verified validity certificate 8/2/2000.
Earlier it was not there. Who has to be verified?
So 6 years after Madhuri Patil, this amendment has happened in the rules.
Please, my lord. That may not be the reason, my lord.
We'll take out the amendment, why the amendment has happened.
And also proviso to Rule 4 was inserted in that is also on 8/2/2000.
Objection reasons will check that. I mean. ಅಷ್ಟೇನಾ ನಿಮ್ದು?
ಅಷ್ಟೇ.
ಹೇಳಿ 617.
Section 617 of Companies Act, my lord, the Section 23 of 1990 Act, my lord, this has specifically stated as to which are the establishments in public sector means, which were to be included, my lord, brought under the purview of 1990 Act. Lord, it excludes the central government companies, my lord, Indian Railways being a company fully owned by the central government, my lord.
Your submission, categorical submission made is, this act will only apply to the state government, not to central government, and
Yes.
said it. But that doesn't appear to be correct, because
No, no.
6171.
That's what I'm excluding that, my lord, for the reason that companies which are owned by the central government or state government with more than 51% of the share, which are deemed to be public sector, they are included in this. Therefore, my lord, Geetanjali judgment is not applicable to my case.
So where is railways excluded from this?
The central government organization fully owned.
Central government organization is excluded in yav provision illa.
But it only specifically says that these are the establishment in public sector which are governed by this act. That is what the definition means. And this definition doesn't include the Indian Railways, which is a fully owned company.
Indian Railways was established under what?
Parliament Act, if I'm right.
Act.
Please, my lord.
That is what 5 will come under.
No, 5, kindly see, my lord. What it says is a statutory body or a corporation established by or under the state or central act, owned or controlled by the state government.
Yes.
Now, it should be owned or owned by the state government only. But this is owned by central government.
Yes.
Therefore, my lord, this act is not applicable to the case on hand.
Yes.
This is my first.
That is a distinction you want to draw.
Yes. And secondly, my lord, assuming that the act is made applicable, even then, my lord, they cannot proceed for 2 reasons. Firstly, my lord, it is a complaint made by a stranger. A complaint made by a stranger.
You're on a review petition, not you're not.
Lord, your lordship said, no, your lordship said that the matter has to be reheard.
Only that last portion.
Lord, the last portion is itself, I am telling, my lord. Last portion says that your lordship have directed that liberty is given to the district caste verification. Then the district caste verification committee cannot go into this for the reason that the complaint is by a stranger. Therefore, my lord, they cannot go into a complaint filed by a stranger as held by the division bench of this honorable court.
Yes.
Then secondly, my lord, the second contention what I am raising is, my lord, he has taken a caste certificate that he belongs to Kadakurba. Government Order 11/3/2002 includes Kadakurba where there is an exemption given to the persons who have obtained Kadakurba caste. 11/3/2002. That I have produced as annexure. Annexure C. In the writ petition, typed copy I have produced, page 25. Your lordship may kindly come to page 27.
Annexure C.
C. Typed copy I have
To the
produced.
RP na writ petition?
Writ petition.
Writ petition papers ideyana? Writ petition la RP ivagira ನೀವು writ petition don't argue.
Your lordship, Lord, your lordship said that your lordship will hear the matter. Lord,
Only-
this is a legal issue that has to be decided.
On DCVC, whether it's
Yes,
excluded or-
DCVC only I am bringing it to your lordship. Now, 11/3/2002 exempts a person. I'll just read out that paragraph, my lord. The appointments already made in respect of persons belonging to Parivara, Talwar, Maleru, Kuruba, Besta, Koli community who have obtained employment under ST quota as Nayaka, Maleru, Kadu Kuruba, Jain Kuruba, Gond, Rajagond, Kolidhar and Tokri Koli shall be treated as appointment under general merit category with effect from the date of this order, and they shall not be eligible for any promotion or any other benefit as ST in future. Lord, I belong to Kadu Kuruba caste, my lord. Now, my lord, the latest judgment with regard to the Honorable Supreme Court, my lord, has categorically held that I am entitled to that benefit.
Again, it runs contrary to the the larger bench decision.
ಅವ್ರು ಮುಗಿಸ್ಲಿ ಆಮೇಲೆ ನೀವ್ ಹೇಳಿ.
ಆಯ್ತು,
At the
ಆಯ್ತು,
moment.
I'm sorry.
Correct. 35 my lord, of the judgment of Supreme Court. This was rendered on August 28.
Yes.
Para 34 and 35 I'll read. Apparently thus the above official memorandum was issued in ignorance of the government of Karnataka circular dated 29/3/2003, which further extended the protection granted to the earlier government circular dated 11/3/2002 to the communities including Kotegar, so and so. This government circular seems to have been completely escaped the notice of the Ministry of Social Justice and Empowerment, Government of India, while issuing the official memorandum dated 8/7/2013. Clearly, thus, the official memorandum suffers from the vice of non-consideration of the vital document being the circular dated 29/3/2003 issued by the government of Karnataka. Hence, we have no hesitation in holding that the official memorandum 8/7/2013 cannot supersede the communication dated 17/8/2005 issued by the Ministry of Finance, and the same cannot be read to prejudice to the prejudice of the appellants. In the wake of the discussion made above, we conclude that the appellants are entitled to protection of their services by virtue of the government circular dated 29/3/2003 issued by the government of Karnataka as ratified by communication dated 17/8/2005 issued by the Ministry of Finance. The circular dated 29/3/2003 issued by the government of Karnataka specifically extends protection to various castes, including those which were excluded in the earlier government circular dated 11/3/2002. This subsequent circular covers the castes such as so and so. And thus ensuring that individuals of these castes holding scheduled caste certificate issued prior to the descheduling would be entitled to claim protection of their service, albeit as unreserved candidate for all future purpose. Additionally, the communication issued by the Ministry of Finance dated 17/8/2005 reinforces the protective umbrella to the concerned bank employees and also save them from department and criminal action. Therefore, my lord, by virtue of this judgment and the 11/3/2002, which I am entitled to the benefit, my lord, they cannot proceed with the inquiry insofar as the caste certificate is concerned.
Yes.
Please.
Heard. Shri Vijay Kumar, counsel for the
That
petition.
judgment, my lord, only one point I would like to. The judgment which my learned friend has relayed runs contrary to what the law has been laid down by the Supreme Court.
This is the latest
Larger
judgment.
bench,
We'll have
my
to go by the judgment, that's all.
ಅಲ್ಲ
We'll
ಸುಪ್ರೀಂ
go
ಕೋರ್ಟ್
through
ಇದೆ ಕೊಡ್ತೇನೆ ಸ್ವಾಮಿ ನಾವು ಇಲ್ಲಿ
ನಾ ಕೊಡ್ತೀನಿ ಯಾವಾಗ್ಲೂ
ಅಲ್ಲ ನೀವು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಾನು ಕೊಡ್ತೇನೆ
ಕೊಟ್ಬಿಡಿ ಏನೇನ್ ಕೊಡ್ತೀರೋ ಕೊಡಿ.
ಪ್ಲೀಸ್ ಮಿಲೋಡ್
Heard so and so.
Rule 7A enables Milord to prosecute. By in a circular, how can a Milord it runs contrary to the statute?
The Supreme Court judgment.
In order to who the vote bank, the ruling
Reserved
parties will pass
ಏನ್
order.
ಕೊಡ್ತೀರೋ ಕೊಡಿ.
ಕೊಡ್ತೇನೆ sir.
Kalburgi bench matters. Serial number 1, Chaitanya Kumar.
Chandriki.
It's appearing for the respondent number 5, my lord. Last date of hearing, your lord.
Yes.
Petitioner was directed to take out notice. My name is not deleted, my lord. To that effect, I am submitting.
There is a petitioner notice ತಗೊಂಡಿಲ್ಲ.
The process ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಬಂದಿದೆ.
None appears for the petitioner. Registry direct delete the name of Shri A.M. Nagral is that appearing for respond number 5.
Obliged.
2 weeks time is granted to the petitioner to make payment of process fee. If needful is done, registry is directed to issue notice to respond number 5, returned by March alone date.
March 19.
Obliged.
Serial number 2.
Hearing for the respondent, my lords, in this.
Yes.
The last occasion, my lords, I have filed the compliance report. The clarification which is to be made regarding the login is to be made by the authorities.
Yes.
Now the authorities want to change the software, my lords. It needs 4 weeks time for available for public domain.
That 4 weeks time would be required to make available the information for general public in the public domain. Relist on 30th January.
Serial number 3. Ravi B. Patil.
This compliance report is yet to be received. The same date.
When will you file it, madam?
The same date could be given, my lords. Since
DGP seeks for 4 weeks time relist on 30th January.
Serial number 4.
My lord, in this case, I pray for a 4 weeks time, my lord, due to certain, I could not communicate the order for further compliance due to my brother's marriage. It will be 4 weeks time, my lord, I'll further communicate and file further compliance.
For respond number 1236 for 4 weeks time, 30th January.
Please, my lord.
Further orders, serial number 5.
Further orders. Further orders.
Serial number 5. Last time, Mr. Shauri, UGC Council submitted that there is a similar question pending in a writ appeal. Well, that is posted today for pronouncement. Therefore, kindly have it after vacation.
What is this further orders? Why is it before us? Disposed matters. Why are they listed today before
Well,
us?
serial number 5, first matter is not disposed of. Other matters I do not know.
Kalburgi
Only
bench.
2 matters.
Kalburgi bench.
I am sorry. This is Kalburgi.
Kalburgi
list.
bench.
I am sorry. I am sorry.
In a case, further orders. Relist on 30th January.
Serial number 6.
Let's say appear for the petitioner.
So what is the correction?
Let's kindly see page 5, my lords. This is writ petition filed by me, my lords. The allotment in favor of a respondent 6 to 62 was called in question. Lords, identical, the allottees also filed a writ petition in page 18, my lords. They sought for direction against the APMC for the order and directions were interchanged, my lords.
Yes.
Please.
Two, 2328.
2328 is filed by me, my lords.
And 2388.
202388. Please.
1 of 24 has been filed, stating that the orders passed in the 2 connected matters have got interchanged. Under the order dated in WP 202328 is found reference in WP 202388 and vice versa. In that view of the matter, the registry is directed to correct the above and issue fresh orders. Issue fresh certified copies. IA 1 of 24 is allowed.
It's the filing of an appeal, my lords. Earlier, your lordship granted 30 days time, my lords. It may
The
be
time
from the
granted
date of receipt.
earlier is extended by a period of 30 days from today.
From the date of receipt of order.
From the date of receipt of copy of the order.
Yes,
Okay.
let's see. Your lordship may kindly direct the registry to return the documents, my lords.
Original documents produce ಮಾಡಿದ್ದೀರಾ?
Ah.
Original and certified copies of documents as produced by each of the parties is directed to be returned after complying with the due formalities.
Obliged.
Bill number 7.
Appearing, my lord, I am for petitioner, lordship. I file a for correction of judgment.
Yes.
In case number 7, lordship, in judgment, Roman 2, my lord, is my survey number mistake and name situated in Firozabad village. Instead, Raichur ಆಗಬೇಕು ಸ್ವಾಮಿ. ತೆಳಗಡೆ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ರೋಮನ್ 3 ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ರೋಮನ್ 2 ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ರಾಂಗ್ ಆಗಿದೆ ಸರ್. Survey number actually correct is 1209.
1/24 has been filed for correction of operative portion of Roman 2 of the order dated 24/9/2024. The reference to the property in Roman 2 is corrected to be survey number 1209.
Measuring
1 acres 11 guntas.
Yes, ma'am.
Situated at Raichur village,
Yes.
Taluka and district Raichur.
Please.
Registry is directed to issue a fresh certified copy.
Obliged.
1 of 24 is allowed.
Yes.
B group matters, serial number 8.
In this matter, my lord, in this matter, my lord, I appear for the petition respondent number 3 in 8.1 and petitioner in 8.3, my lords.
Lord, in the 8.2, my lord, the lordships have disposed of the matter to conduct a survey in the entire survey number in 8.2, my lord. That matter, my lord, I have filed an application for recall. Lord, in that matter, your lordships have ordered to conduct a survey of entire survey number 70. Lord, they have conducted survey. They have produced the compliance report. Lord, before this honorable court, it was placed by the honorable before this court, my lord, by SCGP, and one more copy was placed before in the office. Lord, we applied. They did serve the copy of my lord on us regarding the compliance. 8.2. Lord, one survey report what we applied from the certified copy that was in favor of us, and the second survey compliance report, my lord, which I have done survey, which was produced before this court, that was altered.
So there are 2 survey reports according.
2 survey reports, which has been given to this honorable court one, and there is one more copy which has been penned in the.
Where is that copy?
That has been in the, I have produced in the file, my lord, along with my IA.
IA 1 of 24.
Yes, my lord.
Yes.
Lord, in page 42 and 43, my lord, which has been produced before the ADLR, which has been given before the court, before the
IA number
1/24, my lord.
1 ಅಲ್ಲಿ 42 pages ಇಲ್ವಲ್ಲಪ್ಪ.
Which was filed on 27th August 2024, my lord, after the disposal of this petition.
7th August. 42.
43, my lord, relevant page. Now the subject matter, my lord, before this court is only with respect to 23 and 24 and 1B. 1B contains, my lord, 8 acres. This is a report, my lord, which is correctly given by the ADLR before the office, in the office. Lord, if lordship peruse which has been given before this court is in page 29, which has been obtained through certified copy. He has marked including 24, my lord, which is against the order passed in the 1995 for conversion. And while that is now the subject matter, my lord, 23 and 24. 24 has been included. There are 2 reports conducted by very same ADLR.
And where is this report at page 43 filed?
My lord, lordships can see that he has marked.
Really, where did you get this report at 43?
RTI, my lord. We have taken on the RTI before the office, in the ADLR office. They didn't serve the copy on us. So we have obtained under RTI, and even before this court, my lord, we have taken the true certified copy. 2 reports are there, my lord. And the SCGP also.
For the state,
May I make a submission?
madam? Yes.
I appear.
It is pointing out page number 29. That is with regard to direction, compliance of direction number 4.1. Whereas page number 42 is 4.1 and page 12 is 4.1. 43 is with regard to 4.3, my lords.
Marking is very important, my lord. Yes.
There were 4 directions given by this honorable court. In compliance.
4.1 is to survey extent of 17.
Entire extent
Sub-assess.
Indeed, my lord.
So what is it according to you? Which is the?
Page 12 is the same report.
Page 12.
Page 12. That is filed before the Honorable High Court. Page 24.
And kindly see even page 14 also, my lord.
Page 26, my lords. Page 26 is the same report. And page 29 is the same report.
The 1B is only to an extent of 8 acres. Now he has included 24 also.
Please see the top of the thing is right. It is shown as 4.1 at page 12.
Not 4.3.
4.2 is at page 13
Yes, my lords.
with the measurements. 4.3 is the
Page 14.
location of conversion.
That is
4.4
is Outer Ring Road.
acquired for the purpose of formation of the ring road.
Ring Road.
4.5 is in the presence of all the people.
Indeed.
All these are different.
The only
sketches.
problem is, here it is shaded, my lords. In page 14, it is shaded in orange color. That we don't get in a Xerox. This portion is been shaded in orange color before this Honorable High Court, which is at page 14.
Filed a compliance report, my lord. It is in color copy.
Now,
Compliance
when we take a Xerox copy,
Just a moment, just a moment.
On page 29, if that being the case, my lord, why they want to?
Just a moment.
Please, please, please.
Compliance report.
ಇದು out ಮಾಡಿದ್ದಾರೆ. ನಮಗೆ ಕೊಟ್ಟಿರೋದು.
Compliance report was filed in which matter?
Same matter. 201595.
1525.
1595.
95.
That is disposed of.
ಅದನ್ನೇ ನೋಡ್ತಾರೆ.
When was it filed?
Lordships, it was filed on.
On 9/7/2024, my lord. 9th July. Compliance report.
This was filed on 26 and the original, the colored illa illonu. We only have monochrome.
Oh, my lord, colored copy has been
Colored
placed,
copy has been.
but we have seen it and
Also
after
security
seeing only we have
Copy is
applied.
not here. We don't have a colored copy here.
They have sent it to email also, my lord.
These are all different sketches.
Please,
The contention that you are raising,
please, my lord,
that at page 42
please.
is different from page 28,
29.
29.
29.
Yes.
And Page 14.
29 is as regard the 60-meter ring road.
Please, I'm not
That
disputing.
is different and this is different.
Yes, my lord, he has marked in 29, he has marked only he has to show what is the extent of road. But he has shown including the 24 also.
ಎಲ್ಲಿದೆಯಪ್ಪ 29 ಅಲ್ಲಿ
Some marking.
meter
You can see the shaded marking.
that is not 28, that is page 20 29 28 ಅದು 4.1
My lord, 4.1, yes, my lord.
4.1
Yes, my lord.
ಇದು 29 ಅಲ್ಲಿ 4.4
No, I'm only 29, my lord, page 29, 4.1.
ನಿಮ್ ಪೇಜ್ ಇಲ್ಲಿ 28 ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು.
Oh, sorry, my lord, I apologize, my lord.
So you
This,
want
my
to
lord.
see 28.
Yes, my lord. The only contention is 23 and 24 are the disputed lands. Now they want to, they have given to us that without including 24. Before this court, they have included 24.
We have only monochrome. Madam, you need to give us the color sketches.
I'll verify and furnish the fresh one, the colored one.
Submission of learned counsel for respond number
Respondent of 5 and 6, my lord, in the 8.2.
5 and 6 in WP 201595 of 2023 is that in pursuance of the direction at 4.1 of the order dated 13 June 2023, there are two distinct sketches which have been prepared. In order to assess, one at page 28 of the application in IA 1 of 24 and the other at page 42.
Please.
To ascertain the veracity of the said submission, learned AGA is directed to place on record the original colored survey sketches.
Please.
Released on 23rd January.
Please, oblige, my lord.
It's number 2 for being spoken to, serial number 1. MVV Ramana.
Appearing for the petition in this matter, my lords.
I appear for
Yes,
the
Mr.
first
Ramana.
respond in this case, my lords. I've moved the memo. There is
You have moved.
one
Yes.
small correction, my lords. In para 4,
Para
learned
4.
counsel.
Yes.
Learned counsel for responding college has been mentioned, my lords. College never entered appearance. It was university's submission.
University. The matter has been moved for being spoken to. It is submitted that instead of the usage of the word university, word college has been used in line 1 of para 4 at page 4. Accepting the said submission, the same is corrected. The word college is directed to be substituted by the word university in this said line 1 and issue a fresh certified copy.
Order serial number 2. Rakesh Vibhat.
Lots, paid, my lord. Paid 40 lakhs, my lords.
ಇನ್ನೆಷ್ಟಿದೆ
50 lakhs ಇದೆ, my lord. 50 lakhs ಇದೆ ಅಂತ.
ಯಾವಾಗ?
My request is, my lord, on 6th it may be posted, my lord.
6th.
No, my lord. No. It may be posted on that day, direction may be given, my lord. 6th or 7th in it.
ಅಷ್ಟೊಳಗೆ ಪೇಮೆಂಟ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಅಷ್ಟರೊಳಗೆ ಅಂತಲ್ಲ. On that day, direction may be given, my lord.
At that day direction.
My lord, I have paid, my lord. 1 crore rupees has been paid, my lord, within.
ಅದಕ್ಕೆ ಟೈಮ್ ಕೊಡ್ತಾ ಇರೋದು ಬಟ್ ನೀವೇನು ಒಳ್ಳೆ
I will
ಸ್ಟೇಟ್
pay, my lord.
ಕ್ಯಾರೇಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಇದನ್ನು. Learned counsel for respondent confirms receipt of 40 lakhs. Learned counsel for the petitioner seeks for and is granted 2 weeks time to make his submission as to by when the balance amount would be paid. Released on 6th January.
Please. My lord, sir. On the last question also, my lordship was pleased to direct, file my wakalat, but the office has not.
Registry is direct print the name of she so and so submit that he has filed Vakaratnama
On
21st November 2020.
21/11/2024. Registry is directed to print his name as such.
Please, interim order may be.
Interim order earlier granted is extended till next date of hearing.
Serial number 3.
Respondent number one, is my lord. Counsel on record, my lord, met with a freak accident, he is injured his ribs, my lord.
Mr. Usman,
A couple of days back, my lord, a copy of the
did
X-ray,
he injure his ribs in an accident?
while getting down from his car, my lord, he slipped and his ribs hit a wall.
Submitted that the counsel for respondent number one has suffered from an accident and has been advised bed rest.
Yes.
Hence a request for how much ribs under how many weeks? 4
3
weeks?
weeks
6
is advised, my lord.
3 weeks.
Yes.
Hence a request for adjournment by 3 weeks is made. Relist on 16 January at 2:30 p.m.
Date January.
16 but at 23rd January. Let him recover.
Serial number 4. BL Sanjeev.
So Srinivas, none appears for the petitioner. Relist on 16 January.
Serial number 5.
Five. Yes, Mr. Shashikanta, you are saying something.
Lords,
Our question. Now that he is there, let him make his. Yes.
writ appeals filed by University Grants Commission, my lord, challenging the order of learned single judge, directing to UGC to do the exercise of considering whether, as on that 2013-14, whether the ex post facto recognition could be given or not. My lord. That direction is set aside. Now that UG, by virtue of that only in these writ petitions also, two things are challenged, my lord. One is the UGC's public notice, wherein it is said that from 2012-13 we have not recognized, 13-14 we have not recognized KSOU was the public notice. That is also challenged, and by virtue of our notice, KSOU has terminated the MOUs. So those institutions with whom MOUs are terminated are before lordship. In one batch of matters where that MOU had a clause for arbitration, direct liberty, reserving liberty to exercise that option, writ petitions were dismissed. But in these batch of remaining writ petitions where there is a prayer with respect to students, I mean, lordships have felt that, lordships have directed KSOU has also made available some list of students who have taken examination or who have admitted through them. For that reason, it is now pending. In the light of the judgment today, it is pronounced as open court, my lord. The learned single judge had made 3 directions. One direction was that KSOU shall issue them certificate because they have conducted. Because they were in-house students, no franchisee, and not in violation of territorial jurisdiction. So, and there is a government of Karnataka circular which said that we will recognize those students for our employment purposes. So those two will prevail over, but direction to UGC to now do an exercise and consider whether ex post facto approval could be given or not, that is now rejected.
Okay.
So that is the order. Today
What to
it is
do with
pronounced.
these students?
These students, if they fall under that category, my lord, if they are.
The judgment was pronounced today, na?
Yes, today.
Go through it.
My lords, if possible, kindly pass over the matter, my senior peer.
No need to pass over. We also have to see the order. Let them get the certified copy. Let us see the order.
Yes.
And what effect it would have on the students.
Please, my lords.
Learned counsel for the UGC submit that today a judgment has been passed by the division bench in writ appeal number 906 of 2022. He seeks for and is granted 2 weeks time to place on record a certified copy thereof, certified a printout, relist on 22nd January.
Serial number 6. JM Rajana Shetty, connected matters.
Pawan Kumar? None appears for respond number 3, relist on 16 January.
Serial number 7. Shrikant MP.
School matter, my lords,
Pen drive.
it's one development, my lords, my lords, which I have to, my lords, on the complaint filed by one of the parent, my lords, which also alleged some, my lords, commission of certain offences under Atrocities Act. It appears, my lord, the DYSP had an inquiry fixed today. And it seems it is now to be held by tomorrow or day after. Because of non-availability of the PSI. My lord, probably, my lord, the investigation may be into, my lord, all these issues because the complaint is exhaustive, which I have also filed before the Honorable Court. Probably, my lord, that may have some bearing, my lord, since far as the case is concerned. As such, my lord, lordships, one request, my lords, my lords, insofar as playing off, my lords, the pen drive is one part of it. The lords may have this matter, my lords, after vacation for further hearing, my lords, so that, my lord, the material which comes out from the investigation also can be, my lords, placed before the court. Because
They are not getting their salaries. That's the problem.
my lord, the salary is one, my lords, insofar as salary placed on record, my lord, judgments of division bench and dishonorable court, saying that whenever they are identified as excess by the department, it becomes the obligation of the department to pay the salary. Not necessary that, my lords, the management has to do anything. I have filed rejoinder, my lords, I placed on record the judgments also, saying that they are required to pay. In fact, my lord, the headmistress of the institution against whom, my lord, they make allegations, she has not, my lord, received salary. She is not, my lord, sent also.
Not bothered about it. Mr. is not. They are bothered about their salary.
That, my lord, that is the issue. Salary has to be paid, irrespective of whatever it is. But the intention, my lords, to go out of the institution is what we, my lords, are questioning. My lords, if genuinely, if there is a case, my lord, if a person is identified as excess, my lords, the state is bound to pay the salary. That's what the, my lord, the addition of division bench.
That's why vacate the interim order, my lord.
No, no, not
We will,
necessary.
Since there is an interim order that.
Interim order is posting them to some other place. It's not necessary. Whenever they are identified, it is becomes the duty of the manager department to pay. If lordships have,
Strength, my lord, we cannot.
that is irrespective of any such thing. It is the
That
duty
is
of.
What is the interim order granted in this matter?
My lord,
Temporarily working arrangement made to the teachers, my lord.
What is the interim order granted?
interim orders, my lords, was posting them to different institutions.
Post, my
When,
lord.
Yes.
when was it passed?
My
When
lords,
was the interim order passed?
that was immediately within 2-3 days of, my lords, the
Not.
TCs being taken away, my lords, it is done. If lordships have the copy, my lords, of. Or if the department is insisting, my lord, there is no difficulty to argue the matter, my lords, and if lordships have annexure P and Q, my lords, page number 92 and 95, my lords. 29/6/2024.
Annexure Q and R has been stayed.
Yes, my lord. Annexure Q, my lords, are dated 5/7/24.
Right, order dated 23/9.
Yes, my lords, 5/7/24 and 12/7/24.
What is Q and R?
My lords, posting them to different institutions. In amended.
You don't want them to be posted to different institutions.
My lords, I
And
want.
you don't want to pay them.
My lords, I'm not saying I'm not ready to pay.
No,
What
if you
I'm
want the
saying
interim
is.
order as regards their posting to be stayed, then you pay. Otherwise, we'll vacate this interim order.
My lord,
Then
that-
they will take their action.
My lord, that is what I am trying to say. My lords, if lordships have my rejoinder, my lords, the
Mr.
further,
Shrikant,
please.
now because of the stay of annexure Q and R, their services cannot be used anywhere.
Lords, I am ready to take them. I have students. That's what my lords I have said in my affidavit.
Now, just now you have submitted that if they are excess, then they will have to, government has to pay.
What I tried to say was, my lord, the stand of the department is because they had no workload and they were identified as excess and they could not be paid salary,
You have
we
so
shifted them to.
much problem against them. You make so many allegations against
Please.
them. But you still want them not to go anywhere.
Lords, let me put it this way, my lords. Ultimately, my lords, it is true that we have problems, my lords, with them.
Then
My lords,
either if you want to retain them, pay them.
no, that, my lords, if I put it. if we are given permission, my lords, to have a new, my lords, staff, absolutely no objection. Certainly, my lords, we don't want
That
them.
we'll consider later.
Certainly, my lords, we don't want them. My lord, that is the issue. My lords, that's the reason, my lords.
This interim order we will vacate.
No, my lords, I'll argue the matter, my lords. Now itself, lords may consider, my lords, on merits.
Order, please. Argue, please.
Please, my lords.
Yes.
Your lordships wanted to have a look at the, my
Now,
lords, pen drive.
no, we don't need to look at that.
My lords, because if lordships have my.
That's a
lords,
different issue altogether.
Please.
This is a different issue.
No,
So
no, no.
You can argue.
The issue what I raised in this petition was that, my lord, the institution which was being run, my lord, smoothly and, my lord, without any, my lord's problems.
For
Is,
the purpose of interim order,
my lords,
either you pay, we are on the vacating stay application. For vacating stay application, either you pay them or relieve them. You cannot say, I won't relieve them and I won't pay them.
my lords, I have sought for, my lord, stay of that. My lords, after hearing, my lord, the department, the interim order is granted. My lord,
Now also we are hearing you.
my lords, let
We have
me-
to given you the option. What do you want
My
to
lords,
do?
my lord, that's what I'm trying to say. If lordships, my lords have, my lords, one, my lords, may consider, my lords, before my lords, I bring to your lordship's notice the judgments of the, my lord, dishonorable court. The interim order was granted, my lords, after hearing, my lord, the other side.
Yes.
The respondents, my lord, private respondents, my lords, entered appearance after, my lord, they chose to, my lord, stand outside. After the interim order was granted, my lord, they, my lords came, my lords, by filing, my lord, wakalat. That's a fact. My lords, if they are, my lords, really aggrieved by any means, my lord, what the option which was available for the department was to challenge this because they claimed that they are aggrieved by the order. They should have, my lord, preferred an appeal before the division bench of the Honorable Court. That they have not done. My lord, the orders which have been passed, specifically that contention was raised, my lords, in the coordinate bench, was, my lords, without authority of law and without there being any provision, my lords, to their rescue. As if it is, my lords, a department-owned institution. My lord, the staff, my lords, are shifted to some other institution. The law says, my lord, it is not permissible. Section 98, my lords.
That is why we are saying you pay them.
Lords, that is what I'm saying, my lords. I need not, my lords, is what I'm trying to say. They have, my lords, they're required to, my lords, comply with certain requirements as required under the, my lord, the Education Act and the rules made thereunder. Without doing that, they cannot say that we can shift them elsewhere or else you pay the salary. That cannot be the situation. They cannot say that they cannot ask my lord, the management to pay the salary. If you lords kindly have, my lords, the further affidavit which I have filed.
Yes. On?
My lords, that is on 30th November 2024.
30th November.
ಹೌದು.
30th November.
Further affidavit is filed on 30th November.
My lords may have, my lords, page number 63, my lords, in that.
That's it. 30th November ಇದೆಯಲ್ಲಿ.
Further affidavit.
Garthi? ಇಲ್ಲಮ್ಮ 30th November ಏನೋ ಇದೆ.
Lord, they are dismiss the employees, my lord, firstly, without taking permission from the competent.
I'll answer,
authority.
madam. I'll answer each and everything.
Let him argue.
Please.
He is going to face the consequences of his argument. You are aware of it.
Or else, my lords, the other side. I mean, it
You
all
are aware
depends
of the consequences. You can argue. Yes.
Your lords may have a look at, my lords, page number 63.
Page number?
63, my lords.
The further affidavit. 30th.
63 is
Judgment. That's what I'm trying to say.
Yes.
Issue is considered, my lords, consistently by my lords, division bench of this honorable court in writ appeal, my lords, 1411 of 2012. That is, my lords, followed, my lords, by my lords, the learned single judges of this honorable court. The law, my lords, is well settled. Paragraph 1 itself, my lords, 1 and 2. And my lords, on that, there's a direction. Next document, my lords, at page number 65. Page number 73, para 9, my lords. Reference was made to, my lord, the division bench order. Then, my lords, page number 74, the order portion. Next, next also, my lords, page number 76. Para 4, my lords, the question which was considered. Lordships are having, my lords, page number 76.
Yes.
Page number 80, my lords, para 4. Whether present petitioners are entitled for salary on account of closure of school for want of strength and the failure on the part of the respondents in not giving suitable posting in some other private aided schools.
Yes.
My lord, the issue was considered. Para 7, my lords, decision of this honorable court, my lords, in another writ petition is extracted. And para 7, my lords, at page number 82, my lords, in that order, if I'm permitted, my lords. Though the petitioner had claimed 18% interest per annum on the arrears of salary, the same is exorbitant under the facts and circumstances of the case, particularly in view of the submission made at the bar by the learned government advocate. There cannot be any dispute that the management of school should try to get the salaries to its employees. According to the learned government advocate, there was a tussle between two secretaries of the management. Therefore, they did not make any efforts to get the salary of the petitioner released, and that therefore the government is not at fault. However, the court also cannot ignore the role of the state government in such matters. Since the school is admitted to aid, it is the duty of the state government to pay the salaries to the employees of such, irrespective of the dispute relating to the management. Be that as it may, having regard to the totality of the facts and circumstances of the case, and since the petitioners approaches this court at an earlier point of time, only in the year 2008, in my considered opinion, the interests of justice will be met if the petitioner is awarded 3 years of interest on the areas of so and so. Then, my lords, all the next paragraph, my lords, decision in writ appeal is also considered. Para 8, my lords.
Yes.
A similar view was taken with the division bench in writ appeal number 1411 of 2012. It would be useful for this court to call out paras number 4 and 5. The very fact that the petitioner was liable to be transferred from one institution to another on the prerogative and decision of the government makes it clear that it is the government obligation to pay the salary. This is exactly what transfers from 15/11/2005 up to 30/12/2008. And thereafter, when the petitioner reported for duty as per the instructions of the government to another institution, that is respondent number 7. Thankfully, the petitioner is receiving the salary with from 30/12/2008. So far as the petitioner is concerned, she should not be forced from pillar to post. If there has been any irregularity committed by any particular education institution, such as either respondent number 5 or respondent number 7, in this case, the matter has to be resolved by the government with reference to the institution concerned and not the teacher who has diligently discharged the duties. It is not denied that another teacher's name is so-and-so, who is identically placed, has been paid her salary. In fact, my lord, this matter was also argued by me, my lord. That's why, my lords, I'm making this submission. My lords, all these issues were considered.
And you know the facts in each of them are different from what you are doing.
My lords, in that case, my lords, what happened in that case, my lords, I would say.
You're going to be facing the consequence of these things.
My lords, I would show, my lord, the rules. My lords, I'm not, my lords, for a moment, your lordship may consider, my lords. I'm not against, my lord, them being identified as excess, being sent to some other institution. My lord, that cannot happen just like that. They have to follow, my lord, certain procedure. That's what I'm trying to say. My lord, without reference to the management, my lord, it just happens. My lord, it cannot be that. If I'm point, my lord, the enabling provision, my lords, is in the section 98 of the Karnataka Education Act. And there are rules also made as to how it should be done. My lord, the department, my lords, cannot treat, my lords, as these persons as their employees and place them, my lords, to any in any other institution as per as they want, without reference to the management. Lords, ultimately, this power can be exercised only after they are identified as excess and retrenched and then posted. That's what, my lords, Rule 10 and 11 specifically says. My lords, may have a look at, my lord, the relevant rules also as to how it should be exercised. My lords, I have the decisions also on the point as to how it should be done.
Yeah, rules.
My lords, the 19 and rules, my lords, which are applicable, which are applicable, my lords, so as far as the employees of primary and secondary aided institutions. That is, my lords, page number 1269, if I'm.
Recruitment in terms of.
Yes.
2013.
Yes.
Rule 13.
Rule 11 and 12.
11 and
Sorry, 10 and 11, I'm sorry.
Page 1275.
Yes.
10, my lords, deals with retrenchment of employees. My lords, how the 10(1)(a) itself, an employee of an institution may be retrenched by the governing council on the following grounds, where the teacher-pupil ratio falls below the standard staffing pattern specified in annexure so and so, as the case may be. My lord, that's what they say is the issue. If your lordships kindly come.
You have not done anything under 10.
No, not that I have not done.
This is for the governing council.
My lords, that is, let me, my lords, I'll read both, my lords, and my lord, demonstrate as to how it should be done.
Yes.
My lord, this has to be done, my lords, or can be exercised, my lords, in the manner as provided under the rules. The circumstances under which, my lord, this can be done, my lords, or rather the requirements, my lords, are my lord, stated in 10(1). If your lordships come to, my lord, 10(2). The procedure to be followed by the governing council for retrenchment of an employee in an institution shall be as follows. No employee of an institution whose appointment has been approved with aid by the department shall be retrenched by governing council except for the reasons specified in sub-rule 1 of section 98. When retrenchment is due to the employees becoming surplus, the junior-most employees so and so. My lords, this is about the governing council. 3, my lord, sub-rule 3. If the governing council does not send the proposal in accordance with clause E of sub-rule 2 of the competent authority, may give directions to the governing council to send proposals within a period of 1 month. Failing which, the salary grants in respect to the entire institution shall be withdrawn forthwith. Procedure to be followed by the competent authority under section 98(1). The competent authority may either suo motu, after personally ascertaining facts, or on the report of one of the subordinate officers, initiate action to retrench an employee by following as far as may be the procedure under Rule 10, and pass an order giving necessary directions to the governing council after having fully satisfied that the retrenchment is called for due to any one or more of the reasons specified in Rule 10 or Section 98. The competent authority shall cause a list of all eligible and qualified retrenched employees to be maintained at the state level. The list of teachers shall be prepared subject-wise and category-wise. The list shall be prepared on the basis of seniority, taking the date of approval of appointment with aid as the basis. The details of category of reservation roster of such employees shall also be recorded. The competent authority shall submit periodically, and every time an employee is retrenched, the details on. So, my lord, I'll come to my lord 10(6), which is, my lord, so is the specific provision. On receipt of the vacancy position, the government or competent authority shall, without prejudice to initiating action under sub-rule 1, allot through computerized counseling the retrenched employee on the basis of seniority, and after taking into consideration the subject requirement and reservation and roster point to any other institution where a regular sanctioned vacancy exists, and direct the concerned management to issue appointment order to such candidates and direct such candidates to report for duty in the said institution. My lord, this rule was also challenged, my lord, before this honorable court. In fact, my lord, in one of the cases, my lords, I was arguing that it can happen only with the what this court has ultimately said, has read down the provision. It said it can happen only with the consent of both the management. Ultimately, my lord, that is another aspect of it. Now, not this issue, whether the teachers can be posted to another institution, my lord, without there being any reference, my lords, to the management, Lord, has been repeatedly considered by this honorable court earlier. My lords, one such decision, my lords, if I'm permitted.
God. Yes.
Short order, my lords. This honorable court held, my lords, it is not possible without reference to the management. In the instant case, my lord, there are several such decisions, I can place it on record. In all the decisions, my lord, what is held, my lords, ultimately is that, my lord, the management, my lords, concerned has to be provided with an opportunity of, my lords, before taking any action. My lord, the department is free to take action, my lord, the private respondents are competent to challenge, my lord, there is no difficulty about it. Fact is, at least an opportunity of hearing should be afforded to the management. Specific allegations made by, my lords, the petitioner in this case is against both, my lord, the private respondents and as well as the DDP and BU. The specific allegation is, as soon as the institution gets grants, my lords, this we came to know only after, my lord, these issues happened. My lord, some of the teachers, my lords, are from outside. They, my lords, according to the instruction, they wanted to go back. But what the specific allegation we made is that, my lord, they join with, my lord, the DDP and the BO, particularly the BO. My lords, they go to each and every, my lords, every parent, ask them to take TCs, and even as my lords, that is admitted by the government advocate also, BO himself, my lords, issues transfer certificates in many cases. Lords, we have made a representation to the my lords, department saying that this is what is happening in the institution. Please do something about it. Nothing is, my lord, done insofar as our representation is concerned. My lord, they create, my lords, the report, my lords, with responsibility, I'm saying, insofar as, my lord, the availability of students. Now also, my lord, they have placed on record some document which is my lord, contrary to the SATs itself, saying that only one child, my lords, was there, because, my lord, that child is none other than the one who has filed complaint, my lords, criminal, my lords, complaint against them, my lords, alleging atrocities act. They left, my lord, they name only that child and say others were not there in the institution. My lord, consistently this is done, my lords, only to defeat the rights of the management. My lords, I can understand, my lords, if we are asked, probably we would have, my lords, given some explanation. If that was not feasible, not correct, otherwise, department, my lords, was free to take any action. They don't want to wait for that. BO himself, my lords, issues order, posting them to some other institution, which is, my lords, without authority also. My lords, my lords, if all the my lords, facts are considered in totality, my lord, what it discloses, my lords, is, my lords, with great responsibility, I'm saying, an effort to ensure that the school is closed. Nothing more than that, nothing beyond that. My lord, they wanted to go out of the institution. That's why all these things happen. My lords, I made a submission that, my lords, in the footage I have, my lords, there are, my lord, these respondents are seen with, my lord, those from different organizations. My lord, being there, present in the institution or in the, my lords, in the premises of the institution, within the compound, after the school hours. I mean, most of them are from, my lords, are outsiders. Only few of them, my lords, are the parents. However, my lords, others are only outsiders, my lords, who have come, my lords, who try to, my lords, enter in and, my lord, try to create some disturbance. We had to, my lord, in some cases, we had to issue transfer certificate. We had no other option, my lord, but we communicated this, my lords, to the department also. Department, my lords, again maintained silence on our representations. Nothing was done. But insofar as, my lord, posting them to different institution, that is done, my lords, without, my lords, even asking the management as to what the management wants to say. My lord, in these circumstances, what my submission is, that, my lords, my lord, there is no difficulty, my lords, in running the institution. It's not that, my lords, we want to harass them. I want to save my institution. What happens, my lords, if these, my lord, staff, they go out of the institution? Ultimately, my lords, have to close it, in spite or irrespective of the fact that whether the children, they want to come back or not. That is the problem we are facing. Now, my lords, none of them are not, my lords, have come back. Even when, my lords, I can understand the situation. They are, my lords, required to teach where they are required to go. My lord, they were sent to some other institution. They said they were there. The order was stayed. What was expected on their part was to come back. They make an allegation, my lords, and seek for vacation, saying that there are no students. My lord, irrespective of whatever it is, what was expected from a teacher, my lords, who has nothing against the management, he is to be there available in the institution. My lords, it is the effort of, my lords, ultimately it is the effort of the management. With the help of, my lords, the teachers, my lords, we can get back the children. My lord, children, they are ready to come. They are from the same village. My lords, Kannada medium school, surviving, my lords, in remote place. My lords, your lordships can understand what the pains we have, my lords, for having established the institution, my lord, what the institution is going through now. My lords, we have an English medium school in the same place, but we want to save a Kannada medium school also. Only for, my lords, the village, those who are from the village, they are, my lords, who are not in a position to afford, my lords, the English medium education or whatever. My lords, for them, we want to do something, my lords, and the department cannot say that you are required to pay the salary for the period, my lords, without discharging their obligation on the first part. My lord, that is what my grievance is, not otherwise. If they give the opportunity, my lords, will definitely, my lords, address what the issue is. They can, my lords, my lords, we are only concerned with DDP and BO, my lords. If any higher authority, my lords, is there, my lords, definitely he can, my lords, independently verify the, my lords, grievance and can come to a decision. My lords. This is what, my lords, we are trying to say.
Third, reserved for orders on IA 4 of 24.
Please.
Serial number 8. Mukhtar Kambi.
Yes, Onkar.
Here for the petitioners, my lord. This is the education matter pertaining to revaluation of the answer scripts pertaining to the postgraduate course in pathology, my lords.
Pathology. First year.
No, there is only one examination, the final examination. The candidate, my lord, she appeared for the examination held in the month of June 2024, and the results were announced in the month of July 24. The National Medical Commission has framed guidelines known as the postgraduate medical education regulations 2023. It is at page number 28, my lord. And in respect of valuation, clause 8.4p, my lord. Page 32, my.
Yes.
8.4 valuation B. All answer scripts. May I read, ma'am? All answer scripts shall be subjected for 2 valuations by the concerned university. Subjected to 2 valuations. The average of the total marks awarded by 2 valuators for the paper, which is rounded off to the nearest integer whole number, shall be considered for the computation of results. All answer scripts where the difference between 2 valuations is 15% and more of the total marks prescribed for the paper shall be subjected to 3rd valuation. The average of the best 2 total marks awarded by the 3 valuators for the paper rounded off to the nearest integer shall be considered for final. So when the candidate, the petitioner, appeared in the examination, this was the regulations of the National Medical Commission.
When were you enrolled?
2016.
I was enrolled in the 16. I had taken the examination in previous attempts. I was not successful.
This regulation came into force in 23.
29th of December 2023.
So you are a postgraduate student, 2 years.
3-year course.
Yes. 16 andre 19 al mugiyate.
Yes, it should have, my lord.
So what was the regulation in 16?
That time it was 4 plus 1. Basically 4 violation under 2000.
You are referring to a regulation of 23, which is subsequent.
Yes, my lord. My lords, one aspect is that, my lord, this honorable court has taken a view in a recent judgment stating that the regulations that would be applied would have to be the regulations which are applicable as on the date when the examination takes place, my lord. That is the principle laid down by this honorable court, my lord.
As regards which matter?
education for the regulations of the
For the undergraduate.
graduate course,
For the undergraduate.
graduate course.
Yes.
Yes, my lord.
But for
So
undergraduate.
that is because there were a different batch,
RS4 and there was a
and-
clarity in the guidelines. The guidelines clearly
different batch
stated.
altogether.
May I just pass on the judgment?
Yes. This was as regard the grace marks.
Grace marks.
Hmm.
Kindly see para number 27 at page 44, my lord.
Yes.
Admittedly, in the present case, the relief is as regards the award of grace marks for the examination in January 24. By such time, the regulations of 2023 and the UGMEB guidelines were already in force. If that were to be so, the question of awarding grace marks does not arise as provided under the guidelines.
Yes.
And the reasoning of this court, that
what is your contention here?
My lords, I was required to be subjected to two valuation, and in case of deviation or variation in the marks, it could have been referred to a third valuation. I have been subjected to 4 valuations, and in respect of, there are 4 papers, each for 100 marks. In respect of paper 1, the lowest marks awarded is 16 and the highest is 51. There is a 36 mark variation. Kindly take
Where's
page,
the table?
page 9 of the writ petition. I have abstracted it, my lord.
No, where's the marks tally?
I have enclosed the valuation slip annexure D, page 34.
34.
Page 34, my lords. Kindly see the bottom total. This is in respect of pathology 1, 27.5, 16, 50, 51, and 50.
But what was your regulation in 2016?
2016 regulations provided for full valuation.
For evaluation. Then reference to the 5th evaluator.
Yes, my lord.
The 5th evaluator has given you a mark.
Yes. My lords, I have taken the examination in 2024, and by which time the new regulations of the Medical Council of India had come into force, providing for valuation by 2 valuators.
Where is Mr. KT?
This is requested for a passover.
What happens once the course gets over?
Let's course, these are residuary mellots with respect to the present batch mellots for the academic year 2021, which is writing the exam in January 2025 onwards, the first batch. Mellots earlier, when they had to submit the thesis, there was no marks given on the thesis. Now, under the 2023 regulations, the thesis submitted by these 21 batch students who will be writing now, we are taking them mellots under this 2+1, because 20 marks, up to 20 marks, they have for thesis. Under the previous 2000 regulation, there were no such marks. And the curriculum also, my lords, previously, my learned friend is relying on the judgment of the grace marks, my lords. There, the UBME guidelines, my lords, and my lordship had seen in the previous case, the guidelines clearly stated that the guidelines are applicable for the students admitted from 2019 onwards. And the students therein were asking grace plus 40-60 criteria. They wanted mix of both. That is where the court told, this honorable court took a view that the examinations keep as and when it has come. So no grace marks because we have given you 40-60 criteria for passing, unlike 50%, 50-50. So, but here, my lords, earlier it was out of 700. Paper was out of 700. Now it is out of 800, my lords, total. And 20 marks is given to thesis. Here the girl, this petitioner has submitted her thesis in 2018 itself. 18-19.
But if you're holding the examination as per the new CBME guidelines,
My lords, again under the CBME.
then the regulation 2023 would have to apply.
Sir, residuary students, my lords. We are not giving marks on the thesis. Thesis then submitted, that has been evaluated, and they've seen it, accepted the thesis. Given
So
the
there won't be a
even
re-evaluation of the thesis.
Practical, please, my lords. Even for practicals, my lords, Practicals, earlier it used to be on a live demo on a patient, my lords, for practicals. But under this regulation, it's not on the live patient. They see the patient history, then they ask probe questions,
But this
multiple
is-
questions.
That's the practical exam. This is a theory exam.
This is
Practical theory consists of practical as well. Without practical, both theory and practical together will be declared pass.
Practical bere marks, theory bere alla.
Howdu, but together come.
Together we'll come to later.
Please.
The evaluation is being
My
made on
grievance-
theory.
My lordship, my lordship
So
sees.
you
this
if you are
again,
holding
so-
the examination as per CBME 2023, the PGMR regulation of 2023 would also be applicable.
This is for my submission is, my lords. One is, my lordship had seen page 31 for a moment.
31.
31, the regulation itself, there's a little gray area, my lords, here. It says.
So benefit has to go to the student.
No, my lords, 8.2.
Gray andre nimag baralla.
No, my lords, with respect to the regulation itself.
Black andre matra nimge.
Well, I'll just read, my lords. There shall be examiners external, 8.2, my lords. page number-
Yes.
It says the examiners both
Internal and external.
external for PG examination in broad and super specialty for so and so for PG. The minimum number of
That is of course.
examination shall be 4,
That has nothing to do with this.
shall be 4.
Yes.
Out of which at least 2 shall be internal, external, and at least one of them shall be from the different university outside the state.
Hmm.
Here it says 4 minutes. Again, for valuation, it says 2 minutes. Subjected to 2 valuations.
Why is there
Minutes.
copy paste is it?
ಏನು 4 ಅಂತ ಇಲ್ಲಿ
What
ಹೇಳ್ತಿದ್ದಾರೆ.
do you say 4 here and
This is
then
tenancies, my lord.
8.2 and in 8.4 you say 2 evaluations.
Please,
for the theory paper, my lord.
ಇಲ್ಲಿ valuation ಅಂತ ಇಲ್ಲಿ exam.
All answer scripts.
Well, let's valuation. They talk about valuation down. Here they say examiners. Examiners for practical or theory, that is not being told.
So this is relating to examiners.
Please.
Evaluation is on 8.4.
4. But again, examiners, well, the moment it shall be evaluated by 2 examiners, it says. But here it says we should
All answer scripts.
What is the relevant portion is 8.4B.
8.3, my lords,
8.3 cannot have a impact on the evaluation when there is a specific clause on valuation.
appointment for examiners, my lords.
You appoint another 100, you appoint, it's okay.
Here again.
Valuation, how it is to be done is 8.4. And this only says 2 evaluators, which is rounded off to the nearest integer. And 15% or more marks
Maximum
received
marks.
shall be subject to third evaluation. The average of the best 2 marks awarded by 3 evaluators shall be rounded off to the nearest integer.
But my lords, this is
My
my
lords,
lords, the request for Mr. Ketty has
This
requested
court
for a
has
pass.
held
Now, once you say CBME of 23 will be applicable,
My lords,
8
savings, my lords, the savings clause is there under the 2023 regulations, my lords.
second paper has a 38 mark difference.
My lords, if they.
So
if-
third paper has 26
that
and
are
the fourth
relevant-
paper has 29. They subjected to the fifth valuator. In respect of paper 1, the fifth valuator has given 50.5. Thereafter, they have averaged it with 27 marks, which is the least.
sir, you may not get that benefit. You will get only evaluator 1 and 2.
My lords, he make. one line-
Evaluator 1 and 2 is 27.5 and 16. Now it has to be referred to a third evaluator, then best of those 2.
No,
Even then you won't pass.
Why? It cannot be that the first and second examiner's valuation will be referred to the third valuator, man. The third and fourth as well could be.
Now you'll have to ignore this whole thing. It will be only the first 2 which will have to be taken.
Not to the detriment of the student, my lord, that.
You can't take the best of everything like that.
My lords, the fifth
If you want to-
valuator has given
If you
50.5,
want to
which
go
is,
by 8.4,
yes,
then only 2 evaluations.
yes, my lord. Which of the 2 evaluations, it can't be to the disadvantage of the
You
student.
can't take 5 at all. Yes, Mr. Ketty.
23, if it is applied, 23, 8.4 A is to be read with B, and A says all the teachers of the other colleges. That
Yes.
is not his college.
That doesn't matter.
That's
That is not the issue.
who
B is
able
the
to
issue.
perform there. So all answer scripts shall be subjected to the 2 valuations by the concerned university. So it has to be read with that. So it should be other.
If we are to, it's not the question of other or internal, that is not the issue. The issue is, B contemplates two evaluators,
Yes.
the average of them. And if there's a difference of 15% to a third evaluator, then the average
Yes.
is rounded out to the nearest integer. Now you've done 5.
We'll take the best of the two. but
Which 2 is the question now?
the-
First two, sir.
So
Why did you do 5?
Melats, we have done 5 Melats,
Why
university.
did you do 5?
Melats, because Melats, we, with all the students, as if now, with the student Melats, even in January, December, January also, there was an exam. We had first two.
From within the college.
No, no, everybody outside. I'm sorry, Melats.
You have to be clear on what they have to do, because they are following the old 19.
Melats, only for the
That
pre.
itself is an infirmity. They should have started following it from 1st of January 2024.
It came into
But-
effect from 29th of December 23.
This is
Melats,
June 24.
Examination was taken in June 20.
So January itself, it was,
They should have changed it.
whoa.
Melats, there was a meeting, Melats, wherein with respect to the curriculum and the thesis marks and the other criteria, looking at it, Melats.
Go beyond PGMR
That's,
rules.
No,
for
they are-
PGMR,
There are lots.
There is a small incongruity there. But the incongruity is this. In the old curriculum, the thesis did not have any marks. You had to just get a thesis approved and 700 marks was the total marks. Now, under the 23 scheme, the paper.
The 800
800.
marks.
So to reconcile between the two, it becomes a hybrid. I get examiners too, my papers are of 700, all that kind of a thing has emerged out of this. Had they notified it
But what
properly,
is your stand?
our stand is that from January 2024, for all examinations, the 2023 PGMER comes into force.
So if that is the case, then it will be
So
2
what should have
evaluators.
happened is, they should have actually brought in, even for the old batch, they should have brought in the 800 mark scheme with its breakup in that fashion, giving marks for the pieces, everything in accordance with that. So had they done that, the evaluation also would have been in sync.
No, they have not done it. What is to be
No.
done now?
Then I would only say that without going too much into the background of it, except that because it has come into this, it should be the best of the two papers. But the best of the two papers should be
To the
one
benefit of the
external-
student.
no, Melats,
one external, one internal.
one external, one internal, Melats, fine.
So which is external, internal in
Just
annexure D?
the other thing, the other limb which my learned friend is urging, let it go for one more round of valuation.
Melats,
Because the
already 5 are done.
Discrepancy being so deep, let it go for one more valuation. Man.
Now, if we send it for another evaluation, 8.4 cannot be implemented.
No, 8.4 can be applied still.
8.4
We would
can
make
be,
a submission, I will make a submission, my lord.
Melats,
Let it be sent in terms of 8.4.b for our, as per a statement recorded from us, and let it go for valuation, for revaluation and subjected to two evaluators. Not
so
from
which are the
concerned-
best 2 marks to be taken into
Melats,
account, Mr.
Not from the
KT? That
concerned
is what
college.
we are asking you from the
no, nobody is from the concerned college, Melats, here.
concerned college or outside college, that's irrelevant. Now, which are the best 2 marks to be taken here?
Melats,
The 3 marks,
Melats, one internal, one external also.
8.4, even if we refer to a third evaluator, the best of the 2 marks. So which, there's a 27.5, 16, 50, 51, 50.5. Please see page
And-
34.
the effect of this averaging is, if they apply 27, it drastically brings it down and I'm
You will not pass.
declared, I fall short by 2 marks.
27.5 and 16 is of no use to you.
Because of this anomaly, congruity, my suggestion to the court is, keeping in mind the nature of the evaluation, the vagaries of the evaluation, and it would be a good precedent also to see how it comes out for the purpose of assessing the issues of valuation. Let it go for one more round of valuation.
Melats,
That we are going to send, that's no doubt about it.
Then in that case, 8.4.b will stipulates from the, not from the, from that college, any other college, any 2 persons. Any
We
two
don't know
qualified
who has
persons.
valued the paper. The university has not put it
You
by
are
way of.
saying do the evaluation entirely again.
Do the evaluation by 2 evaluators in terms of 8.4.b who are not from the concerned college, which is good enough.
My lords, one submission, my lords.
I'm not sure who has done the
My
valuation.
lords, my lords, one submission, my
Yes.
lords, my lords. Already 5 valuations have been done, my lords, here. Here the valuation,
Madam,
what the one and
you are the one who has created.
no,
the
my lords,
problem.
one, I'll just
The
wait, I'll
objections
clarify,
are-
I'll clarify, my lords. With rest, the 1 and 2 are the internal examiners who are outside the college, within the university. Out, not from the same college, my lords, are not from the R3 college. And 3 and 4 are outside the universities. They may be outside, maybe from the deemed universities or outside the state. So, my lords,
they
what I
want
would
this thing
suggest,
to
my
not-
lords, is if they may take, my lordship may take external number 1 and internal number 1. And if there is a deviation, my lords, if there, for example, my lords, 27.5 becomes 28, 28 plus 50, there is a deviation, 28 plus 50, again, my lords, total it should be 200, again, 41 plus 52.
You have not implemented PGMER 2023.
My lords, if
and
it
that-
is
Your
taken
lordships had
maximum
also
two-
taken a view, my lords, that
2
the
valuations, my
regulations
lords,
of the
2
MCI
valuations,
would
my lords.
apply.
Thought.
My lords, one last.
And
submission.
the you,
One
may
last-
I only also point out,
Confusion ಮಾಡ್ತೀರಾ ನೀವು?
No, my lords, one
the
last submission.
objections are not on record.
Let me finish, Omkar.
So we'll give them time for objection now.
No, my lords had said if it is not filed, it should be
My lords,
taken.
one submission, my lords.
Yes,
Here, my
yes.
lords, examination, my lord, 4 exam, the issue here is they are asking for 2 valuation. In fact, even the pleadings, they are asking for the highest marks, my lords, here. If my lordship sees, if we go by 2 valuation as per their own this thing, my lords, by the PGMR, if you take 1 external, 1 internal, they are
There is
asking.
no classification of internal and external.
My lords,
In
internal,
8.4B,
my lords, it says any, either outside or within the outside the college, within the university or outside the university. It says, my lords. If my lordship may, if my lordship may take 1 external, 1 and 1 internal here, irrespective of what marks are given, because my lord, it will have a great repercussion. There are like thousands of students, again, they'll come back, my lords.
so item number 1,
1 and 3 may be taken.
1 is internal,
Please, 2 is internal.
2 is internal.
Please, 3 and
3
4 are
4
external. And
What about
again,
5?
5 is an internal or external, my lord, because
Don't
it's a
even-
1 minute, Omkar, please.
So we'll take 3 and 5.
My lords, it will be 3 and 5, my lords. For example, okay, my lords.
Take 3 and
I'll-
5, it
I'll-
passes.
I'll give that
I
example
cannot
as well, my lords.
objected to this.
My lords, if we take 3 and 5, okay, for what about others, my lords? For example, other students are there again, because if
Those
if the
are not
university,
before
let me finish, sir. If the university takes a call, my lords, after this, to avoid much litigation, okay, we'll uniformly apply to all the students who have appeared in June, then, my lords, we will not be able to, we will not be, either we should say no 1 and 2, we are only taking 3 and 5, or 3 and 4, 2 or 4, 2 or 5, everybody will come with permutation and combination where they will pass. That will be difficult. Rather, my lords, it would be easy. It's not for one student here, my
May-
lords. It's in the interest of, it will have a great repercussions. It
Kindly
has a
see the
cascading effect.
situation, my lord.
Omkar, 1 minute, let me finish. It will have a cascading effect, my lords,
It has only
throughout.
one effect.
Not
That
one.
is to
It
prevent
will have
exposure
multiple
of their
students, all the
their
people in June,
examination
even in
system.
January, students who have written.
That's what I'm hopping on.
My lords,
And this
even
will be one
January,
Step in that direction for the ninth.
they will,
matter, my lord.
my lords, January
That is
will
a
come,
far-reaching
June will
consequence.
come. Then
This
where
is
do we go,
something
my
which
lords?
is just
Because
a step
examinations
in
are coming. It's,
Considering the fact that the people
my
who are
lordship may
part
see,
of
my
the
lords.
Why are your internal examiners giving so less marks?
My
than
lords,
your
it's not,
external marks?
for example, next page, my lordship may see, my
The
lords.
case in point.
My lords, see, my lords, if each person has his own perspective while
My
giving
lords, the
answers.
5th valuator
My
has
lords,
given 50.5,
my lords,
aligns with the second.
Just 1 moment. Now, basically, this entire confusion has been created by you by not implementing PGMER.
My lords, we had in
2023.
fact sought an opinion, my lords.
What?
Who are you to seek for an opinion? When
Well, that's
you are given
because of the-
PGMER 23, you have to implement
My
it.
lords, there is a district residency program. Under the regulations, my lord, what it said was, with respect to district, no, my lords, under the regulation itself, it said that
Cuts.
PGMR district residency program will start for the academic year 21 onwards.
We'll have it tomorrow. We understand there's going to be a ramification and implementation is going to be.
Please, my lords,
But for this whole batch, you will have to do PGMER 2023
will,
so that everybody is brought on same footing,
please,
not only for them.
so
You
whose
have to do
valuation has to be
8.4
taken?
Again,
My lords, again,
for the mistake that you have committed, you will have.
my
to-
lords, what about the past students, my lords? Again, the past students also
lords,
will come, my lords.
That-
We're
that
saying
is-
that my marks are
Correct, that
less.
Submission is not correct for this reason, my lord. When an average of 4 is taken, which is the manner in which they have done as per the previous regulation, an average of 4 will always bring down the total average. So by bringing down the total average, if still people have passed and nobody has come to court except he, because he is aggrieved, which means that we only need to alleviate his problem, but alleviation of that problem we do not do. There are two limbs of his prayer. We do not do by virtue of this method, by this apprehension of the whole thing, but by a method where he is showing that such a wide discrepancy is there. We evaluate that once again. We evaluate that on the basis of two evaluators. He is prepared for the two
Consider the
evaluators.
thing tomorrow, make your submission on that.
Please.
Because you cannot be doing this mixed approach, which is creating problem for all the students.
I'll seek instruction, please, it will have a,
In one breath, you'll do 2019 and say 2019 we are right.
let's
Then
say
you'll
there was
come
a
and say, no,
clarity,
2023 is right. Sometimes you'll make a mix of both of them. You are nobody to do that. You just have to follow what they have said.
please.
2023 from 1st January 2024, 23, you'll have to follow that.
Please.
1st January 24,
20.
you'll have to follow that. In June 24, you are still following 19.
Yes, my lords.
You can't be doing that.
I will.
Grace marks ಕೊಡುವಾಗ ಇಲ್ಲ ಅಂತ ಬರ್ತೀರಾ. ಇಲ್ಲಿ ಬಂದಾಗ ಹಿಂಗ ಅಂತೀರಾ.
Standards of evaluation as prevailing on the date when the examination is held
Understand
is
the
the standard
university has to maintain its standards.
that is to be made up.
But you have to be student friendly also. You are, the impression that we are getting in all these matters, you are in adversarial litigation with the students.
No, it's not.
Bad, it's not a good
Correct. I will
thing
seek
to do.
instruction. We'll see what we can do, my lords, the best.
Tomorrow you let us know.
Please.
The request of the issue that has arisen in the present matter is that the petitioner, being a student admitted in the year 2016 for postgraduate medical, had taken up examination in June 2024 when PGMER 2019 had been applied. Though PGMER
2000.
2000 was applied, though PGMER 2023 had already come into force. Learned Counsel for the University seeks for a day's time to obtain instruction, make a submission. Relist tomorrow, 20th.
Great.
Serial number 9.
Report bandidya?
For petitioner, my lord, in this.
My lords, on the last occasion, my lordship was pleased to
No, as the report comes.
report.
They said C is the correct answer, madam.
No, as this is also, I have the objection. I have given the NAL
We
scientist.
can't go on with objecting. We referred it to a authority. They have come back with saying C is the correct answer. We
No,
can't go
see,
beyond that.
It's a, see, that college, what they have given the opinion, it's under Rugg University only. Ruggs University, same Rajiv Gandhi
Madam,
University.
we referred it with your consent. You should be
Yes,
bound
your
by it.
lordship.
You
Yes,
cannot
your-
now be finding faults with it.
No, no, yes, your lordship, but even though that is, it's not the, as per the textbook, I have given the reference, as per the textbook. It
We
is,
wouldn't have allowed them to find fault. We won't allow you to find fault. If it had come in your favor, we would not have heard them otherwise.
Then mine opinion is also is there, my lord, expert
Yes,
opinion.
petitioner is before this court seeking for the following reliefs.
And also one submission, my lord, as
Details
per
of the
their
petition.
ordinance, one submission, my lord. As per their ordinance in the dated 5/9/2022, my lord. They are telling the procedure for page number 3, para number 5. See, the marks awarded and the result so declared shall be the final. Under any circumstances, further evaluation shall not be entertained. I don't want further re-evaluation. What for the students? They won't have the re-evaluation, re-totaling or anything else. There is no provision in this. Is the bias? I don't want further evaluation. Same too, it will be re-evaluated.
My lords,
This is which batch are you?
this is RS4, my lords.
RS4 doesn't have revaluation.
No,
It's
madam.
only average of 2.
No, my lords, this best of two.
That's been upheld by this court. Petitioner is before this court seeking for the following. The grievance of the petitioner was that the answer given by the petitioner to question number 22, bracket Roman 3, as option D was a correct answer. And the said contention was based on an expert opinion received from CSIR, National Aerospace Laboratory 31. Learned counsel for the respondent university on the basis of input received from 3 other professors had indicated that the answer to annexure to the said question was option C. And that is what has been provided in the key answers. Since, however, an expert opinion had been produced along with the petition, this court had referred the matter to expert opinion of the department of the ENT department of the Bangalore Medical College. A report from the Bangalore Medical College from the said expert committee has been received. Dated 18/12/24 has been received. In terms of the said report, the committee members have opined that of all the 4 choices, option C is the correct answer. In that view of the matter, the opinion, the expert committee's report is required to be accepted by this court. This court having no expertise or knowledge of the questions and or the answers which are subject matter of the above petition. Since the expert committee has opined that the correct option, correct answer is option C, the petitioner having answered option D, the grounds made out in the above petition cannot be sustained. The petition therefore stands distressed.
Number 10. Vikram Muni Rajagopal.
On that issue of section 64, where the registrar had passed an order on the last occasion, I stopped only at this point. My lord, the issue was the 1/3 requirement had not been met. We saw that the number of general members are much more, and the 1/3 requirement was not met. But there was some intimation to the registrar, and therefore, my lord, the proposition canvas was that anyway on his own motion he can do so. I had only made that submission that on his own motion has been the subject matter of interpretation by this honorable court. In fact, my lord, I've come across a decision by your lordship also. That there is active application of mind and reasons to be set out is what comes out of it. Just 3 decisions.
Yes.
Lord, the first one is at ink page 2, that is the well-known Bangalore Grain Merchants Association. What was held, my lord, is that page 13, para 9, page 13, para 9, somewhere 12 lines from the bottom.
Yes.
The only requirement is that on the basis of such information, my lord, is that?
Yes.
The only requirement is that on the basis of such information and material gathered either on its own initiative or received from other sources, the concerned authority has to come to the conclusion on an active application of mind whether to take up the inquiry or not. Undoubtedly, the decision must be his own. He cannot mechanically act at the behest of some other person or authority without independent application of mind to arrive at a conclusion on the need and expediency of holding an inquiry. It is not argued before us, nor can it be disputed that the suo motu exercise of power does not cease to be such merely because a member of the public or someone in the know of things brings relevant facts to the notice of the prescribed authority, in this case, the registrar. The registrar, on a consideration of such facts, has to decide whether it is a fit case warranting initiation of inquiry in the overall interests of the society. The decision must be his, and the decision must, of course, be based on relevant factors, but there is no limitation as to the sources by which he should be prompted to take action.
Yes.
But at page 15, para 13, a submission was made that no, it actually he must act only on the 2 requirements of either 1/3 or on the general board's requirement. Well, that at para 14, page 16, The full bench said, no, that doesn't make sense. There is a fallacy underlying the argument advanced by the learned counsel for the petitioner. Neither the contextual interpretation nor any canon of construction could countenance the argument of the learned counsel. The argument of the learned counsel ignores the crucial fact that suo motu power conferred by the first limb of subsection can come into play independent of the power confided to the registrar in two specific situations. Well, on the next page at the top, 17, the top. The registrar is bound and obliged to initiate an inquiry if that 1/3 requirement is met. He has no option but to act and direct the inquiry. But if the number is less, the registrar can very well refrain from holding the inquiry, but if he feels that the inquiry is not warranted. His refrain may be on account of many factors, allegations being vague, or ex facie incredible, or contrary to the information on record, or the allegations being unrelated to the constitution, working, or financial constitution of the society. This is how the full bench understood the scope and extent of suo motu application of mind. This, my lord, this was followed by several benches, my lord. At page 24, a coordinate bench, and then my lord's decision. Page 24, a coordinate bench had occasion to consider this, my lord. At page 40, para 10. All these were in the context of section 25(1) of society, paramateria. Para 40, page 40, para 10, section 25 is extracted. Bangalore grain merchants is extracted, my lord, at the next paragraph. At page 49, the coordinate bench understands the full bench judgment as this. At page 49, para 14, that when active application of mind is mentioned, it requires a setting out of reasons. At page 49, my lord, para 14. After grain merchants is extracted, it is well settled law that Supreme Court in the case of S.N. Mukherjee so-and-so has held that decisions of this court referred to above indicate that with regard to the requirement to record reasons, the approach of this court is more in line with that of the American courts. An important consideration which has weighed with the court for holding that an administrative authority exercising quasi-judicial functions must record reasons for its decision is that such a decision is subject to the appellate jurisdiction of this court under Article 136 of the Constitution, etc. My lord. Para 15. It is trite law that even a quasi-judicial authority is required to assign reasons for passing the order. This is how, my lord, the coordinate bench said that reasons are at the heartbeat of every conclusion. My lord, at page 56, my lord had occasion to consider the same. Page 56, my lord, June 2023, your lordship's decision. At page 63, para 7, section 25 is taken note of. And my lord, the three circumstances are identified, namely suo motu, complained by majority of the governing body, or complained by not less than 1/3 of the general body. At para 9, a distinction is drawn between the three circumstances. Para 9, a perusal of the above section would indicate the registrar may on his own motion and shall on an application of the majority of the members of the governing body. Therefore, that distinction, your lordship, notices that where it is his own motion, he may or may not. But if it is on the application of the board or of the general members, 1/3, then he does not even have a choice. Para 14 is relevant one. Para 14, page 67, as regards first category, the registrar may on his own motion institute an inquiry. It is a mean and purport of on his own motion, which is up for consideration in the present matter. Merely because the third party were to submit a complaint, the registrar cannot initiate an inquiry without application of his mind, which are the facts in this case, my lord. If a complaint is received by the registrar, and if the registrar on perusal of the said complaint were to be of the opinion that inquiry is to be instituted, then he can order to do so. And when such an order is made by the registrar, it can only be said to be on his own motion, since there is an independent application of mind by the registrar. It is only in the event of the non-application of mind by the registrar and the registrar blindly following the complaint lodged by a third party that there is an embargo under subsection 1 to section 25 of the Act, and such an inquiry would not come within the purview of subsection 1 to section 25. But in the facts of that case, my lord, look at what had transpired. In the present case, as could be seen from the order of appointment of inquiry officer, on receipt of a complaint, the registrar issued 2 notices for a preliminary inquiry and to find out whether there is a prima facie truth in the allegations. It is upon receipt of the said report that the registrar applied his mind to the report and came to an independent conclusion that an inquiry is required to be held. Thus, the appointment of inquiry was upheld, my lord, in the facts of that case. Here, my lord, in the facts of this case, all that the registrar says is, I have received a complaint, therefore I am initiating inquiry. That too in the situation where an audit has been carried out.
Yes, Rakshit.
Also, seeing as in head up in our court, my lords. Here, my lords, in paragraph number 4, my lords, your lordship
That
has
is- that's
observed
not the point.
in the order, impugned order, my lords, page number 21. ಉಲ್ಲೇಖ ಒಂದು ಮತ್ತು
Oh, yeah.
page number 21 of the petition, my lords.
Yes.
ಉಲ್ಲೇಖ 1 ಮತ್ತು 3 ಪತ್ರಗಳ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ 2015-16ರಿಂದ 2023-24 ಸಾಲುಗಳಲ್ಲಿ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿ ಅನ್ವಯ ಸಂಘದಲ್ಲಿ ನಡೆದಿದೆ ಎನ್ನಲಾದ ಆರೋಪಗಳಾದ ಮೋಸ, ವಂಚನೆ, ದುರುಪಯೋಗದ ಗಂಭೀರ ಸ್ವರೂಪದ ನ್ಯೂನತೆಗಳು, ಅವ್ಯವಹಾರಗಳು ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಈ ಆರೋಪಗಳಿಗೆ ಜವಾಬ್ದಾರ ಯಾರು ಎಂಬ ಬಗ್ಗೆ ನಿಖರವಾದ ವರದಿಯನ್ನು ಪಡೆದುಕೊಳ್ಳುವ ಅವಶ್ಯಕತೆ ಇದ್ದು, ಕಾಯ್ದೆ ಕಲಂ 55 ಪರಿವೀಕ್ಷಣೆಯನ್ನು ಒಳಪಡಿಸುವ ಸೂಕ್ತವೆಂದು ನಿರ್ಧರಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. There is a very well application of mind also, my lords. Even the annexure B, my lords, the report submitted by the auditor, statutory audit, annexure B, my lords. Page number 23.
Yes.
The Karnataka ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 53 ಕಲಂ 63(1) ಅನ್ವಯ ತಮ್ಮ ಸಂಘದ 2023-24 ಸಾಲಿನ ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ಕುರಿತು ತಾವು ನನ್ನನ್ನು ಲೆಕ್ಕ ಪರಿಶೋಧಕರು ಎಂಬ
This is
ಉಲ್ಲೇಖ
63(1).
Please,
This is appointed by the registrar, not by the society.
please, my lords. My lords,
Yes,
it's by the society, my lords.
But
It's by the society. Ullekha 1. It's
ಸಂಘದ
return to
ನಿಯುಕ್ತಿ ಪತ್ರ ಸಂಖ್ಯೆ 179.
return to society, my lords.
Yes.
63 ಪ್ರಶಸ್ತವಾದ ಅಧಿಕಾರದಿಂದ ತಮ್ಮ ಸಂಘದ 23-24 ಸಾಲಿನ ಅಂತಿಮ ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ಪೂರೈಸಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 59 ಕಲಂ 63(8) ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರದಿಂದ ತಮ್ಮ ಸಂಘದ 23-24 ಸಾಲಿನ ಅಂತಿಮ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿಯನ್ನು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಲಗತ್ತಿಸಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಸರ್ಕಾರ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ 59 ಕಲಂ 63(10) ಅನ್ವಯ ಸದರಿ ಲೆಕ್ಕ ಪರಿಶೋಧನಾ ವರದಿಯನ್ನು ಮುಂಬರುವ ಸಂಘದ ವಾರ್ಷಿಕ ವರದಿಯನ್ನು ಮಹಾಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಿ ಅದರಲ್ಲಿರುವ ನ್ಯೂನತೆಗಳ ಬಗ್ಗೆ ಅನುಸರಣಾ ಕ್ರಮ ಕೈಗೊಂಡ ಕ್ರಮದ ಅನುಸರಣಾ ವರದಿಯನ್ನು ಸಂಘದ ವಾರ್ಷಿಕ ಮಹಾಸಭೆ ಜರುಗಿದ 30 ದಿನಗಳಿಗೆ ಒಳಗಾಗಿ ಸಹಕಾರ ಇಲಾಖೆಗೆ ಮತ್ತು ಸಹಕಾರ ಸಂಘಗಳ ಪರಿಶೋಧನಾ ಇಲಾಖೆಗೆ ಸಲ್ಲಿಸುವುದು. That is the report, my lords. Based on that, he has seen his report, my lords, and has taken a cognizance of this, my lords. Even the judgment produced by his line senior counsel, my lords, in the same full bench judgment, my lords, in the same paragraph, my lords, the paragraph number 9, your lordship, look at paragraph number 9, first judgment, full bench judgment, my lords.
Yes.
In that, now we come to the more crucial and controversial question, that is, what is the meaning and import of the expression on his own motion, and what is its interrelation to the immediately following clauses of the same subsection? There could be no doubt that the expression on his own motion is synonymous to suo motu, which according to the dictionary meaning, no one's one's own initiative. Own motion obviously implies application of mind and formation of one's own opinion. It does not matter how and from what source he gets information, but it does not mean that the authority conferred with such power should eschew from consideration, information, or
Really, what is your submission?
my lords, there is a application of mind by the.
Para 4 is the application of mind.
Please, my lords.
Is what you are saying.
That's what my submission is, my lords. And even the next 2 lines after that, my lords, no fetters can be placed on the specified authority from the standpoint of source material on which it should exercise the power. An authority exercising the suo motu power is not debarred from obtaining informations and materials from various sources. The only requirement is that on the basis of such informations and materials gathered either on its own initiative or received from other sources, the concerned authority has to come to the conclusion on an active application of mind, whether to take up the inquiry or not.
Basically, your submission is para 4 is the active application.
Please, my lords.
Heard. Dhananjay Joshi, learned senior counsel for the petitioner. Jaykumar S. Patil, learned senior counsel for the respondent, along with Sri Rakshit Kumar for respondent number 4, reserved.
Grateful. Interim order to be extended.
Interim order earlier granted is extended.
Lords, elections are being held on 29th, my lords.
29th.
Oh, the elections ಇದೆ.
ಆಗಲ್ಲ.
ಅದಕ್ಕೆ election.
Calendar has already started, nominations have come in.
It can be It can't be pronounced by then.
I understand, my lords, but if they file nominations, my lords,
It's already going on. That's an independent exercise.
there is.
Can't help it.
Grateful, my lord.
Thought.
Serial number 11. Kaveri Timaya and Connected Matter.
Waiting for the second response.
Wait for the petitioner in this case, my lord.
Yes.
This case, my lord,
ದುಡ್ಡು
I filed
ಕಟ್ಟಲ್ಲ ಅಂದ್ರೆ
wakalat 2 days back. 17/12 I filed a wakalat.
ಏನಮ್ಮ?
17th ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ
ಯಾರಿಗೆ?
ಯುನಿವರ್ಸಿಟಿ ವಕಾಲತ್ ದ ಪಿಟಿಷನರ್ಗೆ
ಹಾ.
ದ ಕೇಸ್ ನಂಬರ್ 31599.
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡೋದಾದ್ರೆ ಮಾತ್ರ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಇಲ್ಲಾಂದ್ರೆ ವಜಾ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ ಅವ್ರ
ಇದ್ರಲ್ಲಿ
NOC ವಕಾಲತ್ ಹಾಕ್ಯಾರಿ.
ಹೆಂಗು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ವಲ್ಲ?
yes.
ಅಂದ್ರೆ ಇರೋದ್ರಿಂದ ನಾವು ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸ್ವಾಮಿ. ಪಿಟಿಷನ್ ಇದೆ ಅಂತ ಹೇಳಿ ಇದ್ ಮಾಡ್ತಾರೆ. ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ. ಆಕ್ಷನ್
So to
ಚಾಲೆಂಜ್
submit
ಮಾಡಿ.
that she has
Lord,
filed
either-
wakalatnama for petitioner. Registry the printer name as such and delete the name of Ms. Kaveri Timaya as that appearing for the petitioner. 11.1 ಅಲ್ಲಿ
ಅದ್ರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ.
ಏನಿದೆ
ಅದಕ್ಕೋಸ್ಕರ-
interim order?
ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಬರೀ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಸ್ವಾಮಿ. ಇವಾಗ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆ ಕೊಡ್ತಾ ಇದೀನಿ. ಇನ್ಫ್ರಕ್ಷನ್ಸ್ ಆಗತ್ತೆ ಎರಡು ಪಿಟಿಷನ್ಸ್. ಯಾಕಂದ್ರೆ ಆಕ್ಷನ್ ಆಗಿಲ್ಲ, ಮತ್ತೆ ನಾವು ಫರ್ದರ್ ನೋಟಿಸ್ ಕೊಟ್ಟೆ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಇವಾಗ ಎಷ್ಟು ದುಡ್ಡು ಬರತ್ ನೋಡೋಣ.
Lord,
ಒಳ್ಳೆ
ವಿ ಆರ್ ರೆಡಿ ಟು
ಕೊಡ್ತಾ ಇಲ್ಲ.
ಮೈ ಲಾರ್ಡ್.
ಎಷ್ಟು
ಇದ್ರಲ್ಲಿ
amount?
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ವಿ ಆರ್
4
ರೆಡಿ ಟು
ಕೋಟಿ
ಸೇವ್
79 ಲಕ್ಷ ಸ್ವಾಮಿ.
ಅಂತಂದ್ರೆ ಆ ಪ್ರಾಪರ್ಟಿನ ಹರಾಜಿಗೆ ಹಾಕೊಳ್ತಾರೆ ಸ್ವಾಮಿ.
14 crore 79 lakhs my lord.
ಮೈ ಲಾರ್ಡ್ ನಿಯರ್ ಬೈ 39 crores ನ ಆಲ್ರೆಡಿ ಹರಾಜಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ವಿ ಆರ್
Yeah.
ನಾಟ್
ತಗೊಂಡಿದಾರ? ಹರಾಜ್ ಆಯ್ತಾ?
ಹರಾಜಲ್ಲಿ
ಸ್ವಾಮಿ.
ಆಗಿದೆ ಸ್ವಾಮಿ. ಹರಾಜ್
ಹರಾಜ್ ಆಯ್ತಾ?
ಆಗಿದೆ. ಎಸ್
ಅಂದ್ರೆ ಇದೆಲ್ಲ ಸ್ವಾಮಿ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಮೋರ್
property
ದೆನ್
ಮೇಲೆ.
15 crores ಮೇಲೆ ಪ್ರಾಪರ್ಟಿ
ಎಷ್ಟು
ರಿಕವರಿ.
amount ಎಷ್ಟು ಡ್ಯೂ ಇದೆ?
ಇವಾಗ ಅಟ್ ಪ್ರೆಸೆಂಟ್ 14 crores 79 lakhs ಮೇಲೆ.
ಬೇಸಿಕ್ ನಾನ್ ತಗೊಂಡಿರ್ತಕ್ಕಂಥದ್ದೇ 14 crores ಮೇಲೆ. ಅದ್ರಲ್ಲಿ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿ 40 lakhs ಅಂತ
today-
ಹೇಳ್ತಿದ್ದಾರೆ. ನಾಟ್ ಬಿನ್ ಗಿವನ್ ಅ ಸಿಂಗಲ್ ಡಾಕ್ಯುಮೆಂಟ್. ಹೌ ಮೆನಿ ಪ್ರಾಪರ್ಟೀಸ್
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ ಬೇಕು?
ಎಸ್ ಮೇಲಾಡ್ ಯಾವ್ಯಾವ ಪ್ರಾಪರ್ಟೀಸ್
ಕೊಡಿ,
ಅವರೇ
statement
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಯಾರ ಸ್ವಾಮಿ.
ಅಂತ
ಇದೆಯಾ?
ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಯಾರ ಅನೆಕ್ಷರ್
ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ ನಾನು. ಆದ್ರೆ
F to J ಇದೆ ಸ್ವಾಮಿ. ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಯಾರೆ. ಅದ್ರಲ್ಲೆಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ. ಇವಾಗ ಎಷ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ ಅನ್ನೋದು ನಾವು ಹೇಳಿದೀವಿ ಅದರಲ್ಲಿ.
ಮಲಾಡ್ ಎಷ್ಟು
4 account ಅಲ್ಲಿ ಒಂದು account
ಇದೆ ಮಲಾಡ್. ಮೈ ಹಸ್ಬೆಂಡ್ ನಾಗರಾಜ್ ವಾಸ್ ಪ್ಲೆಡ್ಜ್ಡ್ ದ ಪ್ರಾಪರ್ಟಿ ಮಲಾಡ್. ಹೌ ಮೆನಿ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಪ್ಲೆಡ್ಜ್ಡ್ ಇನ್ DCC ಬ್ಯಾಂಕ್ ಅಂತ ಇವಾಗವರೆಗೂ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಸೆಟಲ್ ದ ಮ್ಯಾಟರ್ ಮಲಾಡ್. ಆದ್ರೆ ಯಾವ ಪ್ರಾಪರ್ಟಿ ನಾನು ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಮಾಡಿದೀನೋ ಆ ಪ್ರಾಪರ್ಟಿನ ಅವರು ಹರಾಜ್ಗೆ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡ್ತಾರೆ. ದೆನ್ ದ ಸೇಲ್ ವಿಸ್ ಫ್ರೀಸ್ ಆಗೋಗುತ್ತೆ ಸ್ವಾಮಿ. ಸೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ನನಗೆ. ಅವ್ರದ್ದು ಅಮೌಂಟ್ ನ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ
Your
ಆಗ್ತಿಲ್ಲ.
husband had taken the loan.
ಎಸ್ ಮಲಾಡ್.
And is no more now.
ಎಸ್ ಮಲಾಡ್.
ಹೇಳಿ ಯಾವ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಲಿಸ್ಟ್ ಕೊಡಿ.
ಲಿಸ್ಟ್ ತರ್ಸ್ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಅಟ್ಯಾಚ್ ಆಗಿರೋದನ್ನೇ ಸೇಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಲಿಸ್ಟ್?
ನಾವು ನಾಳೆಗೆ ಇಟ್ಕೊಂಡ್ರೆ ಬೇಕಾದ್ರೆ ನಾನು ಆದಷ್ಟು ಮೇಲಲ್ಲಿ ತರ್ಸ್ಕೊಂಡು ಇದ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಆಗಿದೆ?
Submit that the petitioner is very much interested in settling the dues
lord.
of the respondent bank. Where the petitioner is unable to do so, since the petitioner has no details as regard the properties which had been mortgaged by her late husband,
Yes,
who
ma'am.
had in fact taken the loan, who had in fact availed the loan. Learned counsel for respondent bank
My lord, submission.
directed to furnish the statement of accounts as on date to the petitioner along with the list of all
Kindly have
properties-
opening day, my lord, 6 or 7 my lord.
list of all properties which are claimed to have been mortgaged by the late husband of the petitioner in favor of the respondent bank.
Please,
Relist on 7th January.
please.
Much
Please.
Interim order earlier granted is extended till next date.
Much-
Shri 11.1 ಅಲ್ಲಿ Shri Rajendra MA has entered appearance. Memo of retirement filed by Shri SV Prakash is accepted. He is discharged from the matter. Registry is direct delete his name. Yes.
Serial number 12. Krishnati.
Appearing for the petitioners, my lordship.
Lord, appearing
A
for the,
short accommodation may be kindly given, my lordship.
my lord,
Non-record advocate has some inconvenience, my lordship.
my lord, I am appearing for the respondent number 2 and 3, my lord. This serial number 12, 13 and 23 orders is all are the very same similar matters, my lord.
Yes.
My name may be shown, my lord. Yesterday I filed wakalat now, my lord.
12,
Yes,
13
Annamalai.
and
12, 13 and 23, my lord.
23 connect to each other. Shri so-and-so submit that he has filed wakalatnama for respond number
2 and 3, my lord.
2 and 3. Registry is direct.
My lord, I am
delete his name
filing,
as such.
I am filing the
A statement of objections
You
and
file it in the
application for
office after
vacating of
giving it over.
statement.
Yeah. You submit that you would be filing a statement of objection along with vacate stay application. He is permitted to do so. Counsel for the petitioner is granted 2 weeks time to go through the same and make a submission, relist on
8th January, my lord.
relist on 6th January.
Much obliged.
Much obliged, my lordship.
Till number 14.
Paying for the petitioners. Fresh matter. Matter of doing a no confidence motion.
No confidence. Yes.
The only short point is,
This case, my lord, I filed in pleading application,
I know,
in pleading application.
AKK rules. 15 days clear notice, it's a covered judgment.
15 days notice kotilva. Where is the notice?
You get it in
Page
Annexure A.
12/12/24, meeting to be held on
21st. Nade.
9 days.
For not serious lapse in this case, my lords.
In
Let
labs,
them.
we'll quash it, preserve liberty.
Liberty.
Petitioner is before this court seeking for the following reliefs. Sorry.
Sorry, my lord. My lord, I will
That
take
AG
notice.
accepts notice for respond number 1, 3, and 4.
My
2
lord, I
days.
will take notice for respondent number. Sorry, my lord, I am appearing
The
through.
Prashant Biar, no, you are welcome to appear through VC. The Prashant Biar accepts notice for respond number 2. Petitioner is before this court seeking for the following reliefs. The short grievance of the petitioner is that the no confidence, and the notice of the no confidence motion was served on the petitioner on 12/12/2024.
Was served on 14th, dated is 12.
No. The notice of no confidence dated 12/12/24 was served on the petitioner on 14/12/2024, indicating the date of meeting to be 21/12/2024. And as such, 15-day clear notice has not been issued. The same is clearly apparent from a perusal, ex facie perusal of Annexure A. In that view of the matter, I pass the following order. Writ petition allowed, a certiorari is issued, so and so Annexure A is quashed. Liberty is reserved to respond number 4 to issue a fresh notice by giving clear 15-day notice and proceeding therefrom.
Pleading application. Pleading application. And the.
See, so and so has filed an impleading application since the above petition has been disposed. So, in view of the proposed order to be passed, the impleading application is rejected.
Please, ma'am.
Number 15. Anjuna Swami.
This matter, my lord. Seeking permission to contest it also vote, my lord.
Contest illa, very vote.
ಅಲ್ಲ contest ಅಲ್ಲಿ kindly, my lord. Annexure.
Contest beka, vote beka.
One submission. Once annexure ಈ page number 133.
Contest vote.
ಎರಡು ಕೇಳ್ತಾ ಇದ್ವಿ.
We'll give them time to file the objections.
One submission, madam.
And AGA accepts notice for respond number 1, 3,
Nomination ಇರೋದು ನಾಳಿದ್ದಿಗೆ ಇದೆ.
and 5. Shri
21st
TL
is the
Kiran Kumar
nomination.
accepts notice, is directed to accept notice for respond number 2. Issue notice to respond number 4,
Madam.
returnable by
ಅಲ್ಲ kindly, madam. Kindly one submission, madam.
emergent notice returnable by 30th January.
one submission.
Then it's CS, 4th February.
One submission. Kindly, my lord, peruse, my lord, page number, annexure ಈ
If
page.
we have to permit you to vote, we have to hear respond number 4. Without hearing respond number 4, we can't.
Then vote, madam.
Vote, separate vote, ballot box.
Till number 16. Jaiprakash Shetty.
In the meanwhile, office objection to be complied with, process fee and copies to be furnished by end of day tomorrow, process fee,
Well paid.
failing which interim order will stand automatically. Yes, Mr. Reddy.
Please. I question the validity of the order. The contesting respondent raised a dispute under section 13 of the Karnataka over the Cooperative Societies Act. There is a subject matter. An ex parte order has been passed. Let's kindly see. See, I was nominated to the post of director in the year 2016. Due to some differences between the 6, 7, 8, I resigned, submitted my resignation on 12/12/2019. And there is a deemed acceptance under section 28A of the Act. Despite this, my resignation was accepted by the, in the general body meeting held by the 6th respondent.
Yeah, seal number 16.
16,
16 is for recovery of money.
recovery of money. That is not interesting. I ceased to be a director of the Sixth respondent collected fixed deposit from the general public.
What is the claim? What is the,
Claim for recovery.
on what basis?
See, the section 39 is not attracted to the contesting respondent. Lordship, kindly see section 39. If
It's on account of loans obtained.
loans obtained by, not loan. This is the contesting respondent made a fixed deposit, that's respondent number 6. On maturity, not return. That is a subject matter. If the FD is not returned, then the remedy is available under the provision of.
So you have resigned, Antira.
Yes, resign.
When did you resign?
12/12/2019.
Where is the document?
I have produced the document at page page 16. Page 16 and typed copy next.
Where is the resolution?
Resolution page 19.
Ms. Reno, Sridhar BS.
Please.
ಏನ್ ಕಾಣಿಸಲ್ವಲ್ರಿ ಇದು
ಅಲ್ಲ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ದೀನಿ.
ಹಾಕಿದೀರಾ? Item number?
Item number page 23, ತೀರ್ಮಾನ. ಟೈಪ್ಡ್ ಕಾಪಿ. ಶ್ರೀ ಶ್ರೀಧರ್ BS ನಿರ್ದೇಶಕರು ತಮ್ಮ ವೈಯಕ್ತಿಕ ಕಾರಣ ನೀಡಿ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕ ಸ್ಥಾನಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿರುತ್ತಾರೆ.
DGA accepts notice for respond number 1, 2. Issue notice to respond number 3 to 8, returnable by 4th February.
Annexure
The
E.
operation of the order dated so and so at annexure.
E.
Annexure ಏನು?
E. Page
ಅರ್ಧ
48.
ಇಲ್ಲ. Annexure E. Insofar as the petitioner is petitioner is concerned, is state till the next date of hearing. Is however made clear that the said order can be enforced against the other directors of respond number 6. Process fee and copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated. 10 days time is granted to comply with office objection.
Please.
If office objection is not complied by 9th January, petition would be liable to be dismissed.
17.
This case for only voting rights.
ಏನಕ್ಕೆ? Non-attendance,
Please, non-attendance.
only
No,
non-attendance.
none.
And AGA accepts notice for respond number 1, 3, 4. TL Kiran Kumar for respond number 2, issue notice to respond number 5, written out by 4th February. Vote separate, please. Process fee and copies by end of day tomorrow. 10 days to comply with office objection, if not by 10th dismissal.
18.
Yes.
My lords, the petitioner is a student of law, 3 years course, my lord. She was admitted in 2022 to the course, my lord, for the 3-year course. Now she has written the last semester examination, my lords. What happened was in the subject of environmental science, she got 25 marks, my lord, for 80. She's supposed to get 32, my lord. In the internals, she's got 19, which totals up to 44. Now there is by virtue of annexure A, my lord, the candidates are given option for revaluation.
Subject to payment of 2,000 rupees.
No, my lords. Kindly come to page number 13, my lord.
13.
1-3.
And then separated, yeah. Yes.
In the bottom, my lord, revaluation, the second point, revaluation of answer book is 500.
Challenge violation
Challenge
2,100.
revaluation is 2,000. Either, please come to next page, my lords. After point number 3, my lord, revaluation and challenge valuation for the same answer book is not permitted.
So you've done revaluation.
Revaluation I've done.
ಆಗ್ಲಿಲ್ಲ.
Aglila,
ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು.
please, my lords. I'm a topper
Girish.
in the college, my lord.
Senior other marks, they are good. Where's Mr. Girish? Shri Learned AG accepts notice for respond number 1. Shri Girish Kumar is directed to accept notice for respond number 2 and 4. Issue emergent notice to respond number 3 returnable by 1st February. The respond number 4 is directed to permit the petitioner to apply for challenge evaluation in the subject environmental studies as regard the examination held on 24/8/2024, which challenge evaluation will be subject to the result of the above petition.
Much obliged, ma'am.
Process fee and copies to be furnished by tomorrow,
Please, ma'am.
and compliance of office objection by 10th.
Hearing on IS serial number 19.
I beg to appeal for the respondent, my lord.
My lord,
I have made this application.
I'm filing
My lord, the,
counter to this.
my lord, the petition was disposed of by your lordship on 25/7/2024.
Yes.
Your lordship may recollect, my lord, this is a matter, my lord, where
walls.
they have,
Yes.
yes, my lord,
Rain falling.
rain falling.
Hmm.
They undertook before your lordship, my lord, to remove the walls on all the 4 corners, my lord, above first floor, and only to metal sheet, my lord, with the help of iron rods. While doing so, my lord, we are on the ground floor. Their work is on the 2nd floor, common wall.
They have damaged something.
They have, my lord, they have made all the bricks to fall on our this
No,
lot
no.
carelessly they have done.
But
So
therefore,
we have lodged a police complaint, and at that stage they have stopped the construction
my
work.
lord, these small things, my lord, should not attract the attention of the court. Kindly see this
Third.
statement.
Request to
No,
Paris.
no,
Allah, your
It's,
lordship may kindly see, my lord.
It is
Till
not
this day,
second
they have
floor.
not done.
It is first floor.
You have been fighting this litigation for 2 decades now.
More than 2 decades,
Yes,
3
More than
decades.
2. What
3
I remember
decades.
is 2 decades.
Yes.
And you are in the ground and first floor.
And they give police complaint. Therefore, I was summoned to the police station. I cannot work.
My lord,
They want the bricks to be removed, and at the same time, the work should not go on. My lord,
my lord, to give a quietus, my lord, we will get it through executing court, my lord.
no. I will remove it. I have given an undertaking to this honorable court.
Identify a contractor
Yes,
who is acceptable to both of you.
yes,
They
My lord,
will-
yes.
Both of you
Yes, my
appoint
lord.
a-
They are deliberately, my lord, damaging our property. My lord, that is our case. While doing so,
which is not correct.
my lord, that is the case.
We are not getting into that right now.
No, that's why, my lord, we are getting it
My lord,
executed
may I
through
submit, my
executing
lord?
court, my lord.
Mangalore matter ಗೊತ್ತು ಆಯ್ತು. ನೀವಿಬ್ರು ಅಪೇರ್ ಆದ್ರೆ ಮುಗೀತು ಅಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ.
ಹೌದು.
Now identify a contractor who
Yes.
will be acceptable to both.
Yes,
He will do the work as undertaken.
yes, my lord.
My lord, may I submit? My lord?
Yes.
I have no objection for this, but the whole work would take not more than 2 days and removal of bricks. And it is my property. I am removing it.
Let us
And-
know on the 7th or 8th of January between both of you.
Yes,
Who is a contractor? 2 days ಅಲ್ಲಿ ಮುಗಿಯೋದು. 20
ಅಷ್ಟೇ,
ವರ್ಷದಿಂದ ಜಗಳ ಆಡ್ತಾ
ಅಷ್ಟೇ.
ಇದ್ದೀರಾ.
And ಧೂಳು ಬರಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ರೆ
ಬಂದೇ
what
ಬರುತ್ತೆ
is
ಸ್ವಲ್ಪ
this?
ಧೂಳು.
ಬಂದೇ
ಧೂಳಲ್ಲ,
ಬರ್ತದೆ.
ಧೂಳಲ್ಲ. They have damaged our floor ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ.
ಒಂದು-
Tile true.
ಬೀಳತ್ತೆ, ಒಂದು ಟೈಲ್ ಒಡಿಯತ್ತೆ. ಅದು
As your lordship suggested, my lord, we will suggest a common contractor who could do
common
the.
this one, and if there is any damage which is caused, will also be rectified.
Yes, please. Yes.
You can't do anything without some damage.
Allah, damage,
Will be some damage.
without damage, my lord, they can.
And I,
Demolition work ನೀವೇ ಮಾಡಿ ಹಾಗಾದ್ರೆ. ನೀವೇ ಮಾಡ್ತೀರಾ?
Allah, through.
let them,
ಅದು ಎಷ್ಟು ದುಡ್ಡು ನಿಮ್ಗೆ ಕೊಡ್ತೀವಿ?
yes, yes, my lord.
Yes, my lord.
I will find out, my lord, because by that they will damage my property.
Ah.
That also is there, because they are fighting for 3 decades.
ಹಾಗಾದ್ರೆ ಅವ್ರು ಮಾಡುವಾಗ ನಮ್ದು ಡ್ಯಾಮೇಜ್ ಆಗೋದಿಲ್ಲ. ನಾವು ಮಾಡುವಾಗ ಅವ್ರದ್ದು.
This is separate.
ಬೇರೆ ಒಬ್ಬರು ಕಾಂಟ್ರಾಕ್ಟರ್ ಇಬ್ರು ಹೇಳಿ.
ಅದೇ ಹೇಳಿದ್ದು.
Yes.
There, in this litigation which is going on for last 3 decades, another IA has been filed. Now contending that the petitioner is damaging and or has damaged the property of the respondent while carrying out the demolition. In that view of the matter, in order to bring about a quietus to the issue, both the councils are directed to identify a contractor who is acceptable to both the parties to carry out the works.
Yes,
Subject, however, to the payments to be made by the petitioner.
yes.
relist on 9th January at 2:30 PM.
Grateful. Yes.
Serial number 20, Dhananjay Kumar.
Appearing for response number 2, my lord.
Petitioner, my lords.
My lord, last date appearing, my lord, from the court directed the response number 2 to consider this request for waiver of some portion of loan, my lords. Now, respondent to bank communicated the petitioner their inability to waiver of interest. Illa, adu only agriculture loan bailane helutte. I may be permitted to pass an communicated to the petitioner, my lord. As per 70, clause 70 of the bylaw, my lords.
It will have to be heard then. Interim order will continue.
No, my lords.
No,
Petition become infractious. He has challenged the auction schedule done 23/8/2024.
Learned counsel for respondent submit that the respondent is unable to provide any any relief on account of the interest as sought for by the petitioner. Relist on CSI, relist on 15th January.
Please.
Interim order earlier granted is extended till next date.
Grateful.
21. Sumana Nagaland.
This is the tax practitioner's matter. It's directed by your lordships. We filed an affidavit.
Lord, I appear for the petitioner, my lord.
This one more development. They filed a memo in response to our affidavit, seeking some further assurances. So we'll file that affidavit also.
Tomorrow?
No, it's here. We've kept it ready.
You're filing it. Now that you have served it on them?
Yes, yes, my lord.
Lord, I have received it at 1 o'clock, my lord. Kindly have the matter tomorrow, my lord. We'll close it.
All the assurances
I was not.
This is not,
it was not what?
Lord, I could not have a look at it.
We respond.
Not get instruction. Fine.
Tomorrow, my lord.
An affidavit has been filed by respondent number 6. In response thereto, a memo has been filed
today morning, my lord.
by the petitioner. In response to the said memo, another affidavit of respondent number 6 has been filed. Learned counsel for the petitioner seeks for a day's time to obtain instruction, make a submission. Relist tomorrow.
At 2:30 hours or in the regular?
2:30.
2:30. Interim order to continue.
Interim order earlier. 2:30, it will come.
Regular.
Yes. Grateful.
22.
But this is a matter pertaining to a law student seeking transfer lots from Jamkhandi to Bangalore lots.
No, that political science major.
Yes, lots.
Which college?
Lots, the college which lots, St. Joseph College was there, lots available, but seat is not there, lots. I inquired with them.
In which college seat is available? You tell us.
There is no seat available, lots. In second year, there is no seat, lots. But now, lots, I also
till January 13, my lord, this semester will be there, my lord. Thereafter exam starts. So again, he'll have attendance shortage wherever he goes. And he has to study in the same combination, my lord.
Same.
Political science and
I inquired
economics.
with the college, my lords, second respondent college. Lots, not question appearing for them, lots. Lots, what they say, lots, they can accommodate me, lots. And they will also give lots subject to the directions of this court, not they can.
We can't change the rules. You identify, only thing that we can do for you is you identify the college, then we'll direct them. Otherwise, no.
At this point of time,
There's no seat. I identified lots. I went to the college. There's no seat in the college.
One college, Airad Bengaluru, log.
now the list which we have given, they have not chosen from them. And moreover, my lord, even semester we
Benefit
can't.
being extended.
Otherwise, I have lots. I was advised to same lots. Plus, I may permit me to take up admission to first year, lots the second year.
That you can do.
Second respondent.
First year you can do.
First year, lots.
You lose 1 year.
Yes.
That is the only other option.
Yes, lots.
Petitioner is third. Petitioner is before this court seeking for the following relief. The petitioner had applied for transfer. Petitioner is a law student who had taken up as one of his subjects political science major. He had applied for transfer to respondent number 2 college, which was refused by respondent number 1 university on the ground that respondent number 2 college does not have a subject political science major. In the petitioner was furnished a list of other colleges which had the subject political science major. However, the petitioner today submit that he is not interested in joining any of those colleges, but would take up, but if permitted, he'll take up the first year law course with the second respondent.
Yes.
In that view of the matter, I pass the following order. It's a fresh application. There's no mandamus.
I will
required.
do it. I'll give it immediately.
Petitioner is permitted. Permitted to bad. In that view of the matter, petition is disposed of since the petitioner is always has the liberty to apply afresh for admission to respond number 2 college.
Obliged notes.
Obliged.
Number 23
Pending
and
highest and dismissed.
24. Vanita Devi.
Here for petitioner, my lord. I'm filing amendment application, my lord. The same may be considered to stay the impugned order of the deputy registrar dated
A 1 of
1911.
24 has been filed for amendment accepting the reasons stated in support thereof. This application is allowed. Petitioner is permitted to amend the petition and file amended petition. Fill up application.
Please give on.
IA consolidated, IA 1 of 24 is allowed. Another application and IA 2 of 24 has been filed. Accepting the reasons stated therein, said application is also allowed. Having considered the petition, the order passed by respondent in dispute number so-and-so dated 9/11/24 at annexure Q is stayed till the next date of hearing. Issue notice to respond number 1, written by 4th January. Process fee and copies to be furnished by end of day tomorrow.
That
Plain
man.
language interim order.
25. Prashant, this is
Voting. Contest also, my lord, I'm sought for. I restrict my prayer to only voting.
Live.
Only voting.
Voting. And AGA accepts notice for respond number 1, 3, 4, 5. TL Kiran Kumar for respond number 2, issue emergent notice to 6, written by 4th, voting.
Minimum, my lord, transaction is not made.
Yardu, ellarduna.
No, it is not specified. my lord.
Obburdena.
83, my lord, page number 83, my lord.
ಇಲ್ಲ ಎಲ್ಲರಿಗೂ ಸೇಮ್
ಅಲ್ಲ ಒಬ್ಬರೇ ಇರೋದು petitioner ಇದು.
ಹೌದು, ಒಬ್ರೇ petitioner
ಶಿವಕುಮಾರ್
ಇರೋದು.
BV. Page 83.
serial number 932 for all the ineligible voters, same thing, lord.
ನಿಮ್ದೇನಪ್ಪ?
932 serial number.
932.
All three, my lord, they have
ಕನಿಷ್ಠ
typed.
ವ್ಯವಹಾರ ನೀಡುವುದು.
ಇಲ್ಲ all three, my lord, for all ineligible voters, same thing. No, there is no individual.
That will have to be examined. The interim order ಇಲ್ಲ. Issue emergent notice written by 4th.
26. Kavita N.
Yes, madam.
Lord, auction notice is challenged, my lord.
What is
Monday
the
is
amount,
auction.
madam?
31,72,000, my lord.
How much will you pay?
25%, my lord. 25%.
25% in
within
4 weeks. And after that?
After that, I will file affidavit.
After that, ಇವಾಗ್ಲೇ 50% ಲೆಕ್ಕ ಕೊಡ್ಬೇಕು. ಆಮೇಲೆ
Another
ಇದು 2
4
ವರ್ಷ ಹಂಗೆ ಇರುತ್ತೆ.
Another 4 weeks.
And AGA for respond number 1 and 2 issue notice to respond number 3 written by 4 January. Submission of learned counsel for the petitioner is due to financial stringency so-and-so could not be paid. The total amount due is 31,72,000, 25% amounting to so-and-so will be paid within 4 weeks from today. That is on or before 23rd January. And sum of rupees another 25% in 4 weeks thereafter. That is by so-and-so. In that view of the matter, stay when he defaults so-and-so. Process fee.
That's it.
27.
27.
This is also same, my lord, annexure.
In
Samanya.
A5,
Really, it is not same. For all ineligible voters, my lord, same thing, my lord. It's typed in
A5
the-
we won't give. A5
They
we
have
are
not
not
specified, my lord. That's what, man, I'm trying to show. My lord may kindly take note.
A5 we can't, we are not indulging. That is what we have refused everybody. And AGA accepts notice for respond number 1, 3, 4, 5. TL Kiran Kumar for 2, notice to respond number 6 by 4/2.
And my lord, election may be held to be subject to result of the writ petition. At least that, my lord.
28.
Election shall be subject to result.
In 25 also.
In 25 also, same society,
25 also election subject.
please.
28.
In this case, appear for the petitioner, my lord.
Hmm.
My lord, petitioner is a trust, public charitable trust, my lord. As per subsequent to the application was filed, my lord.
Hmm.
My lord, the respondent number 2 was supposed to, my lord, issue a password,
Hmm.
which they failed to do so, my lord. Therefore, my lord, the petitioner as per Annexure C, my lord, dated 30th May 2024, submitted a representation, my lord. Thereafter, again on 19th June, Lordship may kindly say Annexure D, ink page 29. One more representation was also submitted, my lord.
Hmm.
At first para, my lord, second para,
Page.
page 29, my lord, Annexure D. May I read the my lord, required sentence, my lord. Second para, my lord, we kindly request you to provide UUCMS login ID and password. My lord, without this, my lord, the petitioner could not have been able to pay the fees. Thereafter, my lord, in spite of this, they didn't reply, my lord. Then, my lord, as per the recommendation by the state R1 at Annexure K, my lord, they directed them to, my lord, open for a half day and give an opportunity.
Hmm.
Accordingly, my lord, as per Annexure L, my lord, they have submitted now.
Or
Annexure,
the list of every student is being uploaded.
my lord,
Every student details is uploaded.
please, my lord, even the payment or as required payment has
Has
also
been
been
made.
made. Yes, my
Mhm.
lord. Now, in fact, my lord, as per Annexure F, my lord,
Hmm.
All India Council for Technical Education have already approved, my lord.
Yes.
My lord, now, since 2 months has elapsed, my lord, they are not responding to our any representation, even as per, my lord,
AGA accepts notice for respond number 1, City University.
Rajendra Kumar.
Rajendra Kumar Sungay is directed to accept notice for respond number 2 and 3. The pending consideration of the above petition, the students who have already enrolled by the petitioner with the petitioner institution are permitted to continue their course. Shri Rajendra Kumar Sungay is directed to place on record the status of the applications filed by the petitioner on the next date of hearing. Relist on 20th January.
grateful.
29.
I appear for petitioner in this case, my lord.
Yes.
Lord, the show cause notice at page number 37 has been challenged in this writ petition, my lord. Along with the show cause notice, they have passed an order directing the Deputy Director of Public Instruction to take action before receiving my reply, my lords. Kindly peruse page number 37 and the last para, ಪ್ರತಿಯನ್ನು ಉಪನಿರ್ದೇಶಕರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಮಧುಗಿರಿ ಶೈಕ್ಷಣಿಕ ಜಿಲ್ಲೆಯವರಿಗೆ ನೋಟಿಸ್ ಅನ್ನು ಕಳುಹಿಸುತ್ತಾ
Learned AGA, we'll read it down as a show cause notice and direct him to reply.
I have replied, my lords. I have given reply. My reply was not considered. Before
You haven't even heard them, how have you shifted them? Notice kottilla.
I will produce, my lord. We have given the notice even.
Learned AGA accepts notice for respond number 1 to 5, relist tomorrow.
please, my lords.
Serial number 30.
Appearing for the petitioner, my lord. Challenging
Is tomorrow to enable the learned AGA to place on record the show cause notice issued by respondents and received by the petitioner. Yes.
challenging cell notice, my lord. Due amount is
ಎಷ್ಟು amount ಎಷ್ಟು?
26,37,000, my lord.
Learned AGA for respond number 2, issue emergent notice to respond number 1 written by 4th February. 26 lakh?
37,000.
27,000. 25% 4 weeks, 25% 4 weeks. Process fees also.
31. Ritesh Kumar
For
Singh.
the petitioner, contest and vote, my lords.
Contest illa.
So it is also, my lord, 28.5.
A5.
If your lordships may kindly peruse this memo, my lords,
Well,
there are no outlets to transact with, my lords.
Then why do you want to be part of that society?
There is a civil suit pending, according to them.
If you are not transacted, we are
But there are no outlets to transact with, my lords. Your lordships may kindly peruse it.
that will hear you.
But
And
let-
AGA accept notice for respond number 1, 3. TL Kiran Kumar for 2, issue notice to respond number 4 written by 4th
My lords,
February.
voting, my lords, I request. My lords, kindly
Not
peruse.
transacted, no.
My lords, I have attended the meeting. There is nothing to transact with.
Then why
Your
do you want to
lordships may
vote?
kindly peruse page.
Sorry, Mr. Council, for no transaction, we are not in.
Very well.
32.
32. Yes.
But
As per annexure A, my lord, I need to pay 1 crore 29 lakhs 49,149.
1 crore?
1 crore 29 lakhs 49,149. As on 24/6/2024, my lord. I request this honorable court, my lord, kindly peruse the page number 27.
Order is 1 crore 47 lakhs ಇದೆ.
ಅಲ್ಲ ಆರ್ಡರ್ 1 crore 47 lakhs ಅಂತ ಇದೆ. ನಾನು ಲೋನ್ ತಗೊಂಡಿರೋದು 1,98,630. ನಾನು ಪೇ ಮಾಡಿರೋದು 1,81,00,000.
ಆಮೇಲೆ ನೋಡೋಣ.
1,81,00,000 ಪೇ ಮಾಡಿದ್ದೀನಿ.
When the award is for 1 crore 47, we can't reduce that.
ಅಲ್ಲ ನೋಟಿಸ್ ಅಲ್ಲಿ 1 crore 29 lakhs ಅಂತಾನೆ ಇದೆ.
1 crore 47 ಇದೆ.
ಅಲ್ಲ ಫಸ್ಟ್ annexure 14 A ಮೆಲಾಡ್ at page number 14.
1 crore 47 ಇದೆ.
ಅಲ್ಲ 14 ಮೆಲಾಡ್ page number 14.
ಇವಾಗ ಎಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡ್ತೀರಪ್ಪ?
ಮೆಲಾಡ್ 10 lakhs tomorrow I will pay the 10 lakhs ಮೆಲಾಡ್.
Tomorrow 10 lakhs.
10 lakhs ಮೆಲಾಡ್. ಆಮೇಲೆ 4 weeks ಆಗಿದ್ದಾದ್ಮೇಲೆ I will pay the 10 lakhs ಮೆಲಾಡ್. Because ಮೆಲಾಡ್ kindly peruse the ಮೆಲಾಡ್ statement ಮೆಲಾಡ್ at page number 27.
37.5 ಲಕ್ಷ ಕೊಡಬೇಕು in next 4 weeks.
ಅಲ್ಲ 10 lakhs I will pay the 10 lakhs ಮೆಲಾಡ್. Further I will pay the 15 lakhs.
ಇನ್ನ 25 ಲಕ್ಷ ಕೊಡಬೇಕು.
ಅಲ್ಲ because ಮೆಲಾಡ್ I have already paid 1 crore 81 lakhs for
That is adjusted towards the interest portal.
1 ಕೋಟಿಗೆ
ಆಲ್ರೆಡಿ ಇದಾರೆ, ಇಲ್ಲ ಅಂತ ಇದೆ.
ಅಲ್ಲ 1 ಕೋಟಿಗೆ
ಎಷ್ಟಮ್ಮ ಡ್ಯೂ?
Sale is scheduled on 9/1/2020.
1 crore 47 1 crore 29
1 crore 47.
47.
ಅಲ್ಲ annexure A ಇಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಅವ್ರು
That
1
is
crore
24/6.
there are irregularities.
ಕಮಿಂಗ್ ಅಟ್ ಸೇಲ್ ಟೈಮ್. ನೀವು ದುಡ್ಡು ಕೊಟ್ರೆ ಏನೋ ಸ್ಟೇ ಮಾಡಬಹುದು, ಇಲ್ಲ ಆದ್ರೆ ಇಲ್ಲ.
tomorrow I will pay the 10 lakhs.
ಮಾಡಿ, ಯಾರು ಬೇಡ ಅಂತಾರೆ, ಸ್ಟೇ ಇಲ್ಲ ಅಷ್ಟೇ.
ಅಲ್ಲ
Land AG accepts notice for
15 days ಆಗಿದ್ದಂದ್ರೆ
respond number 4. There's Manjula S who has
Respond number 1.
entered up filed caveat for respond number 1, accepts notice for respond number 2 also. Issue emergent notice to respond number 3, returnable by 4th February.
10 lakhs tomorrow, my lord. After 15 days, my lord, 15 lakhs I will pay.
My lord, 9/1 is sale.
More than principal amount ಆಗುತ್ತೆ.
In this kind of money ನೀವು ಬರೀ 10 ಲಕ್ಷ ಕೊಡ್ತಾ ಇಂಟ್ರೆಸ್ಟ್ ನುಂಗಾಕ್ಬಿಡ್ತಾರೆ ಅದನ್ನ.
ಅಲ್ಲ ಅದೇ ಆಗಿದೆ.
ನಿಮ್ಗೆ ಏನು ಸಿಗಲ್ಲ.
ಅದೇ ಆಗಿದೆ ಸರ್.
ಅದಕ್ಕೆ ಜಾಸ್ತಿ ಕೊಡಿ.
1,81 ಲಕ್ಷ ಕಟ್ಟಿದ್ವಿ. ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಪೇ ಮಾಡ್ತೀನಿ ಸರ್.
25% by 4 weeks, 25 in another 4 weeks. ಇಲ್ಲಾದ್ರೆ ಆಗಲ್ಲ.
Please.
1 crore 47 lakhs.
ನೋಟಿಸ್ ಅಲ್ಲಿ
1,21,617. 10 lakhs tomorrow, balance of 25% by 23rd January. ಆಮೇಲೆ 4 weeks. Process fee and copies by tomorrow.
Reporting settlement serial number 33.
Stay. Though the auction shall go on. Though auction shall still go on, it shall not be confirmed.
In all these cases, it's filing.
Settled, we are filing the memo for withdrawal.
Finally. ಏನ್ ಅಷ್ಟು ದೊಡ್ಡದಾಗಿದೆ ಅಲ್ರಿ ಮೆಮೋ?
In all 7 matters.
They are paying the.
ಜಾಯಿಂಟ್ ಮೆಮೋನ?
ಇಲ್ಲ
We are withdrawing the petition since they have received the money.
Last matter.
Petitioner is before this court seeking for the following relief. A memo dated 19/12/24 has been filed, signed by the petitioner and the counsel for the petition, which reads as under. Accepting the memo and submission, petition is dismissed as withdrawn. Elladallu separate ಇದೆ. Yes.
Connected.
Elladallu same memos.
Further hearing serial number 30.
Further hearing.
Appearing for the respondent, my lord.
Yes.
Take payment to realize I got last hearing and then the consulting. More than 5 months, 29/11 5 months.
ಏನ್ ಮೆಮೋ ಹಾಕಿದ್ರೆ? Which petition?
COP 281/201.
Mr. Nagaraj? You filed a memo. You're for petitioner or respondent? Can we dispose of on your basis? The petition has to file.
Confirm that they have received the realized amount.
You took time for making submission as regards previous orders in COP 281.
On 24/10 to 2024, we paid 1 lakh amount. Check the realized item.
It is for them to make the submission, not for you. Learned 34, learned counsel for the respondent company submit that 1 lakh of rupees has been paid to the petitioner and the matter has been settled. None appears for the.
Represent the petitioner.
Yes, Mr. Nagraj.
34, I represent petitioner, my lord. 1 lakh issued by TD, that is credited to the account. So far as serial number 7 and 9, my lord, I have filed the applications. The other ex-employees wanted to come on record as applicants, as additional petitioners, my lord. Applications are required to be done. And reserved orders, my lord.
Yen Saria Kersala, Mr. Nagraj.
With regard to winding up, my lord. Application for implement as additional, because these 3 persons also the ex-employees, the company.
You had to make a submission as regard the email sent by one of
And
your
we wanted to
settle.
yes,
That
yes,
is-
my
this-
lord.
this is
In
that
that
matter.
regard, the submitted. Yes, my lord.
Hmm.
Those application serial number 7.
Yes.
I got figure
462, 462, my lord.
not available.
Yes, sir.
Learned counsel for the petitioner
Application,
acknowledges
my lord,
receipt of the said amount, but however, submit that that as regards the impleading applicants in CA 460 of 2021, 460 and 461 of 2021, no settlement proposal has been received.
62 also, my lord.
60, 61 and 62. Counsel for the respondent seeks
Yes.
and is granted 2 weeks time to obtain instruction, make a submission. Relist on 9th January at 2:30 PM.
35.
35. Yes, madam.
Yes, I've got the checks. That's
Hmm.
last time I submitted a memo 441 of 2015, the Voro soaps. Just want to make sure it's entered in order. It's
What
not in
memo
order.
have you submitted?
Last week. To
Any-
not dispose it till the checks are cashed.
So you received the checks now.
Yes, all.
When is the
checks.
last date? When is the first check?
This month, 25th.
And next check?
Every month, 25th.
Every month.
10 checks are given.
35 relist on, the 16th or 9th.
9th.
9th. Let us see if that check gets cleared.
About COP matter.
Huh? Yes. You file an application.
36.
You want it to be listed tomorrow and settle it tomorrow, we'll list it tomorrow. Make a memo, as company petitions relist being spoken to on that. File a memo. Yes.
Serial number 36.
Appearing for the petitioner, my lord.
Agidya. Government is approved. You sent it to the. And AGA submit that the matter is now being sent to the government. And the approval is on 19, 19 Allah. 9/12. And the approval is awaited. By when will the approval happen? Relist on 16/1.
37. Vikram Balan.
Lakshmana. ಏನಾಯ್ತಪ್ಪ STP ಕಟ್ಟಿದ್ರ ಇಲ್ವಾ? None appears. Relist on 16-1.
38,
Identified Karthikeyan. And counsel for respondent number 1 has filed a memo which reads as under. He submits that if the inspection is joint inspection is scheduled on 23/12/24 and if the matter is taken up after 3 weeks, submissions as regards closure of the matter would be made. Relist on 23/1.
39,
ಏನಾಯ್ತು ಅದು ಮಾಡಿದೀರಾ ಈಗ ಇಂಟಿಗ್ರೇಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು. ಇಲ್ಲ ಇನ್ನೊಂದ್ರಲ್ಲಿ ದೇ ಮೇಡ್ ಎ ಸಬ್ಮಿಷನ್ BCCMS and CCMS. There are some features which are good here, some features which are good there. They will integrate ಅಂತ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲೇ ಇದೆಯಲ್ಲ ಇದ್ರಲ್ಲೇ ಇದೆಯಾ ಕಂಪ್ಯಾರಿಟಿವ್ ಸ್ಟಡಿ ಇದೆ ಅಲ್ಲ.
ಇದರಲ್ಲಿ ಇದೆ. This is regarding the CMS and the CCMS.
Yes.
So there are a few features, my lord, which the CCMS has and which is absent in the
correct.
CMS. The lordship on the last
So
occasion,
in
my lord.
some other matter, they made a submission as regards will integrate. The Special Commissioner IT.
I will ascertain that, my lord.
Learned counsel for respondent 125 seeks for and is granted 2 weeks time to make a submission. Relist on 16th.
Serial number 6, my lord, list number 2. Serial number 6, list number 2. That was also.
You are not there.
Yeah, I was held up.
Yes, what has happened?
My apologies, my lord. In that matter, my lordship, user acceptance testing and security audit by CERT is going on. And internal audit is also going on by Karnataka State Data Center. So it will take some time.
Serial number 6. Sri Pawan Kumar, learned counsel for the corporation submits that the data audit is, the security audit is going on.
By CERT. Security audit by CERT. And
Security audit is going on.
an internal
report
audit
is
at
awaited.
Karnataka State.
Relist on 30th January.
Obligations. My apologies, my lord.
40,
Serial number 39 is 16.
16.
40.
I appear for petitioner, you know.
Yes.
One submission, my lord. Petitioner has to pay 1 crore something. The stay is granted without any condition.
Without any condition.
Yeah, without any condition.
My senior counsel is in another
Since
court, Your Honor.
2001. It is.
2001 ಅಲ್ಲ,
There is
23
urgency, my lord. 2001 ಇಂದ ಡ್ಯೂ ಇದೆ ಸ್ವಾಮಿ. 2001.
ಎಷ್ಟು ಅಮೌಂಟ್ ಡ್ಯೂ ಇರೋದು?
22 lakhs ಪ್ರಿನ್ಸಿಪಾಲ್, ಬಡ್ಡಿ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಸೇರಿ 1 lakh 1 crore ಆಗಿದೆ ಸ್ವಾಮಿ.
ಪ್ರಿನ್ಸಿಪಲ್ 22, ಬಡ್ಡಿ 80 ಲಕ್ಷ.
ಸ್ವಾಮಿ ಈಗ 2001 ಇಂದ
Counsel for respond number 3 submit that the total dues of the petitioner as on date is more than 1 crore of rupees. Learned counsel for the petitioner seeks for a short accommodation to make a submission. Relist on 20th in CS. Relist on 15th January.
Interim order.
Interim order earlier granted is extended till next day.
Your Honor, may kindly have this matter on 15th busy ಇದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
15th, what, next.
16th, Your Honor, please.
Corporate society matter, madam, 15th, next hold. 2:30. ಏನು ಇಷ್ಟೊಂದು ಇದಾವೆ? ಇನ್ನೂ ಇದಾವೆ.
Both matters.
ಏನು ಯೋಗೇಶ್?
Voting in this matter, Your Honor. Both are right there, my lord. This is 24 and 25.
So we'll restrict the order to only.
Please, even otherwise, my lord, is eligible, my lord, lordship, my lord. You want me to clarify, my lord? Regarding, even otherwise, he is eligible, then only, my lord, you will cast the vote.
If otherwise.
And AGA accepts notice for respond number 1 and 4. TL Kiran Kumar for 2. Emergent notice to respond number 3 written out by 4th January. ಯಾವತ್ತಿದೆ ಇವೆಲ್ಲ?
Elections are on 22nd.
Second.
ನಾಳೆ ಕೊಟ್ರೆ ಆಯ್ತಲ್ಲ ಆರ್ಡರ್.
Please.
ಎಲ್ಲೆಲ್ಲೂ
I
ಹ್ಯಾಂಡ್
not,
ಡೆಲಿವರಿ ಅಂತ ಇಟ್ಕೊಂಡ್ಬೇಡಿ.
ಅದು 2.5 ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
The petitioners, if not disqualified under section
9C.
29C and are declared ineligible under section 20 A5 ಅಲ್ಲ?
Please.
Under section 20 A21 sorry 22 A Roman 5 are permitted to vote separate ballot box.
Please.
Process fee and copies by end of day tomorrow. Office objection to be complied by 10th, failing which in.
Mohammed Tahir, Petitioner Lokesh.
In this matter, I am seeking contest and vote, Your Lordship.
No contest.
Please.
AGA for respond number 1, 4. Kiran Kumar for 2, notice to respond number 3 by 4th. Same order, not disqualified 29C.
Please.
K. Prasanna Shetty,
Lord, only voting.
Voting.
Lord, only.
Same order ಮಾಡಿ ಇದನ್ನು. AGA for respond number 1, 2, 3, 4,
And 6.
6. Issue note, TL Kiran Kumar for 2, issue notice to respond number 5 written by 4th.
Please.
Not disqualified in 29. K-Wait ಇದೆಯಾ? She notice ಬೇಡ. She Devi
ಅಲ್ಲ,
Prasad
K-Wait.
Shetty who has filed K-Wait except.
K-Wait
notice.
ಇಲ್ಲ ಅಂತ ಇದ್ರ ರಾಂಗ್ ಆಗಿ ಪುಟಪ್ ಆಗಿರ್ತವ್ರೆ. ಇದ್ರಲ್ಲಿ K-Wait ಹಾಕಿಲ್ಲ.
ಮತ್ತೆ ಏನಕ್ಕೆ
ಡಿಲೀಟೆಡ್. ಬೇರೆ ಮದರ್ ಸೊಸೈಟಿಗೆ ಹಾಕಿದ್ದಾರೆ.
Shri Devi Prasad Shetty, ನಿಮ್ಮ ಹೆಸರೇನು?
ಗಿರೀಶ್.
Shri Girish, submit that the K-Wait petition filed by him has been wrongly tagged. Registry is direct look into the same.
Request for hand delivery.
Tomorrow and delivery, not today.
serial number 4, Prasanna Shetty,
But here also not voting. But only.
Where parties, ಇದ್ರಲ್ಲೂ K-Wait wrongly put up.
ಇಲ್ಲ ಇದರಲ್ಲಿ K-Wait ಹಾಕಿದ್ದಾರೆ.
ಇದು
Yes, filed
correct.
K-Wait, correctly filed.
AGA for 1, 3, 4, 6.
Please. ಇಲ್ಲ ಅಂತ.
TL Kiran Kumar for respond number 2.
ಅಲ್ಲ ಇದರಲ್ಲೂ ರಾಂಗ್ ಅಂತ.
ಇದ್ರಲ್ಲೂ wrong.
ಇದರಲ್ಲೂ ಇಲ್ಲ. ಕೆಸಬೇಡಿ.
Wrongly put up registry is direct look into the same. Subject to so and so.
Please. Please.
Chetan Jadhav,
Yes.
This is a case where I've taken a loan, my lords, from the respondents.
How much?
My lords, principal amount is 1,60,000, my lords.
How much is due?
From my side, 40,000 is due, my lords.
As per them,
As they claim 11 lakhs and all, my lords.
we'll go by what they claim. We can't go by what you claim
But-
for
My
interim
lord,
order.
my lords, the problem is, my lords, they have attached my property. Then they're
Adike, if you want to stay, you'll have to go by what they claim. Notice 1, notice 2, notice 3, dispute.
Then they're threatening to auction it, my lords. That is the urgency.
Yes, so what is where's the auction notice?
They've told us it's gonna happen anytime soon. That's why. Every day I'm getting calls and being harassed.
Award is 8 lakhs 92, 9 lakh 32 on 1/12/23. And AGA accepts notice. ಇಲ್ಲ ಇದು state cooperative. Why you made the state of Karnataka by Managing Director Karnataka State Cooperative Housing Federation?
I'll rectify it, because it is the respondent is the managing director of the state cooperative housing sector.
What, how do you make this? You can, your cost title is wrong. Your array of parties is wrong.
I'll verify because the note, the property is under their possession, my lords, that is why.
Please check properly. We'll have it tomorrow. Relist tomorrow. File a proper amendment application.
Yes, my lords.
Prakash Reddy,
Petitioner. Sought for voting.
AGA for
1 and 3.
1, 3, TL Kiran Kumar for 2, notice to 4. Same order.
My lord, 3 is there, my lord. Sustino idare. Susti and my lord, 24, 5 inu ide.
ಅದೇ ಸಬ್ಜೆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ವಿ.
Please, please.
ಇನ್ನು ರೆಡ್ಡಿ ಅವ್ರ ಹತ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ಬೇಡ, ಸಬ್ಜೆಕ್ಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಮುಗೀತು.
Sachin BS,
ಸಚಿನ್?
Petitioner.
Yes.
In contest. Voting in
Voting ಏನ? AGA for 1, 3, 1, 2.
Please.
You have not made the commission a party, election authority, you have not made a party.
Madil.
Relist tomorrow.
Vishwanatha Shetty,
Petitioner, Petitioner.
But petitioner was given admission to PSC AG on 3/11/2023 by the respondent, my lord. My lord, subsequent to that, my lord, please, the petitioner was met with an accident on 27/11/2023. He has suffered with his left leg as well as this ankle.
Attendance ilva?
Attendance 80 ಕಡಿಮೆ ಇತ್ತು. ಆ ಸೆಮಿಸ್ಟರ್ ಫಸ್ಟ್ ಸೆಮಿಸ್ಟರ್ಗೆ ಎಕ್ಸಾಮ್ ಬರ್ತಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಸೆಮಿಸ್ಟರ್ಗೆ ಆನ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ವಿತ್ ಆಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ as provided under rule 4.14.5, my lord, they have permitted me to continue. My lord, I have taken examination of second semester also. Second semester of first year. Then when I have given admission for second year, first semester, now examination is going on, they are not permitting.
UAS who is the standing council?
Please, man, I'll serve copy, my lord. In
Srinivasa,
meantime, tomorrow examination is there.
M Srinivasa.
M. Srinivasa is directed to accept notice for respondent number 1 and 2. The respondents are directed to permit the petitioner to appear for the examination scheduled on 20/12/2024 and 23/12/2024. The results of the said examination shall however be subject to the result of the above petition. Relist on 27th January.
Praying for hand delivery.
Tomorrow it will be delivered.
Please.
Don't go today.
ಸರಿ
ನಾ ಇಲ್ಲಿಂದ ಹೋಗೋವರೆಗೆ ಎಷ್ಟೊತ್ತಾಗುತ್ತೋ
ಆಗ್ಬೋದು.
ಗೊತ್ತಿಲ್ಲ.
ಮಧ್ಯಾಹ್ನ ಇದೆ ನಮ್ಮ ಬೆಳಿಗ್ಗೆ.
ನಾಳೆ ಮಧ್ಯಾಹ್ನ,
KS Kallesh.
ಜನ ಸಾಯಂಕಾಲ.
Voting, please.
Voting. AGA for respond number 1, 3, 4. TL Kiran Kumar for 2, 1, 2, 4 and 6. Kiran Kumar for 2. Notice to respond number 5 written by 4. Same subject to objections.
Girisha Kodgi,
For the petition.
Yes, Girish?
Voting.
Appearing for respond number 5, madam. ಇದರಲ್ಲಿ 13D ನೋಟಿಸ್ ಎಲ್ಲ 195 days ಬಿಫೋರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ನೋಟಿಸಸ್ ಎಲ್ಲ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ರಿಸೀವ್ ಆಗಿಲ್ಲ. 13D ನೋಟಿಸಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ 195 days ಬಿಫೋರ್ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ಡ್ ಪೋಸ್ಟ್ ಹಾಕಿ.
ಅದೆಲ್ಲದರಲ್ಲೂ ಕಂಪ್ಲೈ ಆಗಿದೆ. And AGA accepts notice for respond number 1 and 3.
Meeting ಹೋಗಿಲ್ಲ.
TL Kiran Kumar for 2, notice to rest 1, 3 and 4 AGA. 2 TL Kiran Kumar, notice to respond. The Devi Prasad Shetty was filed KV for respond number 5, accepts notice for respond number 5. So and so subject to.
Sunil Kumar BN,
For voting.
ಹೇಳ್ಬಿಡ್ಬೇಕಪ್ಪ ಯಾರು AGA ಅಂತ. AGA for 1, 3, 4, 5. Kiran Kumar for 2, notice to respond number 6. Same subject to objections.
Asana Kumar P,
Yes, Prasanna Kumar. And AGA accepts notice for respond number 1 and 3. Issue notice to respond number 2 written up by 4th February.
Mohammed Tahir,
Voting, same society.
Respond number 1, 2,
Respondent number 1.
1 and 4. AGA 2 Kiran Kumar, 3 same.
Please.
Purva Reddy,
Yes.
Yes, sir. The university is insisting that the pay the affiliation fee with the GST.
GST.
Similar matters of the
Yes.
interior matter.
AGA for respond number 1, Bangalore University
Siddharth B. Desai,
Siddharth B. Desai for respond number 2 and 3. The GST 18%.
And delivery.
And delivery illa. No and delivery today. What is the number in which the interim order had been passed?
32.
Kodi.
Sir.
Kodi.
32,780.
845. All
Shamana
orders
B.
will be signed only tomorrow. Much.
Only for the vote 1, 3, 4 state.
1, 3, 4 state.
Kiran Kumar 2
Kiran Kumar 2 notice to 5.
and 6.
Okay, state 1, 3, 4. 1, 3, 4 and 6. Kiran Kumar for 2 issue notice to 5. Same order.
Ramana BH,
Same Rashid. 1, 3,
1,
4.
3, 4, 6. Kiran Kumar for 2 notice to 5.
It is in the state.
Sachin BS,
Tomorrow. Election authority is not. Tomorrow. Election authority is not made a part.
Release tomorrow.
Shamana BH,
1.
1, 3, 4, 6.
Yes.
Notice to Kiran Kumar for 2, 5 notice. 19.
Shetty,
Petitioner was
195 follow ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಇದ್ರಲ್ಲ ಇದು ಸಸ್ಪೆನ್ಸ್ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಡಿಮೋಟ್ ಮಾಡಿದ್ದಾರೆ petitioner.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅವ್ರನ್ನ ಸೆಕ್ರೆಟರಿ ಪೋಸ್ಟ್ ಇಂದ ಅಸಿಸ್ಟೆಂಟ್ ಗೆ ಡಿಮೋಟ್ ಮಾಡಿದ್ದಾರೆ. ಸೇಮ್ ಚಾರ್ಜಸ್ ಅರ್ಲಿಯರ್ ಒಂದು ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್.
Seeing the resolution ಆಗಲ್ಲ.
Resolution.
And AGA accepts notice for respond number 1 and 2. Yeah, respond number 3 ಯಾರು? Standing counsel.
ಅರ್ಲಿಯರ್ TP ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಸುಂಗೆ ಅಪಿಯರ್ ಆಗಿದೆ.
Shri TP Rajendra Kumar Sunge, Alanahalli Primary Agriculture Credit Cooperative Society, Alanahalli. He is directed to accept notice for respond number 3,
location.
relist on 7th January.
Rakshit Kumar,
Voting right.
Number ಹೇಳಿ.
Lots 1 and 4, my lords, state.
1, 4 state, TL
2 is
Kiran Kumar for 2, notice to respond number 3.
3 minutes.
Yes, 21,
Same.
same.
Please.
22,
Girisha Kodgi,
Girish.
Pay for the same voting rights.
The voting rights ಯಾರು? AGA.
Respond number 5 is the same.
But- Same answer. AGA for 1,
My lord.
3 and 4. TL Kiran Kumar for 2, notice to respond number 5.
Shamana B,
1, 1, 3, 5, 6.
1, 3, 4.
1, 3, 4, 6. Kiran Kumar for 2, notice to respond number 5.
Devi Prasad Shetty,
24, what is this? Pending matter ಯಾಕೆ ಮೂವ್ ಮಾಡಿದಿರಾ?
ನಾಳೆಗೆ ಅಂತ ಕೊಟ್ಟಿತ್ತು, probably someone's might, some of my friend might have missed the memo ಇದಾಗಿರ್ಬೋದು.
Total mood ಅಂತಿದೆ.
ಹೌದು, ಮೂವ್ ಮಾಡಿದ್ವಿ ನಾಳೆಗೆ ಅಂತ ಹೇಳಿದ್ದೆ.
Release tomorrow.
ಪ್ಲೀಸ್. ಆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಹಾಗೆ ಉಳಿತು, ಅದನ್ನ ನಾಳೆಗೆ there is some urgency.
ಏನ್ urgency, Mr.
ಅದು 195 days ಮ್ಯಾಟರ್.
47 release tomorrow.
ಪ್ಲೀಸ್.
ಬಾಕಿ ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿ.
Lord, may I just make 47, your lordships have not issued normal notice to the society, but the authorities have informed the society.
Very good. You are appearing for whom?
The society, my lord.
Good.
ಅದರಲ್ಲಿ
You can appear tomorrow.
If we had on reopening, my lord, they are asking for quashing of returning officer's appointment. ಅದ್ರಲ್ಲಿ ಅವಸರ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್
ಏನ್ ಅವಸರ ಇಲ್ವಾ? ಇದೆಯಾ?
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್
My lordship, my lordship, list number 1, serial number 60, my lordship. May kindly post it for orders for further hearing. I have written arguments.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 230 ಎಲ್ಲಿದೆ?
60.
Number 1, serial number 59.
In this case, appear for respondent, my lord. The petitioner has not deposited a single file, my lord. As per the act of this honorable court also. I was directed to ascertain that there was non-payment of certain months, my lords, in between.
5,000 rupees.
Correct, my lords. My lords, I had filed an memo of calculation, my lords. ಇಲ್ಲ ಕೊಟ್ಟೇ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರು ಬರೀ ಸುಮ್ಮನೆ ಸುಳ್ಳು ಹೇಳೋದು ಒಂದು.
ಎಲ್ಲಿ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇಲ್ಲ?
Lords, I filed it, my lords, yesterday itself. ಕಾಪಿನ ಸರ್ ಮಾಡಿ. My lords.
ನಾಟ್ ಪೇಡ್ ಅಂತಿದೆಯಲ್ಲಪ್ಪ ನಿಮ್ದು Jan 23 ಆದ್ಮೇಲೆ ಏನು ಇಲ್ಲ.
ಅದೇ ನಾನೇ ಹೇಳ್ತೀವಿ 2 minutes, my lords. I'll just take 2 minutes. My lords, may kindly peruse this, my lords. My lords, the daughter.
We are giving you enough and more opportunity.
My lords, my contention is only this, my lords, that the daughter-in-law under the law is not entitled.
We'll just vacate the interim order. You have come as a legal representative, not just a daughter-in-law.
My lords, the daughter-in-law was also made party in the original proceedings.
Learned counsel for the petitioner has filed a memo. The peril of the said memo indicates that no payment has been made from February 2023. In that view of the matter, interim order earlier past stands vacated.
My lords,
Relist on
my lords may consider
28th January.
My lords may consider it, my lords, that she is not entitled to pay even otherwise.
That's why we have vacated the interim order.
My lords, I filed an application for modification to that extent also.
We are not going to hear you.
My lords,
either you pay or no.
My lords, the petition will render infructuous, my lords.
It will be rendered infructuous. That's what we told you 4 times. You are not ready to listen.
My lords, she is
Next
not.
word.
My lords, she is not liable to pay. My lords,
you-
she will not be covered under the definition of
Yes.
children, or not the respondent will be covered.
Hmm. ಯಾವುದು ಇದು ಲುಕ್ಔಟ್ ನೋಟಿಸ್?
It was a matter of investigation, my lord.
ಸೈಬರ್
Re-investigation.
CBI ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಏನಾಗಿದೆ?
ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿದೀವಿ. ಅದನ್ನ ಈಗ
ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ.
ಫೈಲ್ ಆಗಿದೆ. ಅದು ಪೇಪರ್ ಪ್ಲೇಸ್ ಮಾಡಕ್ಕೆ ಪೇಪರ್ ಪ್ಲೇಸ್ ಮಾಡಿದ್ರೆ I have also given a copy to the petition.
My lordship, it's a matter of cyber security, cyber things. They have not secured any electronic devices from the accused, and they have provided B report for the investigation.
ಬಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ ಸ್ಫೂರ್ತಿ, ಬಟ್ where is the report?
Technical report, my lordship.
Technical person as regards that. That is what we had asked you to produce.
Yes, we have summoned her to produce all those things at the first instance. She has not produced the mobile.
Forget her.
So they didn't secure, my lordship. That's what they want.
What have you done?
Nothing, my lordship. They have not secured any electronic devices, and they have stated B report.
What have you done?
It's a matter of cyber thing.
My lord, she has not produced all her mobile hub routers and other things, my lord.
Their duty
Duty
is to
require
secure.
the mobile.
Uh,
That only indicates your person doesn't know how to investigate. The hacking is on account of Twitter account.
Yes, ma'am.
Who? Gmail.
No,
They have not.
ಅದಕ್ಕೆ ಫೋನ್ ಏನಕ್ಕೆ ಬೇಕು ನಿಮ್ಗೆ? ಅವ್ರ ಫೋನ್ ಕೇಳ್ತಾ ಇದ್ರೆ ಅವ್ರಿಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಗೊತ್ತಾಗತ್ತೆ ಅಷ್ಟೇ.
ಫೋನ್ ಹ್ಯಾಕ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಅದು ಒಂದು. ಇಮೇಲ್ ಅಕೌಂಟ್ಸ್ ಎಲ್ಲ ಏನಾಯ್ತು?
That is clearly mentioned in the forensic report that it has not been hacked or somebody else. has
Without
not-
securing
not
anything,
forwarding.
the forensic
So
report
expert
gives.
opinion. ನೀವೇ ಸುಮ್ಮನೆ ಹೇಳ್ಬಿಟ್ರೆ?
I will make the IO to be present, my lord, next date of hearing.
22 matter.
Nale,
Annada.
relist tomorrow.
Kindly, kindly.
60,
My lord, since serial number.
51.
My lord, since
And
serial
for the
number
respondent.
59, may I request
Sorry,
for-
Mr. Counsel, we have
10
told you,
My lord-
please don't say this. We have given you 4 times.
My lords,
And you
I'm-
again come and say that you aren't paid, so we won't get the interim order extend, that's all.
My lords, I'm
Don't
requesting
again-
for an earlier date, my lords, that
Relist on,
10th.
vacate ಮಾಡಿ, relist on 10th. Yes. Just a moment, please. 61.
61, I am for the respond number 2 and 3.
May kindly have it tomorrow. Senior said he will.
61 relist tomorrow.
62.
My lord, I appear for respondent number 2. However, my lord, we've not been given instructions.
Bank guarantee invocation.
My lord, one humble
Documents,
submission.
my lord. I've already served a copy. Yes.
Yes.
Lord, these are the 2 documents where the letters were, it evidences that the letters were received after the validity of the bank guarantee.
We'll have it tomorrow, Mr.
As you mentioned.
My lord, one humble submission, my lord.
madam.
My lord, our name appears before respondent number 2, the RBI. However, we've not been given instructions to appear for them. Our name may be deleted, my lord.
You have not been given instructions.
Yes, my lord.
Then we'll have to pass some order against your RBI.
My lord,
If they have not given
notice
you
may be
instruction
issued,
Despite an order of the court.
my lord, notice may be issued to the RBI, my lord.
Number 3,
Uh,
for RBI, we are on record.
You are on record. As long as somebody is there, fine. Respond
My
number
lord,
2
our
is.
name may be deleted, my lord.
No, respond number 3 is the ombudsman.
Ombudsman, my lord. Ombudsman orders. being
Ombudsman is an
challenged.
independent authority than RBI. They can't appear for RBI.
It's a division of RBI itself.
So you have no independence, is it?
We have, we are.
Your submission is so dangerous, do you understand that?
Every order, every bank is governed by RBI for that matter.
Yes, but the ombudsman and RBI, same council will appear.
No, my lord, different councils have been.
That is
directed
what we are
notice.
trying to say.
My
On
lord,
behalf of Sri Vinay Giri, who had been directed to accept notice for respond number 2,
Yes,
it
sir.
is submitted that the respond number 2, RBI, has not issued any instructions to respond number 2 to Mr. Vinay Giri. Sri Vinay Giri appearing for the RBI in several matters, this court had directed him to accept notice. It is rather shocking that despite this court having directed Mr. Vinay Giri to accept notice, no instruction have been issued by the RBI. Hence, it appears that the RBI is not interested in prosecuting the matter. As such,
My lord, my
registry
lord.
is directed. No, they have not given you instruction. Don't make any submission. As such, registry is directed to delete the name of Sri Vinay Giri as that appearing for respond number 2 and print the name of Reserve Bank of India in the cause list. Relist tomorrow.
Grateful, my lord.
Fast over, you know.
Passed over matters. List number 1, serial number 8. Kiran DS.
I represent for petitioner in this matter, my lord. My lord, I praise time, my lord. I praise time, my lord. Post vacation, my lord. One date may be given.
Relist on then is GM. 16 January 8.
My lord, small submission. 16th, or my lord, up 20th, my lord, please.
Relist on 22nd January.
Please, my lord. Interim order may be extended.
Interim order.
Serial number 11.
11 relist on 16th. 21 relist tomorrow. Tomorrow.
Serial number 11 tomorrow.
Stand be taken up. We have to finish these matters. 21. Interim order 21. 29. Yes, Mr. Shetty.
With regard to that, they said that they will produce some letter. Now they are saying that no such letter is there. This is with regard to OTS, my lord.
Lord, except that, my lord, we don't have any record, my lord, which.
You're not taken any action. Then we can't accept.
Only submissions which I'm going to make, my lord, that record which is produced before this honorable court, either in the bank record or he's not the manager.
Have you taken any action against this manager?
Lord, we have taken the action, my lord, pursuant to, my lord, he's done like similar, my lord, which I placed before this honorable. It may be.
Learned counsel for respondent.
Yes, ma'am.
Today submit that there is no document.
No, except the document which I produced on, my lord, last date of hearing, that document dated 31 May 2022.
Except the document produced along with the
Memo Hakila.
memo dated.
Memo Hakila, my lord, the document across the bar I submitted.
memo haki.
Letter dated, my lord, 31 May 2022.
ಅದೆಲ್ಲೂ ಇಲ್ಲಿಲ್ಲ.
ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲ ಲಾಸ್ಟ್
ಯೂಸ್ ಆಗಿ ಕೊಟ್ರೆ ಹೋಗುತ್ತೆ.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್
ಮೆಮೋ ಜೊತೆ
ಹಾಕಿದ್ದೆ.
ಲಾಸ್ಟ್ ಟೈಮ್
as except the letter dated 30 ತಗೊಳ್ಳಿ ಅದು ಮೆಮೋ ಜೊತೆ ಹಾಕಿ.
ಹಾಕಿಲ್ಲ ತಗೊಳ್ಳಿ. ಇದೆಯಾ?
Except the letter dated 31/5/2022, which has been produced along with a memo today. A perusal of the said letter does not indicate any action having been taken against Srimati Praveena J, manager of the respondent bank, as regards the improper acceptance or otherwise of the one-time settlement of the petitioner in the present matter. And the said proceedings against Ms. Praveena J would not come to the rescue of the respondent bank in as much as no action has been taken as regard the acceptance of the OTS by her as submitted by the petitioner. In that view of the matter, the respondent bank would be bound by the OTS accepted by its chief manager. By in manager or
He was not chief manager, but he was not in that branch. He was
by chief manager. The rest of the matters being the internal management of the bank. Yes, ಇವಾಗ ಯಾವಾಗ?
Annexure E is the letter, my lord. Annexure E is the letter.
my lord, annexure E, page number 43, my lord.
43 is the letter. It's a regional office and they are saying that they are unknown. It has been issued by regional office.
Once the OTS has been accepted by the bank would be bound by the OTS and cannot contend to the contrary.
Settlement.
The payment having been made.
Pursuant to order made by this honorable court in the interim order. They're not paid, my lord, in time.
My lord, we have
They
paid.
approach this on, my lord, what had happened, my lord, I issued, my lord. under
Then
section-
that will be considered later. Relist on
Allala,
9th January.
we have paid it, my lord.
That will be considered later.
Yes.
Right now,
51.
Wait.
I'm for the fourth respondent, my lord.
My lord, I am for the petitioner, my lord.
yes.
I was allotted site by BDA in 2004, my lord. After that, my lord, the BDA had not developed the site fully, my lord. Now, my lord, the respondent deputy commissioner has passed order converting the very same property for electric crematorium, my lord, without giving notice either to BDA or to me, my lord.
Who has issued that notice?
My lord, the order is passed by respondent number 2, my lord, commissioner. It is in page number 29, my lord.
BDA layout ಹೆಂಗ್ರಿ crematorium ಮಾಡ್ತೀರಾ? BDA layout ಅಲ್ಲಿ site ಹೆಂಗ್ ಮಾಡ್ತೀರಾ ನೀವು? The contention of the petitioner is that a site which has been allotted by the BDA to the petitioner has now been designated to be a crematorium by respondent number 2. And AGA seeks for a day's time to obtain instruction, make a submission, release tomorrow.
Much obliged.
B group matters. Number 2.
ಎಲ್ಲ ಅಜ್ಜನ್ ಮಾಡಿ ಗೇಟ್ ಕೊಡಿ. ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ ತಾನೆ ಇವಾಗ ಇನ್ನೇನ್ ಬರುತ್ತೆ 6 ಗಂಟೆ.
Serial number 36.
ಏನಾಯ್ತು
That committee, I
37.
suggested them, Ramaswamy, the petitioner, has agreed, my lord, along with the 5 persons. And tomorrow I'll file a memo.
Tomorrow. 37 release tomorrow.
36.
36 ಅಲ್ಲ 37.
36. 37.
46 release tomorrow.
My lord, 42, my lord.
Why? When is the next exam? February.
My lord,
46 released on 6th January.
my lord, 42.
48.
40,
7
my
January.
lord, 42. My lord, 42, my
ಒಂದ್
lord.
ನಿಮಿಷ ಇರ್ರಿ.
Serial number 44, second list number
44. ಏನಪ್ಪ 44 ಏನು? ಮಾಡಿ ಎಲ್ಲ ಅಜ್ಜನ್ ಆಗತ್ತೆ.
Madam.
48, my lord.
ಹಾ ಅಜ್ಜನ್ ಆಗತ್ತೆ. Yes.
Pertains to cooperative
Hand
society.
delivery for tomorrow.
No hand delivery tomorrow. It will
Hello.
come, don't worry.
43, serial number 43.
Yes.
My lord, there is concern, the renewal of the recognition of a school. My lord, now the SSLC exams are approaching, and there was already an order by this honorable court to consider post facto, because there was change in the premises, but my renewal was being continued. Only last year, they did not renew my recognition.
Yes, madam.
If only a time could be fixed.
They've shifted already.
But it's already applied, it's with them, it's being considered by them, only thing is that time should be fixed, because the order was passed in July. Till now, there's no consideration.
43 release tomorrow.
My lord, serial number 42, my lord. Matter percent, KSYU marks card issue, my lord, percentage. Day before day, yesterday, my lord, your lordship heard the matter and issue, my lord. Only to pass the order, that is what matter is listed for today, my lord.
ಇವತ್ತು division bench ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತೆ. There's a judgment passed by the division bench. That is what was pointed out by Mr. Shauri. You examine that. We can't pass any order in this. A little late either.
But
42 released on 13th January.
My lord, ಫೈಲಿ ಬಂದಿದೆ ಸ್ವಾಮಿ, ಅವ್ರ ಲಿಸ್ಟ್ ಕಳ್ಸಿಲ್ಲ.
ಯಾವ್ದು ಫೈಲ್ ಬಂದಿಲ್ಲ?
ಬಂದಿದೆ ಜಸ್ಟ್
ಯಾವ್ದು ಬಂದಿದೆ?
Order sheet ಎಲ್ಲ ಏನು?
230 ಲಿಸ್ಟ್ ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ, ಈಗ ಲೇಟ್ ಆಗಿ ಬಂತು ಸ್ವಾಮಿ. ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟ್
ನಿಮ್ಗೆ ಯಾರು ಕೊಟ್ರು ಫೈಲು? ಎಷ್ಟಾಗಿಲ್ಲ ಸರ್ ಇದು ಫೈಲ್ ಯಾರು ಕೊಟ್ರು?
ಲಿಸ್ಟ್ ಅಲ್ಲಿ
SKJ
ಫೈಲ್ ಹೆಂಗ್ ಬಂತು?
SKJ ಅವ್ರ ಇದು ಕೊಟ್ರು ಸ್ವಾಮಿ.
ಫೈಲ್ ಹೆಂಗ್ ಬಂತು ಇಲ್ಲಿಗೆ?
ಇಲ್ಲಿಟ್ರು ಸರ್, ಗೊತ್ತಿಲ್ಲ ಹೆಂಗ್ ಬಂತು ಅಂತ.
ಕೊಡಿ, ನನ್ನ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇಡಿ, ನೋಡೋಣ ಫೈಲ್ ಎಲ್ಲಿ ಹೋಗುತ್ತೆ ಅಂತ ನೋಡೋಣ. Please don't indulge in these kind of things that we will require. ನಾಳೆ ಬಂದಿದ್ರೆ ಏನಾಗ್ತಾ ಇರ್ಲಿಲ್ಲ ನಿಮ್ಗೆ.
ಇವತ್ತು 230 ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ.
ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲಿ ಸಿಕ್ಕಾಕೊಂತೀರಾ.
ಸಾರಿ ಮೇಲೆ ಸರ್.
That file, you took it and came here to the court.
Yes, madam.
ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ why should we sit till 6 o'clock for this kind of things?
ಸಾರಿ ಮೇಲೆ.
Please don't do this. That person who has given you also will also lose the job. You lose your right to practice. For one matter.
Sorry.
These are very serious things, Mr. Ramanan. Don't take it lightly.
Sorry.
And we won't take it lightly if these kind of things happen. How friendly we can be that much harsh also in these kind of things.
Sorry.
This cannot be entertained or encouraged. Please don't do this.
ನಾಳೆಗೆ tomorrow ಮಾಡಿ.
ಇಲ್ಲ ಏನು ಹೇಳಿಲ್ಲ. ರೀಚ್ ಆಗ್ದಿರಾ ಇರೋದ್ ಕರಿತೀನಿ. 41, 44, 45, 44 ಯಾವತ್ತು? ಆಫ್ಟರ್ ವೆಕೇಶನ್. CS ಅಲ್ವಾ? 21st January, 4 ಫೆಬ್ರವರಿವರೆಗೂ ದಿನ 180 ಮ್ಯಾಟರ್. ಹಿಂಗೆ ಕಾಯಿ ಅದು ಗೊತ್ತಿಲ್ಲ, ನೀವೇ ಹೇಳ್ಬೇಕು. ನಮ್ಗೆ ಇಷ್ಟೇ ಪ್ರಪಂಚ, ನೀವು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾವ ಹತ್ರ ಹೇಳಿ, ನೀವೇ ಹೇಳಿ ಎಷ್ಟ್ ಹತ್ರ. ನಾಳೆ ಹಿಂಗೆ ಕಾಯ್ಬಿಟ್ಟು ಹೋಗ್ತೀರಾ, ಅದಕ್ಕೆ ಕೇಳಿದೆ. 21st January 45?
48.
ಇಲ್ಲ ಅಲ್ಲ, 48?
ನಾಳೆ
ಯಾವಾಗ? ನಾಳೆ ಬೇಡ, ಇಲ್ಲ ಆಗಲ್ಲ.
ನಾಳೆ
ಹೇಳಿಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ 21st January. 48 21st January.
ಮೇಡಮ್ ಇದು
ಬರ್ಲಿಲ್ಲ, ಇವಾಗ ಬರ್ತಿದಾರೆ ನೋಡಿ. ನಾಳೆಗೆ ಅಲ್ಲ, ಈಗ ಬಂದಿದ್ಯೋ ಇಲ್ವಾ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಬಂದಿದ್ರೆ ಏನ್ ಮೂವ್ ಮಾಡೋದು ಬೇಡ ತಿರ್ಗಾ.
ಹೇಳ್ಬೇಕಾ?
ನಿಮಿಷ, ಈಗ ಒಂದ್ ಸ್ವಲ್ಪ ಸುಧಾರಿಸ್ಕೊಳ್ಳೋಣ. ಯಾವ್ದು ಅಂತ ನೋಡೋಣ. ಯಾಕಮ್ಮ ಇದು ಇನ್ನೊಂದ್ ಬರ್ಲಿಲ್ವಾ? ಗಿರೀಶ್ ಕೊಡ್ಗಿ ಅಂದ್ರೆ ನಿಮ್ದಿದೆ ಒಂದು. ಗಿರೀಶ್ ಕೊಡ್ಗಿ ಒಂದು.
ಗಿರೀಶ್ ಕೂಡ ಎಲ್ಲ ಹುಡುಕ್ತಾ ಇದ್ರಲ್ಲಿ.
ಇದು ಇವ್ರ ಅಡ್ವೊಕೇಟ್ ತಗೊಂಡ್ಬಂದಿದ್ದಾರೆ. ಲಿಸ್ಟ್ ಆಗ್ದಿರಾ ಹೆಂಗಾಗುತ್ತಪ್ಪ? ನೀವು ಎಷ್ಟು ವರ್ಷದಿಂದ ಬರ್ತೀರಾ ಹೈಕೋರ್ಟ್? ಗೊತ್ತಿಲ್ವಾ ಕೇಸ್ ಹೀಗೆ? ಅವ್ರು ನನ್ ಕೆಲಸ ಮಾಡಕ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ರೆ ಈ ಫೈಲ್ ತಗೊಳ್ಳಿ ಅನ್ಸಿದ್ದಾರೆ. ಏನು ಅಂತ ನೋಡಕ್ಕೂ ಆಗ್ತಾ ಇಲ್ಲ ನನಗೆ. ನಾನೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಚೇಂಬರ್ ತಗೊಂಬಾ ಅಂತ ಅಂದವ್ರೆ, ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ. ನಾನ್ ಕೇಳ್ಕೊಂಡ್ ಬರ್ತೀನಿ. ಲೈವ್ ಅಲ್ಲಿ